Hello, how are we, beautiful people, and the rest of you? Hope you're all doing well here on a hump day, Wednesday, hump day. Honeybee, hello to you, one buzz, and one buzz. One buzz, I think you were here for the, was it the Edge of Faust trial? I think we saw you then. Hope you're doing well, my darling. Nice to see you again. Afternoon, Badaza, how are you, sir? Rhonda, my lovely Rhonda, how are you, my darling? Always nice to see you, Rhonda, in the chat. Hope you're doing well. I think you were at the dentist yesterday. I got my dentist next Tuesday, unfortunately. But it is what it is. There you go. So we're back for another crazy day of this trial. I mean, I'm not sure. I'm not even sure if I'm ready for this. Do you know what I mean? I think he testifies himself today. I think. I'm not 100%. But we'll see. I think this is going to be a disaster again today. I think it's going to be cringeworthy again today. So hold this space is what I would say. We'll see what happens with this now. Let me just do this. Okay. Right, I'm not going to mess about because people can catch up as they need to catch up. So we'll get straight into it because I've got everything ready and I need to get everything done. Okay, that's fine. That's done there. Okay, so with all that said, this is a reminder, this is day 3. Let me put it on 1.25. We'll see how this goes. And yes. Oh, Cat's coming for operation. Well, good luck, my darling. Good luck to you. Hope it all goes well, my darling.
In person, in street clothes, pro se, Attorney John Wasilewski appears as standby counsel.
Hi, good morning to everyone. Of note is that, one, we're outside the presence of the jury. It's now 8:22. As everyone recalls, I had ordered us to go on the record at 8:15 with the jury, so we're running a little behind. Of note is that yesterday I did try to make arrangements with the jail lieutenants and Director Briggs to ensure that Mr. Olson is given access to the law library to use any computer or laptop that is customarily provided to.
Hello, Lady Di.
And I understand that that was done. And I was also informed that when the Deputy Bruce, that is, went to meet Mr. Olson at 7:15, he was already in the library. Director Briggs did inform me that as soon as they're able to, which would be after roll call, they would take Mr. Olson to the library, and that would be about a little after 6. And so when Deputy Bruce went downstairs, that was 7:15. Mr. Olson was already in the library, and then he was brought up at 8:05. So that was the time that he was in the library. In addition to that, I do want to, as exhibits are being used more frequently, I just want to remind everyone, parties and others, that if anything is needed during examinations, such as a microphone, you are to obtain permission of the court, and at no time should anyone enter the witness box or approach the witness without permission of the court. Okay, just reminding everyone. Okay, now we're going to continue at this time. Mr. Olson?
Yes, so those parts of the discovery and numerous others don't open. There's 1 or 2 missing from one of the drives. Again, the drive that I initially had from 2023, which is completely had been messed with by somebody. There's something wrong with that. It wouldn't that one never opened, and I've always complained about that. The 2 that I had, he tried opening here, it wouldn't open. The one that would open wasn't mine, and that was open on Ms. Sadowski's laptop. The laptops in the jail are much different. These 2 drives, again, so I have never had full access to discovery, never. Very partial. None of the police reports were open. None of the downloads will open. Some of the photos from the.
And I'm going to interrupt you. And one thing I do want to make, no, you don't get to tell the court to hold on. But this brings me to the point I want to make. And I think hopefully I'm answering your question because you seem to challenge the court's authority to control the proceeding. And I'm just going to remind you again that the reason why I do in fact control the proceeding is because that's my job. I have to move this case along. But specifically in a situation like this, where my instruction previously, and again today, is that with respect to discovery issues, I'm hearing a lot of what's already been hashed out or discussed previously. I know that you don't feel that way, and that's perfectly fine. But the fact remains that the court has made its decision. We are well past that stage. If
this is the reason, if he's found guilty, there will be a new trial. Because he's stating, and his attorney stated, that he has no access to any of the materials. And in the jail, he gets half an hour during the trial to open it all up. As much as he's a douchebag, he's going to get a new trial based on everything we're hearing. Because the court, I mean, look, I would be just like, who gives a fuck? Do you know what I mean? You're guilty, who gives a shit? But he has got some rights, so he will get a new trial if he's found guilty.
this is another motion you'd like to bring, then do so. But what I'm trying to prevent is for us to relive history and create another 5-10 pages of a transcript. Okay, I'm not denying you an ability to raise those issues with the court. I'm simply telling you that we need to be more efficient. We've lost a lot of time,
Okay.
and that you can do this by way of a written motion so that you can make it very clear and be particular and specific as to what you believe is the issue here. I've heard a lot of this before, and as I explained yesterday, the court went so far as to issue an order to the state to itemize the discovery, turn it over yet again. And I don't recall off the top of my head the number of times that discovery has been turned over. The state has turned over discovery more than once to more than one attorney and more than once to you, as well as the court itself turning over another copy, an extra copy of a USB drive to you. So I don't want to belabor the record anymore. And I am giving you another opportunity to simply articulate with specificity in written form so that I can properly address that, but also so that the state has a fair chance to respond to your motions. Okay, that's
Okay,
it.
hold on. I have the motion. I have the motion right here.
No.
You have to, I object. You have to allow me to submit the motion.
Mr. Olson, calm down.
No, you're violating
just
Wisconsin Supreme Court
Okay.
rules.
Violation number one.
That's
of the
okay.
day.
I have to submit my motion, and I'm
Mr.
declaring a
Olson, you're ordered to
mistrial.
stop talking. That was your first violation. Your second violation will result in your removal for 15 minutes. And let me remind you, as well as everyone else, that this trial has been delayed, and it will be if you continue to act in that way. Okay, now you have standby counsel, and you know how to do this because you've done this many times before. If you have a written motion, give it to the clerk. He'll upload it to the file, and thus it will be deemed filed. Okay, but same process and procedure as before. Don't approach the clerk. Don't approach the court. The deputies are here. Hand it over to Attorney Wasilewski. He can then indicate it to the deputies, come pick it up, or the deputies can come to you directly and take your motion and then give it to Mr. Clerk to file. That's it.
So,
That's all. There's nothing else we need to say on the record.
yes, there
Other
is. There's
jurors
lots.
here? Violation number 2, remove Mr. Olson for 15 minutes. It's 8:28. We'll be off the record for 15 minutes.
Can you give that to the clerk?
Stand up.
Hello, Dana. Hello, Bex. Oh, wow.
That's enough for me, John. Yes, that's the entire motion right there to the right.
Your Honor, while Mr. Olson's being escorted from the courtroom, he has indicated that there is a stack of papers on the defense table closest to you, and the entirety of that, he tells me, is his motion. With your permission, I'll walk it to the clerk.
How many pages do you know?
I don't. I haven't
Oh,
viewed
you
it.
want to give me a rough estimate after you take a look at it? Okay. You guys would just stand it here.
I would estimate it 70 to 80 pages. Only the first seven pages appear to be the motion per se. I assume the rest of this is what he would characterize as exhibits or supporting documents.
Okay. Before we actually have Mr. Clerk scan it into the system, when Mr. Olson is brought back, I want to confirm with him that that is in fact all of it, because I want to avoid having to do a second or third scan. And so we'll have him confirm that in fact that's all of it. But it's good to know that he has it all ready to go.
Yes, or as a This is just a suggestion, take it or leave it. The clerk could scan it now, but not file it until, and maybe even scan it in parts. I don't know.
Well, I don't think the system's that savvy where he can just add to the same scan. I don't want to have, for example, document 20 created and then we have to create document 22. It should just be one document, one scan of the entire motion. I don't want anything to get lost in the filing.
Okay, well,
So we'll just leave it.
however the court directs is fine with me, but I usually file a motion, and then if I have an attachment, I file it as a separate document, but that's just me. I don't know if that's
That is true. That is just you. This is Mr. Olson.
So it seems they're in timeout for a bit then.
Timeout. Yeah, it's timeout.
Okay.
Yeah.
I was concerned that,
Because after 15 minutes, I still want to confirm that he can follow the rules. And then talk about the motion, the number of pages. I don't want any Okay, we're back on the record outside the presence of the jury. Same appearances before. Mr. Olson does join us in the courtroom. Okay, Mr. Olson, that was your second violation. I just want to remind you the consequences of violations. The third violation will result in your removal from the courtroom, and I will allow you to observe the trial by Zoom, but you will be removed. You'll have an opportunity to return if provided that you promise and agree to follow the court's rules and that you will be able to comply with the court's rules. Now, you've been brought back after the 15-minute break. Will you comply with the court's rules?
I mean, I object to being treated that way, and I believe you're violating my First Amendment right to speak and Wisconsin Supreme Court Rules, Judicial Code of Conduct 60.04, which says you have to let me speak because I have a legal interest in this matter. I have to be able to object, I have to be able to get things on the record in order to preserve my rights.
Paragraph 10, answer questions asked or instructed by the court. Can you follow the court's rules?
I can, if you
Okay,
can also.
then let's continue.
May I just put this on the record?
No, you cannot, because I asked you a question. Yeah, just a minute. There's a process and procedure to all this. So now, having heard your response that you can follow the court's rules, I will expect that. And I'm just reminding you that pursuant to the rules of decorum, the third violation results in your removal. I want to make sure that you remember that. Okay, now before you were removed from the courtroom, you did start talking about your motion. And after you were removed, Attorney Wasowski did ask if your motion can be filed, given to the clerk so that I can scan it. I did not do that because, and this is the reason why, I want you to make sure that, in fact, that stack of papers is everything that you want to file as part of your motion. Once you confirm that, then the deputy can give that to Mr. Clerk and we'll scan it in. Is that correct?
Yes, I just want to make sure that I'm putting it on the record that I'm filing a motion and demand for mistrial and dismissal based on extreme constitutional violations, jury tampering, jury poisoning, misconduct in office, abuse of power, miscarriage of justice, obstruction of justice, violation of my due process. I have no discovery. Your deputies are, I want to ask that you confiscate your deputies' phones because they're texting and talking about my case in the back, and they've been doing this for a couple of days. And I've also noticed the jurors doing it in the hallway, talking about getting Facebook notifications. There's probably close to 6 or maybe 8 now that I've inquired in the hallways as I've been being brought through the hallways every day, ever since Tuesday, since before I was even given these clothes put on.
Mr. Olson, state the detail for your motion. I've understand, having heard what you just said, I have a general understanding of the general basis. I don't need the details because it should be contained in the written motion. Okay, and that stack of paper, is that everything?
Yes.
Okay, so then Mr. Clerk, Deputy, if you could take that and present it to Mr. Clerk.
Sorry.
The clerk will scan it in, and once it's scanned in, the legal parties, but specifically the state should have access to that. You might need to refresh state once the CCAP entry is pulled in, and the state obviously has an opportunity to respond. And so that means that time will be given for the state to read the motion. I understand it is quite lengthy, and that was a big stack of paper.
Real quick, Your Honor, I just wanted to state that the only thing that's missing out of there is case laws, and that's because I was stripped of my ability to look at any case laws now in the place where I'm being housed in the jail, so I have no access to that.
Okay. State anything you want to place on the record at this time.
I haven't read the motion, but I think that Mr. Olson by his antics a couple of days ago in his wheelchair in Orange, I think the cat's out of the bag that he was in custody. So any jurors that are seeing him is kind of a moot point. That's the only response that I have right now, because as Your Honor has already noted, we've turned over discovery, probably each time to a different attorney, a copy directly to Mr. Olson. And frankly, when you're pro se, some of the case law that I cited earlier this week is the defendant's own peril when you proceed pro se if these things don't go as smoothly as you would like. So that's all I have to say. But again, I haven't read the motion, so I don't know what else to respond to at this time.
Okay. No, that's all. No, that's
Quick
all.
response?
No, you can't, because I'm not hearing the motion right now. No. Okay. So my plan this morning is, at a minimum, complete examination of state's witness, the detective. And at that point, we'll take a break. I'll inquire with the state as to witness lineup. I think it depends on when the parties finish their examination of that witness, because if it's closer to the lunch hour, I think what I may do is just end early so that state has an opportunity to go through the motion that's just been filed. But also at that point, once that witness is done, I think at that point, state, you should have a much better idea of how much time you need, correct?
I have 2 crime lab analysts that have now been here for a full day and a half. So if there's any way I can get them in this morning and then we can take a break, and even if we come back a little bit later after lunch, I would strongly prefer that. I won't rest after my last witness in case anything needs to be addressed, but I would greatly appreciate.
All right, let's just push through with the detective, and then I'll take a quick break and gauge where things are at that point. Okay,
Thank you.
let's bring in the jury. Are they all here? Okay, let's bring them in then.
You want defense to proceed, Your Honor?
Yes, please.
Okay. So where I had left off at, I guess the question I was trying to ask was, do you have possession of all of the photos that were taken from the car? Yes. The original, not what the DA has, but the originals that you have. Yes. Would you mind turning over all of those photos to defense? Because I believe there's one missing from what I originally got and what I was now shown by Attorney Wesolowski.
You cannot testify through your question.
Okay.
Just ask your question, okay?
Would you mind then, is there any problem to give defense everything that you have from photos from the white Honda belonging to Betty Hanel? What is your question? Can you turn over all of the photos to defense, directly to defense? All photos and evidence? All photos from the, taken from anything found in the car and the inside of the of the Honda Accord.
All evidence collected, all photos, gets turned over to the state, to the district attorney's office, which then a copy gets made and is given to the defense for discovery.
Okay. Can you turn over all those copies directly to defense? Would you have a problem with that? Is there any problem with that? If there's
Objection, relevance.
Okay, sustained. Move on, please. Next question.
So I would like all photos turned over from the car.
Objection asked and answered.
Sustained. Next question, please.
Okay. During your investigation, isn't it true that you found out that Mr. Olson actually knew Mr. Schuster?
No, not that I'm aware of.
Isn't it true that you found out that Mr. Olson actually may have had permission to be in the RV, which is, go ahead, I'll let you answer that.
No, Mr. Schuster testified that you didn't have permission.
That's not what I asked. Isn't it true that you found that out, that it's possible that Mr. Olson actually had permission to be in the RV?
No.
Isn't it true that this is why Mr. Olson was in that area for several days, because Mr. Olson actually had permission to stay in the RV?
Objection, he's testifying again, Your Honor.
Okay, sustained.
No. So you did testify that Mr. Olson was in the area for several days, isn't that correct?
don't know if I testified to that.
Did you find that out throughout your investigation?
Yes.
So where was Mr. Olson staying during those days in that area?
Objection, Your Honor. The witness should only testify if he knows the answer, not speculate. I think Mr. Olson is calling for speculation.
No, I'm asking him a
Overruled.
question.
Overruled. Answer the question if you know the answer.
I do not know the answer.
Are you the person that completed a phone download of Betty Handel's phone?
Yes.
Now, you had testified yesterday that items cannot be removed from that phone download. Isn't that actually false? Items can be redacted, unredacted, and so forth.
No.
Items can't be redacted from a phone download. Is that what you're saying?
Yes, it depends on what your definition of redacted is.
Redacted is a pretty common word, and there's one definition for redacted. It can be removed. Removed from a phone download is pretty common. There's an unredacted version, and there's
Question, Mr. Olson?
so your testimony yesterday isn't exactly quite true, is it, about items being able to be removed from the phone download?
Items are not removed from the phone download.
So the version that is given to the DA, you're telling me that the DA cannot at all remove items. It is not physically possible?
Correct.
That is incorrect. That is that. So there is there not an ability on the computer to remove a item from the phone, from the download that you give her on a flash drive? She's able to delete that item if she chooses
Olson,
to, correct? I'm asking.
If you have a question, ask the question, allow the witness to answer before moving on to the next question, and do not testify through your form of question.
Because the detective is not being truthful.
Oh, okay.
Sorry.
Members of the jury, let's take a break. Plan for 5 minutes or less, and then we'll come back. I remind everyone this case is not concluded. Do not talk about this case. Do not do your own research. Do not post about your experience, what you've seen or heard so far. Thank you.
There may be trouble ahead.
Objection, Your Honor. Lack of foundation calls for speculation. Unintelligible. I
We're
don't
outside the presence of
understand.
the jury. Mr. Olson, I believe I said this. Yes, I did, because it's in the rules of decorum. Okay, during examination, keep scope of examination relevant. On direct, no leading questions. Do not harass, intimidate, or argue with the witness. And of course, the last point there, these are not an exhaustive list of things to do or not to do during examination, but it ends with do not speak over one another. Do not harass, intimidate, or argue with the witness. You ask her a question and you move on. If credibility is what you're getting to, there are ways to do that, but you don't argue with the witness and you don't harass them. Okay. And I've had to say this to you a couple of times already, so I'm going to remind you yet again that it's impermissible for you to testify through by way of your form of question. You cannot do that.
Yeah.
And when you do that,
This is why you shouldn't be able to just do this yourself. Do you know what I mean? You shouldn't be able to represent yourself unless you have a law degree.
Hippie chick, lady di, spacey Stacy, walking those streets all night. You go, ladies, come and see what's going on now. Let's go, girls.
the state will object, which they've done, and I will sustain that.
Okay.
I want to make sure that we're on the same page. Are we on the same page?
Yes, and I did not mean to do that. It's just I'm not familiar with the process of answering or asking questions.
Sure.
in this
And that's
manner.
understandable, which is why we took this break for me to remind you. And I also want to remind you that there are a lot of things you're not going to like about this whole process, including, of course, not liking my decisions, but also including not liking the answers from the witnesses. It's their answer. You don't argue with them. You ask your next question and you move on. Is that clear?
Yes, Your Honor.
Okay, so let's bring in the jury and we'll continue.
May I ask one quick question?
Yes.
When Mr. Olson testifies again, I don't know at what point it's appropriate for me to object and cut him off, because decorum would say at the end. So
I think for clarity of the record and for the record to be complete, I'm just going to say do what you need to do
thank you.
and let's just move on from there.
I just don't want to violate the rules.
That's understood. Yeah. Okay, welcome back, members of the jury. Let's continue with the trial. Mr. Olson, please continue your examination.
Okay, isn't it true that you can generate reports from the phone download and exclude some and include others into what you're giving the state?
Can you repeat your question?
Isn't it true that you can generate reports from the phone download and you can include or exclude things to the state?
Objection, Your Honor. Compound question.
Overruled. You may answer the question if you know it.
When you're generating a report, you can exclude data such as dates or time frames, but that would then include that through the entire phone download.
Do you have a copy of the original phone download conducted from Betty Handel's phone?
Yes, and that's what was provided to the state.
So, are you aware of, let me rephrase this. So through your investigations, you did find that there was a text from Betty Handel to Mr. Olson, isn't that correct?
No, that's incorrect.
So isn't it through your investigations you found a text that was to a number that stated, "Where are you? Are you coming back?" during the supposed alleged abduction?
No.
Isn't it true that you found a text that stated, "You didn't tell Rex that we knew each other, did you?"
Objection, testifying.
Okay. Sustained.
Isn't it true that you found a text during this also alleged abduction stating, "My credit card has a $25,000 limit"?
Objection, testifying.
Sustained.
So through your conversations with Mr. Olson, isn't it true that Mr. Olson stated that he knew Betty Handel?
Objection, hearsay.
Overruled. You may answer the question.
Yes, Mr. Olson said he knew Betty Handel.
Isn't it also true that when you inquired to Mr. Olson about this alleged incident, that Mr. Olson had told you to check Betty's
Objection,
phones?
testifying and hearsay.
Sustained.
Isn't it true that Mr. Olson directed you to Betty's texts ever?
Objection, hearsay.
Overruled. You may answer the question if you know it.
Can you repeat the question?
Isn't it true that Mr. Olson directed you to check Betty's texts for anything pertaining to this incident?
Yes.
Do you still have the iPhone in your possession?
No.
Does Betty still have the iPhone?
I don't know.
So, because this is material to the case and very important, would you have any problem turning over the original phone download conducted by yourself to defense in the court right now? So that I'll let you answer that.
The original phone download was turned over to ADA Sadowski when the case was filed.
Okay. Isn't it true that yesterday you told Mr. Olson in the courtroom, off the record, that you have the original version in your possession?
Objection, hearsay, and relevance.
Sustained.
So, and again, because it's so important, would you have any problem turning over the phone download, the original one that you have in your possession, would you have a problem turning that over to the defense and court so that it can be examined by a private investigator and also the FBI?
Mr. Olson, I think I already answered this question.
No.
The phone download that was conducted of Betty Handel's phone, the original copy was given to the DA, and then you're provided with a copy. So everyone has the same copy.
So do you have the original phone download in your possession?
Mr. Olson, I'm going to direct you to move forward. You
No.
are badgering the witness.
No,
Next
he's not
question,
answered
please.
that. He's not answered it. Would you mind turning over the original download to the defense?
To the jury, we're going to take a break,
I
and I'll
don't-
have you brought back in about 5 minutes. Okay, remind you, this case is not concluded. Do not talk about this case. Do not conduct your own research, and do not post about your experience.
You didn't answer that. He said that it's been turned over. You would say yes or no. It's a yes or no question.
Hey man, just want to let you know that sometimes you gotta shut the fuck up. And this current time is just one of those times you gotta shut the fuck up. I don't think you're a bad person. I just don't want to hear you talking anymore. You gotta shut the fuck up.
We're outside the presence of the jury. Mr. Olson, I'm reminding you again that pursuant to the court's rules of decorum, paragraph 13, and again, this is not an exhaustive list, but during examination, do not harass, intimidate, or argue with the witness. You've been instructed to move on. You then proceeded to nonetheless ask that same question, maybe slightly differently, but same question. And I really should be counting this as your third violation and removing you from the courtroom and allowing you to then view this trial by Zoom. And as you may recall, I specifically laid out the procedure that if you are removed from the trial and you can only view it by Zoom, you may provide to Attorney Wasiewski specific questions that you've written that you want him to ask. Because I already gave you notice, I can count this as a third violation, but I don't know that you fully appreciate how serious I was about ensuring that you understand the rules of decorum, that you follow it. I'm going to ask you one question. Depending on your answer, I'll know how to proceed. Will you follow the court's rules of decorum, including the rules related to examination?
Well, I'm objecting to that, Your Honor. I'm not purposely violating any rules. I'm trying to get the question out, and I felt that he never answered it. He never said yes or no. It was a yes or no question. You're allowing him to go around the question, and this is extremely important to my case. I've always claimed that there were texts and...
Mr. Olson, okay, I'm going to stop you there. I said this before, and I'll say it again. There may be a lot of times when you're not going to like the witness's answer, but you move on. Right? You don't get to direct how this trial proceeds, and that's what you're trying to do, because the procedures are quite clear. It's been laid out, and to the extent that you didn't think you were violating the rules of decorum, the second time I'm reminding you of these rules, which is why I'm being extremely patient and tolerant of your antics, okay? So much so that...
I will say this. I feel so bad for this judge. She is being very tolerant, a lot more tolerant than I could ever be, I think, in the situation. I couldn't handle this situation with this guy. He's a menace to society. He deserves a fair trial, obviously, but fuck me, he's hard work.
When I should be counting this as a third violation, removing you, I'm not, and I'm giving you yet another notice in the same morning. I mean, we just started, it's only 9:17. Okay, this is the second warning I'm giving to you now. But are you going to follow the court's rules of decorum? You didn't answer my question.
Well,
it's a yes
no.
or no.
Oh, so you're... that was my...
Another
I'm gonna
rule,
follow
answer
them, but
questions asked by the court. Answer my question. Will you follow the court's rules of decorum?
I object. I'm going to follow, but I would like you to also
Okay,
follow
that's
your own
all I
traditional
needed to
code
hear
of
that
conduct.
you will follow. And I reminded you, if it wasn't clear, you committed 2 violations this morning. The third one will have you removed. Again, if you are removed, you may provide specific questions to standby counsel who will then ask those questions. Otherwise, you'll view this trial from Zoom, and that's a decision you make, whether you want to participate or not, and to what extent you participate. That's all. We're going to go off the record until the jury's brought in.
So when he asked, I have some questions. He asked-
Objection, Your Honor. Lack of foundation calls for speculation. Unintelligible. I don't understand.
You may continue examination, but move on from that, okay?
I object to that, Your Honor. This is material to my case. It's
Noted for the record.
Detective Zalewski, Do you know what the Brady list is?
Objection, relevance.
Sustain. Move on.
Your Honor, I object again. Relevance is to the credibility of Detective Zalewski.
It's noted for the record. Move on. Next question, please. Do not re-ask that one.
Oh my God. So isn't it true when you first started investigating this alleged abduction that you thought Betty Handel was crazy or lying? Or
No.
isn't it true that some of and someone that assisted in your investigation thought that she was maybe having dementia or lying?
Yes.
Isn't it true that when the cell phone was found that there was a person calling from a prison?
I don't know.
So why did you go back and question Michael S. for a second time after he already made a statement?
It's not uncommon for a detective to re-interview people.
Isn't it true that he changed his statement?
Yes.
How many times?
I don't know.
So where did they claim that? Where did Michael Fuller claim that the car was located, or Betty Handel was located when this incident was alleged?
When I spoke to him?
Yes, both times, both statements that he made.
Well, I believe the original statement, which I did not take, Mr. Four stated that he saw Betty Handel's vehicle in motion on High 100. And when I spoke to Mr. Four, he stated that he observed Betty Handel's vehicle already parked at Grandpa Frank's with her waving her hands out the window.
Okay. No, isn't it true that you coerced Michael S. Ford to say that the car was not in motion?
Objection, relevance.
Overruled. You may answer the question if you know it.
No, I just testified that he gave two different statements.
So isn't it true that the reason you went back to get a second statement from Michael S. Ford is that there was something found in the car with Betty that she should have been charged for possessing?
No.
So Michael S. Ford testified that that Betty had claimed that she was sexually abused. Is that true or false?
I believe Michael Ford did testify that he said that, yes.
Is it in his statement?
To police or on the record here in court?
Is it in his statement to police?
I don't know.
No, it isn't. But
Did testify. Okay. Sustain, and that statement will be stricken from the record.
Did Betty Handel ever claim that she was sexually abused?
No, not to me.
Did Betty Handel ever claim that to anyone that you're aware of in Franklin police, anyone involved in the investigation?
No.
Okay, I'd like to go back to the credit card usage. And how many stops? How many usages were there during that alleged incident? How many? Walgreens, SKS. You said Clark. So that's 3. Were there more than 3?
Yes, I testified to this yesterday.
How many were there? Just refresh.
5.
5. And what were those?
There was the SK Petromart, Walgreens. There was a Pilot gas station in Oak Creek, a location in Greendale, and I think a Clark gas station in Milwaukee.
So the usage at Walgreens, isn't it clear that Mr. Olson went inside and Betty Handel stayed outside of the car?
I think we could say Betty Handel did not go in the Walgreens.
Okay. How long was Mr. Olson in Walgreens?
I don't know. 7 minutes?
Is that factual, or are you just making a number up?
I'm guessing right now. I don't know the exact time.
Is there a video that shows when Mr. Olson entered the store?
We watched the video yesterday. Yes.
Is there a time from when he entered?
Yes, I don't remember the exact time.
Isn't it true that yesterday you said it was quite lengthy the time that he was in the store?
No, I said the video was quite lengthy.
Okay, the video pertains to when Mr. Olson was in the store, correct?
Yes.
So, isn't it true that Betty Hanel had been outside on her own for a lengthy time?
Yes, as long as you were in the store, yes.
Isn't it true that this happened numerous times throughout the night, that Betty was in her car on her own?
Can you ask the question again?
Isn't it true that Betty Hanel was in her car on her alone while Mr. Olson went into numerous places?
Well, I could say for certain at least twice.
Isn't it true that Betty Hanel was driving during a couple of these stops while Mr. Olson went in to stores, gas stations, vape shop on 27th Street?
Objection, testifying.
Sustained.
Sorry. So isn't it true that Betty Hanel was driving while Mr. Olson went into stores, gas stations, etc. around there?
No.
Is that factual, or you're just guessing?
Well, I'm going off what video I have, the two videos.
Two videos. So it's not factual. Is that correct?
Objection, I don't know. That was not a relevant question or argumentative.
It is
It is
relevant.
argumentative. It's sustained. Next question, please.
Oh my God. So in your original statement, didn't you claim that when the first stop was made with Mr. Olson at a liquor store, that Betty Hanel was driving?
Can you ask the question again?
Isn't it true in your first police report criminal complaint, that you stated that when Mr. Olson stopped at a liquor store, Betty Hanel was driving at that point?
According to Betty Hanel, yes.
Isn't it true that Mr. Olson went into the liquor store while Betty Hanel was driving to at that liquor store?
That's what Betty Hanel said, yes.
So isn't it true then that Betty Hanel could have easily drove away and left Mr. Olson in the liquor store?
That is possible, but we heard Betty Hanel testify earlier this week.
Isn't it true that Betty Hanel changed her story numerous times about being awake all night and being asleep all night?
No, I don't think Betty Hanel changed her story a bunch. I think she's pretty consistent for her age and the circumstances that she went through.
Isn't it true that Betty Hanel claimed that she had slept from 7 p.m. until 7 a.m., or I'm sorry, around 7 p.m. until the next morning?
No, I don't think that's true.
Okay, so what did Betty Hanel actually claim? What time did she actually claim that she slept from in your investigation?
I don't know the exact times. We heard Betty Hanel's testimony already today or earlier this week.
Okay, I'm asking you in your investigation, in your reports, what did you write down regarding Betty Hanel's testimony as to what time she was supposedly sleeping all night? Isn't that correct? She claimed she slept most of the night.
She did say she slept all of the night, yes.
Isn't it also true that she claimed she was up all night and she was exhausted from being up all night?
Yes, she was with you from 3 p.m. till 8 a.m. the next day. Yes, she was exhausted.
No, that's not what I asked. Isn't it true that she claimed also that she was up all night and so she was exhausted from being up all night?
Yes.
Yes or no?
Yes.
So isn't it true that you just stated then that she changed her story?
I already told you I don't think Betty Hanel changed her story.
Isn't it true that you just testified that she claimed she was up all night or sleeping all night most of the night. Isn't it true? You just testified that she claimed she was sleeping most of the night.
Sure. Yeah, it's debatable. That's why I'm in court.
Isn't it true that you just stated also that she claimed she was up all night and therefore exhausted?
Objection, argumentative.
Sustained. Next question.
Were there any texts in the phone download that happened during the alleged incident?
I don't believe so.
Isn't it true that Betty Handel accessed her Google Voice during this alleged incident?
I don't know.
Your Honor, I would like to submit an exhibit of this usage. It's not in this room; it's in the other room.
Okay. Members of the jury, let's take a 5-minute break. I'll bring you all back. Remind everyone this case is not concluded. Do not talk about this case. Do not conduct your own research. Not post about your experience. Okay.
So yeah, tomorrow we're going to do a new trial from Georgia because Bex is from Georgia. I believe it's a murder trial, but it should only last a week. So, but yeah, I'll get into that later. So today I'm just going to play everything today, get it out of the way. So there are a couple trials on at the minute, but that one's got better audio than the other one so far, anyway. It's in Gwinnett County, Bex.
I will in just a second. I just got to mark them. I needed to make sure I have the correct numbers down. That's all. And I needed to ask if it's front and back of the page. I need to put another exhibit sticker on the back.
Work with standby counsel on that.
Okay, and then also there was one thing that needed to be included with my motion. It's in my property. I'd asked Deputy Bruce last night if he could grab it, but he needed to first clear it with you to go into my property, exactly where my flash drives are. But it's another item that goes with the motion. It was prepared by the jail.
How many pages?
No, it's just a disc.
Okay. Well, if it's a disc, then we can do that later.
Okay.
We don't have to do that now.
All right, that's fine.
The clerk had to go downstairs to file your stack of papers for the motion. It was voluminous, and so because of that delay, any event, we can wait for the disc.
Okay. All right. I just want to make sure it was
Take the
concluded.
next. We're gonna go off the record. Take the next 2 minutes while we bring in the jury for you and Attorney Wasilewski to put the exhibit stickers on your
where's
exhibits. Okay, we're off the record.
Oh.
The witness. Go ahead and ask your question.
Are you familiar with that document? Yes. Your Honor, I would like this to be placed on the screens. Published.
State, do you have that? I think queued up on your computer.
I don't.
Okay.
So that is a,
The Elmo then, I suppose?
Yes.
Okay, so Deputy, if you could take exhibit 505 to the DA's table and we'll put that on the Elmo to project it on the TV screen. But before it actually goes on,
and then this, I don't know if I have the remote for that TV. Got it? Okay, thank you. I would like a little more foundation placed regarding this exhibit.
yes, ask your next question if you have one about this exhibit.
So, do you know what that item is?
It's a printout page from the Celebrate report,
From what Celebrate report?
from Betty Handel's phone.
Do you recognize it?
Yes.
Okay. Did you see what it pertained to on the Celebrate report?
Yes.
So what did it say? What does the document say?
It pertains to web search history that was deleted.
Okay. Does it show that Betty Handel accessed her Google Voice account?
Judge, can I have the microphone?
Yes, we'll have to switch it out though. You can step down if you need to. And okay, let's go off the record for a minute. You have to unplug. Is that, can you shift that face over? The microphone, not the wireless, but can you shift?
There was another, line 2 is another Google.
Abduction, isn't that? So that would necessarily, that is definitely in the time of this supposed abduction, isn't that correct?
Yes.
So Betty Handel's statement of her being asleep through this time is, didn't Betty Handel claim that she was sleeping during this time?
Yes.
Okay, what is the next one below state?
There was another, line 2 is another Google Voice web search. That was deleted.
Is that a web search or is that her accessing her Google Voice account?
Well, it's a web history search of the voice.google.com/u/0/calls.
So the one above, she's accessing her Google account, isn't that correct? Google Voice account?
The one above says voice settings and the one below, line 2, says voice calls.
So clearly she's accessing her Google Voice account. Is that not correct?
Yes.
And what time is that second?
6:52 a.m. UTC.
And that equates to what time in normal?
12:52 Central a.m.
So they're both 12:52 Central?
Yes.
And isn't that also during this time of this alleged abduction?
Yes.
So again, didn't Betty Handel claim that she was sleeping during this time?
Yes.
Okay, I would like to ask that you check the other side of that exhibit. Okay, what does the top entry in that exhibit say?
It's number 3. The voice.google.com/u/0/signup. It was also deleted. Occurred 11/24/2022, 6:50 a.m. UTC, which is 12:50 a.m. Central Time.
Okay, again, isn't that Betty Handel accessing her own Google Voice account?
It's the Google Voice account being accessed on the phone.
Okay, so it's Betty Handel accessing a Google Voice account on her phone. Is that correct?
Can you ask the question again?
So on the other side, you've already stated that Betty Handel was accessing her Google Voice account. Again, this is the third entry. Isn't this also Betty Handel accessing her Google Voice account?
Yeah, Google Voice account is being accessed on her phone. Yes.
That's not what you stated from the other two entries. When I asked you if Betty Handel had access to her Google Voice accounts, and you said yes.
Is there a question?
So, what time was this Google Voice accessed?
Are you referring to line 3 or line
Yes.
4? Which line?
This is the third entry on the top there.
The time is 6:50 a.m. UTC.
And this also was during the alleged incident, correct?
Yes.
And also during the time that Betty Handel claimed she was sleeping, correct?
Yes.
Okay, what does the next entry say?
Line 4, voice.google.com, 11/24/2022, 6:49 a.m. UTC, and it was deleted.
Okay, and again, this also was Betty Handel's Google Voice account accessed during the alleged incident. Isn't that correct?
Yes.
And also, this is the time that Betty Handel claimed that she was sleeping.
Yes.
This was also the time where Betty Handel claimed she was up all night. Isn't that correct?
Yes.
That's that. So are you aware of any other activity regarding Betty Handel actually using her own accounts in any way during this time?
It's a very broad question. Can you be more specific?
What are you aware of Betty Handel using her own accounts during this time? Any accounts? Are you aware of any besides this one?
No.
Okay, this is also regarding the phone download. Are you aware that on October 18th, 2023, DA Sarah Sadowski claimed that no messages were withheld by law enforcement?
Objection, relevance.
Sustained. Next question.
Your Honor, I object to that. This is clearly relevant to.
Court's made a decision. Move on.
Wow. Are you aware that on February 14th, 2024, that an unredacted phone download was then turned over to defense?
Objection, relevance.
Sustained. Move on. Court has made a decision. Move on.
Oh my God. There's a redacted and an unredacted version. I know that, but there's even a thing. There's a redacted version.
Guess what? You're a bitch.
Of course. Yeah, it was in there somewhere. Yes, I do.
Any more questions?
Yes, Your Honor. Just 1 second, please. So are you aware of any redacted or unredacted versions of this phone download that the state has in her possession?
I don't know what you're talking about.
Are you aware that the state has a redacted or unredacted version of the phone download?
Objection, asked and answered.
Sustained. Next question, please.
What? There's a clearly unredacted. Are you aware of a stipulation in order regarding an unredacted phone download?
Objection, relevance.
Sustained. Next question. Court's made a decision. Next question.
Oh my God. May I submit these as exhibits, Your Honor?
What's the exhibit number?
500, 501, 502, 503, and 504.
Okay, Deputy.
Your Honor, I would object to these all being used as exhibits. They refer to the not relevant evidence that we've just been discussing.
Okay. Members of the jury, I'm going to allow you to go on a 5-minute break, and then we'll bring you back in. To remind everyone, this case is not concluded. Do not talk about it. Do not conduct your own research.
And altered and was altered, and I. This is the most important part of my case, is that there was unredacted version of this phone download, proving that there is a text missing, and that the phone download is altered, has been altered, and was altered, and I've been given numerous, at least 2 different versions of the download, which can be proven by the CCAP, where an attorney was given full discovery, and then 1 month later, that same attorney was given an unredacted version of the phone download. So that there was 2 versions given to this one attorney. In January, D.A. Sadowski gave Attorney Cromartie full discovery, and he acknowledges this on the record in court in January of 2024. Then on February 14th, Attorney Cromartie and Sarah Sadowski created a stipulation in order without Judge Child's signature that I couldn't get this new unredacted phone download that was turned over on February 14, 2024. So this is the most relevant part of this case, and is probably the most, important thing for my life right now. And I don't see how this could not be relevant. This is the most relevant of the entire case, and it shows malicious and egregious intent by the district attorney to deceive not only myself but the court, and my attorney at that time is whether it is malicious or not by him, he assisted them by signing that document to keep an unredacted new version of the phone download from me. And they did this with the clerk of courts, Amanda Hodges, without
Sum it up so I can make my
without the judge's signature. And then 5 months later, that same document is fraudulently signed in a sense, because it's 5 months later. So this is very relevant, Your Honor. The text, I know the texts were there. I've seen with my own eyes.
Okay, let me take a real quick look at Exhibit 500 through 504. 500 appears to be an email exchange.
Yes.
And all of these exhibits have your personal notes on them as well that I can see. Okay, upon the court's review of Exhibit 500 to 504, and after hearing arguments of the parties, the court agrees with state these exhibits are not allowed in. Okay, let's bring in the jury.
That's why, Your Honor.
I just said I agree with the state that these exhibits are not relevant. They're attempting to relitigate discovery disputes that have already been decided by the court.
Wow, how is that possible? But it shows that she redacted them. It shows that she's deciding with her. Yeah, but no, because it shows malice. This is intrinsic fraud in the court. This is what this is. You agree with this? That's intrinsic fraud in the court. What? Yes, it is. There's no judge's signature on the. Yeah, but that's 7 months later. They shouldn't have. That's not. This is when they kept it from me. No, it wasn't. No. No. Why can't you believe that this is wrong? Are you like you, or are you just lying?
Ready?
I mean, it's either one or the other. You're clearly lying. I know you can see that that's fraudulent. Signing it down. That's why I tried firing you. Now you're here. You won't help me. No, I mean that's pretty.
Okay, we're back on the record in the presence of the jury. Welcome back, members of the jury. Mr. Olson, please continue.
All right. Even sure how to proceed.
Do you have any more questions, Mr. Olson?
Yes, just 1 second, Your Honor. So you said that Betty Handel had and Mr. Olson had made 5 stops where her credit card was used, and you have video of 2 only. Is that correct?
Yes.
So why didn't you obtain the video from the other 3 stores?
I explained this yesterday due to the reporting with the credit card company going back. They didn't have an exact time, they only had a date. and I didn't go and watch 24 hours of video from each location.
So, don't you think this is important to Betty Handel's claim of abduction, to view video evidence?
Video was not pulled from the 3 other locations.
Wouldn't you normally, in another investigation, pull all video that you could to prove an abduction, a claim of an abduction, which is very serious, is it not?
Can you ask the question again?
Isn't someone claiming they were abducted, isn't that serious?
Yes.
So in any other situation like this, wouldn't you go back and pull all video?
At the time, the police department did their best with time and resources in a timely fashion to get evidence that was needed for this case with video, interviewing people, phone downloads, vehicle searches, getting items to the crime lab. So if we probably did the case again, the same outcome would probably happen.
Isn't it true that you didn't get the video because it disproves Betty's claim of being abducted?
Objection, testifying and asked and answered. Overruled. You may answer the question if you know it.
Can you repeat it?
Isn't it true that you didn't get the video because it disproves Betty's claim of being abducted?
No.
At Mr. Olson's preliminary hearing, isn't it true that you testified that Mr. Olson was actually driving at the liquor store, the first stop with Betty Handel and Mr. Olson?
I don't remember.
Do you think it's odd that Betty Handel was driving during numerous stops with Mr. Olson and Mr. Olson going into the stores, gas stations?
Can you repeat the question?
Don't you think it's odd that Betty Handel was driving during the time that she claimed she was abducted and Mr. Olson was getting out of the car and going into stores and gas stations?
No.
Don't you think Betty Handel could have drove off at any time since she was driving and Mr. Olson was not in the car?
No.
Any more questions?
I would like to go back to your interview with Mr. Olson.
Your Honor, I'm going to object to this line of questioning. It wasn't in evidence and it's all going to be hearsay.
It's permissible to the extent that it doesn't elicit hearsay testimony, and of course that it's relevant.
Relevant. God. The way I'm. Isn't it true during your interview with Mr. Olson that Mr. Olson claimed that?
Objection, testifying.
Sustained.
Did Mr. Olson tell you that he was with Betty Handel?
Objection, testifying.
Sustained.
Oh my God. Why are you allowed it? Why wouldn't you put that into evidence? Looking at that, oh my. So is that normal for you not to use a defendant's interrogation in a case?
Objection, relevance.
What?
Your Honor, if you want to get into this more, you should excuse the jury.
Members of the jury, I'm going to give you a 5-minute break. Hopefully no more. Remind everyone this case is not concluded. Not talk about it. Conduct your own research.
Calling Betty crazy. This was a clear and by if they to use this, I've never heard of a
intention with this line of questioning.
And
when I ask you that, I really mean explain to me how you believe this is relevant and that it's not going to elicit hearsay.
I'm not intending to do anything in that way at all. So that none of that is my intention. Just so you know, Your Honor.
I'm talking about the point you're trying to prove.
Okay, yeah. So I'm trying to prove that to me it is. I've never heard of a defendant's interrogation never used in a case, and I think this is a tactic they're using to conceal what actually happened, because in the interrogation and by if they use the video of this interrogation and of myself and Mr. Zalewski and other detectives that were present, I think that this was a clear and malicious tactic they used to hide the truth because of everyone's reaction, my reaction, Detective Zalewski's reaction, the other detective's reaction, and Detective Zalewski knew that this claim was utterly ridiculous, and this was why they were calling Betty crazy. They even to me were like, "Oh, sweet Betty, you mean?" And they were really sarcastic because she was swearing at them and was.
Mr. Olson, I'm going to cut you off here because I think I've heard enough relative to your proper proof. State, I don't think you need to respond, but if you want to, for completeness of the record, you may do so.
Mr. Olson asked for an attorney during his statement, so I can't play it. Additionally, interwoven throughout the entire statement, the other detectives that were there were the detectives from South Milwaukee where Mr. Olson was accused of a homicide. And so I can't play that statement.
Objection,
and so continuing to go into that is completely inappropriate. Additionally, Safety Johnson 7-4, WIS 2D 2-6 in pages 33 to 38, it precludes the defendant from introducing his own out-of-court statements through the state's witnesses. Additionally, 90801 sub 3, a statement not one made by the declarant while testifying at the hearing is being offered for the truth of the matter asserted. This is exactly what the defendant is doing. He's trying to offer these statements in an out-of-court statement for the truth of the matter asserted. He can't do that. He can get on the stand and testify, but he can't bring his statements in through this witness. And it's additionally it's truly just, he asked for an attorney at that hearing. So I can't play it. We couldn't have a hearing about it. I didn't ask to have a Miranda Goodchild hearing because it was very obvious he asked for an attorney at the beginning, and Detective Zalewski was there. He could tell you that. But so I'm sorry. It's just hearsay, not admissible.
Okay, Your Honor, real quick.
I'm going to rule. Okay. The proponent of that information has already had an opportunity to provide the proper proof, and given the arguments of the parties, the court is in agreement with the state. Thus, it is not allowed. We're going to bring in the jury and continue on. You're not allowed.
May I quickly say something?
No, you cannot.
Please?
No, you cannot. You had an opportunity to be heard as to that evidence, and my decision is made. Once the court makes a decision, it must be accepted, and we'll move on. You can always appeal it. Okay?
May I ask inquire about another question? What I'm going to question him now.
Okay, real quick.
So I'm not allowed to ask him what I said, but am I allowed to ask him why they did not put the interrogation into evidence? Because it is odd for such a serious allegation for them not to use the defendant's interrogation.
Short answer is no.
Okay, and just for the record, I did ask for an attorney, but it wasn't in the beginning. It was
Mr. Olson, let's not relitigate disputes that have already been decided by the court, and let's not relive history. Life.
all right, I just object. I feel like you're siding with the state on everything
Mr.
here.
Olson, you don't always get the last word. Okay? You don't. I control the record, and when I say we're done, we are done. You don't like my decision, you can appeal it. I remind you that paragraph 9 of the court's rules of decorum, you are to accept the court's ruling. You may not like it, but you have to accept it and you move on.
May I add?
No.
Can I object to anything? I can't object. Wow.
Okay, we're ready.
Huh? I mean, I'm not allowed to ask him anything. It's quite ridiculous. They didn't use my interrogation. I'm supposed to ask for an attorney for actually spoken to. How do you mean? Ridiculous.
Okay, we're back on the record. Welcome back, members of the jury. Mr. Olson, please continue.
So, Your Honor, before I make my request, am I allowed to make a request to you of this witness?
Okay, my apologies,
Sorry.
members of the jury. I'm going to take you back out there for another break. I hope it's a
Sorry.
short one. Remind everyone this case is not concluded, not talk about it, and do not conduct your own research. Okay. We're outside the presence of the jury. Mr. Olson, you may think this is funny.
No, I don't.
No, I don't want to hear anything from you while I am talking. This is not acceptable. And although I've had your case for a very long time, I think I've had enough exposure to you to know how you conduct yourself. I'm not going to tolerate this anymore. We've lost so much time. I am, however, though, going to give you just a little more time to talk to standby counsel so that you are, I know you're aware because I've gone through this with you before, but that you remember and appreciate that there are rules and procedure we all must follow. And while you're not an attorney, I don't expect you to know. The fact remains that you are representing yourself, you have standby counsel, you are expected to know the rules of procedure. And what you are doing, and I know you're fully aware of this,
No, I'm not.
is to delay this trial.
No, that's not true, Your Honor.
Again, we're not having
Well, it's not
a
true.
conversation back and forth. You don't get to engage with me, okay, in a conversation like this. I am talking, okay? And again, you may not like what I'm saying. You may not like my decisions, but you still have to accept it and we'll move on. There's only one person in this room who controls the proceeding, and that is the judge. Doesn't matter if it's my courtroom or anyone else's courtroom. So now I'm going to go off the record to give you a few minutes to talk to your attorney about criminal procedure so that you understand, because what you just pulled right now, okay, when we bring in the jury, we're ready to go. Okay, you had an opportunity, which would have been a sidebar discussion. So we had a discussion outside the presence of the jury, okay, relative to your examination. If there were other things that you wanted to do that you believe would require the court making a decision, you should have taken that up while we were outside the presence of the jury. And mind you, this morning I started off with letting everyone know that if there's anything you need during examination, let the court know. You had a chance to let me know, but you waited until the jury was brought in. It is not acceptable. This is another tactic of yours to delay this trial. And I'm warning you, this is a stern warning. Again, I'm being more than tolerant of your behavior and your antics, but I remind you that the rules of decorum, I should just have you removed from the courtroom, okay? Because this should be another violation of the rules of decorum. But out of extreme caution, ensuring that this case proceeds in a fair and just manner, I'm going to go off the record so that you can talk to standby counsel to make sure that you understand what is and is not permissible. No, we're done. You don't control the record. You have to understand that. You don't control the record. Here, we're off the record.
She doesn't let me speak. What's for? I asked her to let you take over because I had a concussion at the beginning of this week, but she denied my right to let you take over. That's why I don't have the right. Yes, no, that's what she told me. No. Listen, let me finish. So you interrupt me, she interrupts me.
Yes.
It doesn't make any sense. I can't interrupt anybody.
You're not going to come for the break, sir?
Yes,
Thank
you may step down. We're off the record.
God, man. Anybody else? So. I didn't ask for any. All the pictures from Betty Handel's car that were taken and any items found, and the original phone download that he has in his possession, because I believe this is extremely important to my case, and it's the most vital piece of information, and it involves my life here. And I would like to ask you to order those 2 items be turned over directly from Brian Zalewski so that they can be evaluated by myself. And this would not even take very long. This would take 10, 20, 30 minutes at most, maybe not even that long for me to examine these 2 items and maybe have them examined by a professional who I've already been in talks with. So that's my main concern. I just wanted to say real quick that now when Attorney Wazalewski was appointed, and I did fire him for whatever reasons, that I feel he wasn't helping me. But anyway, you forced me to keep him as standby and said that he was there just in case I needed him to move forward with trial if I was not prepared. Now, when I had a concussion during the beginning of this trial, when there's no final.
Olson, I'm going to direct your focus. Okay. We have a witness on the witness stand, and you had an ask of the court. I understand your ask now is for the court to issue an order directing the detective to turn over discovery directly to you rather than through the usual protocol, which is to the state.
Or the court.
I got that. Okay. And then you now want to also relitigate legal representation. That's at this time.
No.
Oh, you're talking over me and I'm not done talking. That's a violation of the rules of decorum. I've really just had it with you, Mr. Olson. You commit any violation of the rules one more time, I will have you removed, and you'll view this trial by Zoom. I will work on figuring out the logistics of that, but I lost count already, but I think this is probably the 3rd time I've had to warn you that you're on the verge of being removed for the remainder of the trial. So, as I was saying, you want to relitigate your right to legal representation. At this time, okay, a couple things. First and foremost, that's an issue that the court has already decided. The record, I think, is quite lengthy, and it's clear as to what transpired and ultimately the court's findings and decision. The other point is that that's not germane to the examination of this witness. Okay, so you are to stay on what's relevant, and I trust that if you're not, that the parties, well, it doesn't matter whether it's you or a state, but if the line of questioning elicits information that either one of you believe is not relevant, I would expect and I trust that you guys will make your objections and it's noted for the record. But I've just really had enough with your antics. It's 11:03. We can barely get through the examination of this witness. That's all for the record. We're going to bring in the jury and continue. And I think for clarity of the record and finality of the record relative to defense's request with respect to the request of the court issue an order, it's denied by the court.
All right, may I comment?
No.
I mean, I have to deal with this street, bro. She just goes on and on and on. That's fine, but this is ridiculous. This whole trial is a joke. I don't have discovery. You have it, and it won't open. The 2 you gave me wouldn't open. We tried to open them right here. Yeah, that was what Judy back in 2 years is very limited. They never had full discovery. Look. One by Judy Basher.
Objection, Your Honor. Lack of foundation calls for speculation. Unintelligible. I don't understand.
All my discovery for the case. The 1 game by Judy Basher, the 2 games by you don't.
Right.
We tried. So you've seen that that shows that Mr. Olson was physical or forcibly placed anyone or restrained anyone, Betty Handel?
No.
So are you aware of anything physical, Mr. Olson trying to physically do anything to Betty Handel inside of, what was the name of that? Casa de Giorgio?
No.
Are you aware of Mr. Olson forcibly going into any car belonging to Ms. Handel? Forcibly.
Yeah, I think that's debatable based on what I think forcibly is. I'd say yes.
You're aware that Mr. Olson forcibly went into a car. You're aware of that personally. You seen that?
I think if I didn't see, I'm going on the testimony of Betty Handel.
Okay, that's
If
hearsay.
I'm
That's hearsay.
Judge, can I finish speaking?
Sorry. No.
You ask the question, let the witness answer.
I think you're asking me if it's forcibly. If I'm getting into my vehicle, I have an expectation of privacy that no one else would be entering that I'm not expecting. So if someone's opening a passenger front door, I would consider that forcibly.
Are you aware that Mr. Olson actually closed Betty Handel's passenger door or driver's side door for her?
Objection testifying.
Sustained. Next question.
Is there any video outside of Casa de Giorgio?
No.
Are you aware that Betty Handel testified that Mr. Olson and herself only spoke for a minute or two before she left Casa de Giorgio?
Can you ask the question again?
Are you aware that Betty Handel testified that her and Mr. Olson only spoke for a minute or two before she left Casa de Giorgio?
Yes.
Are you aware that Rex testified that Mr. Olson and Ms. Handel actually spoke for about 45 minutes to an hour before they left together at Casa de Giorgio?
I would disagree with your statement of what Rex said.
Okay, are you aware that Rex did testify that Betty Handel and Mr. Olson spoke for 45 minutes or longer?
Objection asked and answered.
Sustained. Move on.
Are you aware that Betty Handel claimed that she walked out alone and that Mr. Olson went out after?
Yes.
Are you aware that Rex testified that Betty Handel and Mr. Olson actually walked out together?
Yes.
Are you aware that Betty Handel did not want Rex to know that she actually knew Mr. Olson?
No.
Also during your investigation, let me think, how can I phrase this? So besides the 5 stores that Mr. Olson and Ms. Handel went to together, are you aware of any other stops?
Yes, according to Betty Handel's testimony, yes.
What were those other stops?
So at some point you stopped for liquor, unless it was one of the 5 stops that's already used with a credit card.
Wasn't there a testimony of another stop somewhere on the north side?
Yes.
Okay, what time was that?
I don't remember. It's the northernmost point on the map that I made.
Okay, there was also a stop made that Betty Handel testified to, where Mr. Olson got out of the car.
Question?
Are you aware of this other stop that was possibly that it didn't involve a store?
Yes, there's a lot of different things that have happened here in 16 hours. Yes, Betty Hannell used the bathroom in an alleyway. Yes, there's a meetup with somebody.
Okay.
Betty Hannell is drinking alcohol. Betty Hannell is asleep.
The stops. That's only for the stops.
Olson, will you please let me finish?
I only asked for the stops, so I didn't ask for you to continue.
Next question.
So there was a. What about this meetup? Could you tell me what this meetup was?
I don't know.
And what time did this meetup occur?
I don't know.
When was? Didn't this occur during the time Betty Hannell claimed that she was asleep?
I'm not sure.
Didn't this also occur during the time Betty Hannell claimed she was up all night?
I'm not sure.
Are you aware of Mr. Olson got out of the car at this time?
I don't know.
Mr. Olson, any more questions?
Let's see. No, Your Honor, that's all.
All right, thank you. Redirect.
Thank you. Just to be clear, Your Honor, just some basics. When you conduct an investigation and you collect evidence, is that kept at your police station?
Yes.
Yes. Could you tell us about that process generally?
Like any just general how I collect evidence?
Well, let's just talk about the phone download for fun. When you do the phone download, what do you do with the original first version?
It's placed on a forensic server that we have at our police department.
And is that ever deleted, changed, or moved?
No.
No. And then how do you turn that over to use in a case?
Copies made and is given to the district attorney's office when the case is filed.
Do you alter that case? Do you alter that file?
No.
No. Did you find any evidence in a phone download, in conversations with Betty, about Mr. Olson knowing Betty?
No.
Did you check all of the texts?
Yes.
Did you interviewed Betty, correct?
Yes.
Did Betty talk about what happened to her cell phone during this incident?
Yes.
What did she say happened to her cell phone?
Said Mr. Olson took it from her.
And at what point in the abduction did Mr. Olson take the cell phone?
Fairly early while she was, I don't know if she was driving or if she was in the passenger seat, but very early in the abduction.
When Betty was recovered, did she have her cell phone on her?
No.
Now, Your Honor, I don't know if Exhibit 505 was ever moved into evidence. No. No.
Yes. I would like to move that in evidence, Your Honor.
Any objection? No, thank you. Received. Oh, I think the TV's turned off again. But do you remember Exhibit 505? No.
Is it what's up right now?
It will be shortly, yes. It was the defendant's exhibit.
Yes.
When you read under the URL, is there an account associated with that?
No.
Can you tell who typed in that Google search?
No.
Does the phone log face recognition when people are typing in Google searches?
No.
And after those Google searches were made, were they kept on the phone?
No, they're deleted.
And we talked about deleted messages and phone calls yesterday. What time frame was deleted off of Betty's phone?
Are we talking about these searches right here or everything?
Everything.
Uh,
Generally.
Generally, like from 7 or 8 a.m. on November 24th, 2022, going backwards.
Just briefly, Mr. Olson brought up Wesley Erdman.
Yes.
What relevance does Wesley Erdman have to this investigation?
The relevance is at one point, Tim Olson claims that he's Wes, and that will prove that they're friends. So I look into that communication between Wes Erdman and Betty Hannell. I reach out to Wes Erdman. I learn that he's a family friend. At one point, he's an older gentleman. At one point, he was dating Betty Hannell's now deceased husband's sister, and that they're friends and they speak once or twice a year.
Did you speak to Mr. Erdman in person?
No, I spoke to him over the phone.
Over the phone. Would you have been, if that phone number belonged to Mr. Olson, at that time, would you have just been able to pick the phone up and call Mr. Olson?
Yes.
Yes. Well, and then where would Mr. Olson have been during that time frame?
I'm sorry.
Would you have been able to call Mr. Olson directly?
I wouldn't have.
No, you wouldn't have been able to call him.
No.
No. So, but you were able to call Mr. Erdman directly?
Yes.
How many victims of crimes have you interviewed in your career?
I don't know. A lot.
Objection, Your Honor.
On what grounds? What basis?
For relevance. Misleading the
response?
jury.
He was attacking the credibility regarding different statements, and I think that talking about victims and their responses to trauma is relevant. So I'm trying to set the foundation for that.
Objection overruled. You may answer the question if you need to repeat it. State can do so.
A lot of victims.
Like hundreds, thousands?
At least thousands.
At least thousands. So when a victim initially reports a crime, is there a standard reaction that occurs?
Yeah, they're scared and they have emotional distress.
And if you re-interview that victim a few days later, what is their demeanor like usually at that time?
Calm.
Is it common that some of the statements change between those two interviews?
Yes.
If two different people interview the same victim, do they ask exactly the same questions?
No.
No. So, for example, you interviewed Michael Four, is that correct?
Yes.
And then Officer Garrett Olson interviewed Michael Four, is that correct?
Yes.
Was Garrett Olson's interview recorded?
I don't know.
No. Did we see any recordings of the interview during this trial?
No.
No. Was your interview with Mr. Four recorded?
I don't know.
No. And did you compare notes and ask exactly the same questions?
No, we did not.
Does it make sense that the responses are not exactly the same?
Objection, Your Honor.
Yes.
On what basis?
He's giving his opinion.
Objection overruled. Next question.
Thank you. Did you respond to the original scene where Betty was recovered?
This is my response as well. I can guarantee you, right, if there was an actual competent attorney representing him, like, we would see how fucked up this investigation was. This investigation, there was no video taken, nothing was recorded. A lot of this is hearsay. I'm not saying he's not guilty of it, but this is a piss poor investigation by this guy. But he gets a pass because this idiot decides to fucking represent himself. What an absolute clown. So, yeah, you know what? So I'm not going to give these guys a pass. This guy's got a right attitude problem. He did a shit job here. And just because the defendant's a clown, yeah, I don't think the defendant understands that. I don't know whether he would have still been found guilty, not guilty, whatever, but he would have had more of a fighting chance to expose how shit they actually did.
Covered?
I'm sorry?
Did you respond to the scene where Betty was recovered?
No.
No. Did you hear the original conversation between Michael Four and Betty?
No.
Do you have any idea what was said on that scene?
No.
He knows from the statement.
I have no further questions.
Recross of the state's redirect.
Okay, so first, when did Mr. Olson claim to be this Wes Erdman?
Objection. That's fine.
Sustained.
I'm confused. Testify. How many?
Next question.
So you just stated that at some point Mr. Olson claimed to be, or I'm confused. So at some point you said that you claimed Mr. Olson claimed to be this Wes Erdman. I mean,
What's the question?
what? In what way did Mr. Olson claim to be Wes Erdman? To who did
Hold
Mr.
on.
All right,
Ask
all
the
right,
question.
sorry.
Let the witness answer.
Do you have any idea about this?
I believe from listening to jail calls, I believe you stated that would prove that you're friends with Betty.
What? Has this been admitted to evidence, this call, where I claim to be, Mr. Olson claimed to be Wes Erdman?
Objection. Relevance.
Sustained. Next question.
What has been happening? A phone call? You really said how to redirect it. I mean, is this testimony about what your claim is to Wes Erdman? Is this something you heard on a jail call?
Yes, I believe I heard it on a jail call.
I can't ask if he's placed this in evidence. What? I don't know. I don't have discovery. Is it so? Has this been placed into discovery? Has this call been placed into discovery?
Objection. Relevance.
Sustained. Next question.
Oh my God. Do you have any knowledge of this? Is this accusation, absurd accusation, is this in any police reports or statements or in this investigation?
Objection. Relevance.
Overruled. You can answer that question.
I don't think it's an accusation. I believe I did write a police report for me speaking to Wes Erdman.
I'm just confused. There's no jail call around. So according to your police report right here, there's nothing in here that you said that you heard Mr. Olson claim he was Wes Erdman.
There a question?
Is there something in your police report stating that you claim Mr. Olson claimed that he was Wes Erdman?
I believe I wrote a police report for reaching out to Wes Erdman.
You're saying Mr. Olson reached out to Wes Erdman?
No, I spoke to Wes Erdman.
Okay, so regarding your claim that Mr. Olson claimed he was Wes Erdman, did you write a report on this?
I wrote a report about speaking to Wes Erdman.
Did you write a report about the phone call that you listened to?
I don't remember.
No. Absurd.
I'm not going to give this detective a pass. There's a lot of stuff here that I think is shady. This is why I think this guy gets another trial if he's found guilty.
Did you listen to many of Mr. Olson's phone calls?
At times, yes.
Did you ever hear Mr. Olson say that Betty Handel actually bought him a Thanksgiving Day card?
Testifying.
Sustained.
Also, there's no point you saying, "Oh my God, you brought this on yourself, dude." You didn't. You sacked so many attorneys. He did a Sarah Boone, so he's brought this on himself. But he's also going to get a new trial if he needs one, if he's found guilty, which I presume he is, because this is a shit show.
So what? are you aware that Betty Handel bought Mr. Olson a birthday card?
Objection. Testifying.
Sustained.
I can't prove it. It really happens. It's all he just made up something about the phone call. I need to show his line. So during this alleged phone call from the jail, how did Mr. Olson claim to be Wes Erdman?
Objection. Relevant.
Overruled. You may answer the question.
I believe you're speaking to your mother and you explain that this person or communication will clear you to show that you're friends.
So, is any of this accusation placed into evidence?
I don't know.
Is any of it placed in discovery?
Objection. Relevant.
Sustained. Next question.
Is there any way you can prove this accusation that Mr. Olson claimed to be Wes Erdman?
Objection. Asked and answered.
Sustained. Next question.
Hold on. Asked her.
Any more questions?
Yeah, just a second, Your Honor. I'm just making sure I don't violate any more rules. What were you saying? So, regarding the exhibit, also, these accessing these accounts were during this alleged incident. Did you investigate these Google Voice account entries?
No.
This was a pretty serious alleged incident. This alleged abduction. Isn't it odd that you didn't do a lot of investigating? You didn't. Isn't it odd?
No.
You don't normally investigate serious cases to the full extent?
I do. I think I was very thorough investigating this case.
So do you think that not viewing camera footage from 3 of the 5 alleged incidents involving an abduction and supposed identification fraud, do you think that not checking those 3 video footage of those 3 locations, do you think that's investigating to the full extent?
During my investigation of Betty Handel being abducted, I followed the paper trail back. I was able to get video at 2 of the businesses where Mr. Olson used her credit card without Betty Handel in the business. At one of the businesses, she stayed in the car. You can see there's another person in the car. I think that's being very thorough. I'm not going to waste time and resources pulling video that I may or may not get at a business, 24 hours of video, and then holding it to go through it and scan it at a later date when I have other pressing issues and time management, and how I handled the case was my call.
Okay, do you think that someone alleging an abduction is wasting your time to have that investigated?
Objection. Argumentative.
Sustained. Next question.
Wouldn't you normally investigate the phone usage a little more? Like, wouldn't you normally investigate this account, who accessed it, whose account this was? Wouldn't you normally investigate that?
I did investigate this.
You investigated whose account was accessed right there?
No,
You just stated that you did investigate.
I investigated the phone download.
So my question is, don't you think this case was serious enough for you to investigate whose account was accessed there?
I already answered yes, this is a serious case.
Okay, so for the redirect with Michael Scott 4, even though you did not hear what was said, Betty Hannell never claimed to have been sexually abused. Is that correct?
Yes,
And also for the record, Michael Scott 4 changed his story as to whether or not Betty Hannell was driving or not driving.
are you asking me?
Yes, for the record, he did change his story, correct?
Yes,
For the record, you also changed your testimony from the prelim and from what actually happened in the criminal complaint. Is that correct?
No.
I'd like to remind you that you're under oath.
Objection argumentative.
Sustain. Ask a question if you have one.
Isn't it true that so you had just stated that Michael S4 changed his story.
Objection yes and answered.
Let him finish the question.
So again, and this is pertaining to the entire case, Betty Hannell changed her story numerous times, correct?
Okay, sustain. The objection sustain. Next question, please. Do not answer.
That's all, Your Honor.
All right. Follow up to that, State.
Just briefly. Officer, if I showed you your report regarding your interview with Wes Erdman, would that refresh your recollection about how you actually heard about this person?
yes.
Yes.
Thank you.
Take a moment to review, and when you're done, please give that back to the deputy. So, why did you look up Wesley Erdman?
Because you asked me to.
And you're familiar then with what was previously marked as exhibit number 114, correct?
Which is what?
The download of Betty's phone.
Yes. Okay. Yeah.
And I'm pulling up what is page 411 of 15,086. And I'm looking specifically at the box labeled number 2. Is there a name in that box labeled number 2?
Yeah. The name is Wes.
Is there a last name?
No.
No. Does that, you just reviewed your police report regarding Wesley Erdman. Does that phone number right above Wes look familiar?
Yes.
By the context in this, could you tell who this was, this individual named Wes?
You mean just from reading this?
Just from reading this?
No.
No. So as part of the investigation, was it important to figure out who Ms. Hannell communicated with?
Yes.
I have no further questions.
Okay. A follow up to that from defense.
Well, my only question to you is, would you supply a copy of this phone call you listened to the court, the state, the defendant, that you heard supposedly heard Mr. Olson claim to be Wes Erdman?
I might be mistaken. I've listened to a lot of calls of yours.
All right. Say any follow up to that?
No.
Okay. Thank you, Detective. You may step down.
And that's exactly why it's gone from he's heard it to now he may have been mistaken, he may not have. So there is no call. Or if there is a call, it was never, it's not like, this is what I mean. There's a lot of stuff going on here that an appellate lawyer, if he's convicted, will have a field day on. So I do believe that there's enough evidence will be produced that he will get a new trial if he wanted to. Now, if he decides to do the appellate appeal himself, then he's got no chance. But a proper attorney would have a field day in this trial. Like you just heard this guy testifying that he believes he heard it on a phone call. Now he's been asked to produce it, or that he may be mistaken. Like, that's quite big, you know. That is, but he's not going to be able to tell the jury how big that is. You know, that's again another detective, another police force doing shady shits.
It's now 11:49, members of the jury. What I would rather do, rather than have the state call their next witness to start very briefly and then recess anyway, I'm going to release you to lunch, but order that you come back a little earlier. I would like us to go on the recommendations for Monday, that they be given that time as advance notice as possible. Unfortunately, we couldn't get there. So to make up for some lost time, I want us to start at 1, hopefully no later than 1:05, 1:10, around there. But certainly before 1:15, we should be on the record with state's next witness. I understand state has 2 more witnesses. At this time, I'm not going to hold you to it, Mr. Olson, but I just want to gauge the time. How many witnesses and whether you would testify?
So my witness list was never, the subpoenas were never went out. I was told that Attorney Zalewski was
Okay, the question is how many witnesses and whether you would testify, so that I have an idea on timing. That's all. I'm just asking for a number.
So so I need to ask, because there's supposed to be a final pretrial. So this is all thrown out of whack.
I'm going to read the record one more time, Mr. Olson, and mind you that you are to answer questions asked by the court. I'm looking for a number so that I can have an idea of timing so I can instruct the jury. How many witnesses, including yourself, and you don't have to tell me if you're going to testify, I just need to know a number.
Okay, hold on one second.
It's not going to be 0. Let's just assume that. I think that would be a safe assumption. So if we have state's 2 witnesses and defense will call witnesses, what I'd like to eventually do is state when you finish your second to last witness, we're going to take a break, and then at that time, I think it's probably reasonable then at that time to consider that we're going to have to go into Monday, that we may have to go into Monday, because even if we start at 1, unless if you can only do so much, and then Mr. Olson can only do so much. But even if the 2 of you are pretty expeditious, that will still probably end us at 3. And then after read the jury instructions, which means there's probably going to be very little time for the jury to deliberate. Of course, I have no idea how much time they'll need, but I want to alert them to the possibility, and an emphasis on possibility, that this could go into Monday. And if that's the case, that they at least have some advanced planning or notice so that they can do some advanced planning. That's my thought. That's why I'm inquiring with the parties as to your numbers of witnesses. State?
Can we just see how it goes after the state's case in chief? I don't expect, it's 2 crime lab analysts. I'm not going to take that long with them. I hesitate to alert the jury that they might be here on Monday with the impending weather, because I'm afraid then they're going to just be angry as opposed to listening to the rest of the evidence. I think they're very well aware we're still going. So I believe just waiting until we see if Mr. Olson has any witnesses and then alerting them at that point. But I think it's a little bit premature.
The time that I'm going to have in my head is 3 o'clock. So the sooner we start ticking closer to 3 o'clock, that's when I'm going to really seriously consider informing the jury that, because I think between 3 and 5, that's just very little time. My reading of the jury instructions is probably going to take close to an hour, 30 minutes minimum. Okay, Mr. Olson, your thoughts on timing, and limited to timing only. We're only talking about timing. Your thoughts?
I mean, I'm not quite sure right now, to be honest. I don't know as far as these 2 witnesses testifying. I mean, so I can't speculate. So
that's fair. And so just think about it. Parties, think about that. Again, in my mind, 3 o'clock is going to be my gauge. The closer we get to 3, I think the higher the possibility that we may not be able to finish today. Attorney West, will see if you could talk to Mr. Olson about the witness lineup and then the colloquy that I'll do with him as well, so he understands. Okay, we are going to go off the record and go to lunch, and we'll be back up at 1 o'clock, and hopefully we'll go on the record immediately after 1. Okay,
can I really quick? I needed Deputy Bruce is very, very accommodating and nice, but anyway, I needed him to grab the item for my motion for my property. Is that okay? Sometime before whenever it's necessary, I just need it to be done sometime before the motion is completely heard.
Yes, you may do that, and I think the deputies know how to get my attention. If you're requesting for something and they are unsure and they want to ask me, they know how to do that. So I don't think that needs to be on the record. Okay, we're off the record.
So he does testify, I've just learned. So, and you'll find out because of, hang on, you can see him here on the stand. So,
Pro se, standby counsel John Vasilevsky also appears.
Yeah, so I was prescribed medication for nausea, vertigo, and I should have been given this medication 3 times a day since last Friday when I initially had a concussion. And then again on Monday when I had the second concussion and a seizure. So I've only gotten this medication 3 times in an 8-day period, and it's supposed to be 3 times a day. I'm not getting it at all. A lot of this problems could have been solved with just getting that medication. Just like to ask if that'd be possible that I get that vertigo and nausea medication. It's a big deal with the severe concussions that I've had in the last 5 days, week.
I think during an extended break, it would be appropriate to have the deputies taking you down back to the jail to see the nurse to have those medications administered. But these are the same medications that the nurse has already indicated that they are not, that you're not required to take it. You can take it to help you, but these include, I know you indicated this is medication for vertigo, but it also includes medication for vitamin D deficiency, as well as for acid reflux and things and whatnot. But ultimately, the bottom line is that the nurse has already indicated to the deputies, which was conveyed to me, that it's not required that you take these, and it's a nice to have, not a requirement, that kind of thing. And so I will do my best to accommodate that, but for the time being, we're going to proceed with the trial.
Okay, there was one more thing from the doctor's orders for the concussion and the seizure. I was supposed to be taken immediately.
Mr. Olson, I'm going to cut you off right there because we are not going down that road. We have not that much time and we're starting really early. I remind you that you are on your last straw. The 3rd violation will result in your removal from the courtroom, and you will observe the rest of the trial on Zoom until at which point when the court inquires with you and you promise and are willing and able to comply with the rules of decorum. Okay, so again, as I was saying, the jurors are all here. We're ready to go. So we'll bring them in and start the trial. State, you have your witness ready?
I do.
Okay. Ready? Okay, let's bring them in. Okay, welcome back, members of the jury. Okay, State, please call your next. I do.
Please state and spell your name for the record.
Melissa M. Groff, G-R-A-F as in Frank.
Thank you. Ms. Groff, how are you employed?
I am a forensic scientist who works in the latent print and footwear unit at the State of Wisconsin Crime Lab in Milwaukee.
And I'm going to break that down a little bit. What is a forensic scientist?
My area of expertise is, forensic science basically means applying science to the law. So my day typically is working on latent print and footwear cases that are submitted from the 8 counties in the Southeast Wisconsin district.
And then what is a latent print?
Latent print, the skin on your hands and the bottom of your feet is different than any other skin on the rest of your body. And it's different because it has raised ridges. And these raised ridges do not flow smoothly from one side to the other. Rather, they can split into two or stop abruptly. And then on top of those ridges, you have sweat pores. And so there's a chance that you're constantly exuding perspiration, as well as picking up fats and oils and substances, both from touching your face or your environment. And then like a rubber stamp, when you touch an object, there's a chance that you're leaving that impression behind.
And you also said you do footwork. Did I hear that correctly?
Footwear.
Footwear. Oh, footwear. What is footwear?
Similar to latent prints, it's examining and comparing footwear from a crime scene. So the bottom of your shoe wears down and gets individual characteristics. And then sometimes if we step in dust or something, you can leave that behind at a crime scene. And then they'll submit a pair of shoes and I compare the two.
Thank you. What type of training and experience, or what type of training do you have to become a forensic scientist?
I have a bachelor's degree from Marquette University. I also spent 3 years with a senior examiner in a one-on-one internship situation or apprenticeship type program. I have over 100 hours of processing classes and over 200 hours, of comparison classes. I also try to regularly go once a year to a conference or some type of continuing education. And I am certified by the International Association for Identification in Latent Print Examination.
And how many times have you testified as an expert in Wisconsin courts?
About 56 times.
I'd ask that Ms. Groff be qualified as an expert.
No.
The court's not going to do that, but you can continue your examination.
Okay. So, Ms. Groff, you've testified about 56 times. And we're here today to talk about latent prints. Could you tell us a little bit about how you receive latent prints from a police department?
There's basically two types of cases. We'll get cases that the agency processes themselves. And so then we'll get like a latent lift or a photograph of print. Otherwise, they actually submit the item itself. And then I actually use chemical and mechanical processes to make that latent print visible so that we can do something with it.
I would like to show the witness exhibit number 117. Ms. Groff, are you familiar with exhibit 117?
Yes, I am.
Could you tell us what that is?
It is the confidential report of laboratory findings that I authored on February 20th of 2023.
And how do you know you authored this report?
My initials are on the first page and all the subsequent pages have them as well.
And when did you author this report?
February 20th, 2023.
And is there a certain tracking number of this report?
There's both a case number and an agency number.
Could you tell us what those are?
The case number is R as in Robert 23-450.
And why is that case number important?
That is how we track the evidence. Once an agency brings in an item, it gets barcoded in an evidence intake. That barcode will then follow the evidence through the process. And that's how I take custody of it. And that's how I write a report. And then if an agency has a question, they need to have a case number to give me so that I know what we're talking about.
And is that report your final report for this case?
Yes, it is.
Okay. I'd ask that exhibit 117 be moved into evidence.
Any objection?
No, Your Honor.
Received.
Thank you. Permission to publish?
You may.
Deputy, or yeah. Ms. Groff, I'm going to show this and walk through the report piece by piece. There's a TV near you, and that microphone also has a pretty long cord, so you kind of move that a bit.
Okay, yeah, that's pretty far.
It might be easier to grab the microphone and see what's the one next to you.
Ms. Graff, if you need to, you can stand right next to the TV and move the microphone closer to the
that's
TV.
okay.
Yeah.
Okay.
Thank you.
Okay.
And I'm just showing the top of this page. The case number we discussed is on the top of this page. It's to the right of the screen that I'm pointing at, correct?
Correct.
And then that is your signature that we discussed.
Yes, it is.
And in this report also was authored on February 20th, 2023. Is that correct?
That's correct.
Do you know which case this is referring to? Or the victim's name or the defendant's name?
The case names will only show the victim on the report, but in my submission and transmittal, I get all that information that comes from the agency.
And then some general questions. Do you know which agency submitted items for this report?
Yes, based on the upper left-hand corner that says Franklin Police Department.
And what items did you receive to analyze from the Franklin Police Department?
I believe it was items I, J, and K.
And then if I go towards the bottom of that, are those the items that you received?
That's a partial listing of the items. I believe they also show up continued on the second page.
Is that the continuation of the item?
Yes, it is.
And how do you receive those items? Or what do they look like when they come to your lab?
It is our policy and procedure that all items have to come in a sealed condition. So they either need to be in like a heat sealed plastic bag that is initialed and dated on the top and the bottom, or a sealed envelope so that no cross contamination and no evidence can be lost. I believe it was a heat sealed bag in this case. I'd have to refer to my notes if you want an exact.
That's okay. You believe it was a heat sealed bag?
I believe so. It was either that or an envelope, tape sealed.
Thank you. When I'm looking at this box, there's 3 columns, correct? Could you tell us what those 3 columns designate?
Sure. So the item number, once I open an item, if there's multiple things inside that packaging, I have to sub-designate it. So in this particular case, you can only see the top 12, but there's 2 more on the second page. So the first column is the item number, and I give that based on how I pull them out of the item. There's no special way to look at it. Just one gets one and the rest get the subsequent numbers. And so I believe there are 14 in this particular case. The middle column is an item description. So what you're seeing here is that I say that they're latent lift cards, which means that it was processed by the agency and then lifted, and they just submitted the lift card to us. I didn't actually get an item to process. If I did, that item description would say what the item was to process. And then the final column says suitable questioned FRD designations, and that stands for suitable question friction ridge detail designations. So our policy states if we decide that something is suitable for comparison, I have to give it an FRD number. So the first item and then 3 through 12 had no suitable friction ridge detail on them.
And I'll just turn to page 2 so
Okay.
we'll talk about them all at the same time.
And 13 and 14, I believe, were not suitable as well. Correct. But item I2 had friction ridge detail that was suitable. And so I gave it item number I2-FRD1. So it stands for item I2-friction ridge detail number 1.
And when something is not suitable for friction ridge detail, what do you do with that, in this case, lift card?
In this particular case, they wouldn't. What happens is when I open them and I first take a look at them, if they're possibly suitable, meaning I see enough of that detail that we talked about, that reproductive detail, I will scan it into the computer and then look at it more closely with Photoshop, which I did for a couple of the other items, but then ultimately decided that they were not suitable. When I talk about the stamp and the ridges and they don't go smoothly from one side to another, rather they split or abruptly stop, where that happens is called minutia detail. And then it's that combination of that minutia detail and unit relationship to each other that I can decide whether I can actually make a comparison to a known standard. And that's what makes it suitable, is if I feel that there's enough data that I can mark that I can make a comparison. So the other ones that were possibly suitable, once I analyzed them closer, I decided that they were not suitable, but I2 was indeed suitable to take to the next step, which would be comparison.
And are there types of items that are better to get fingerprints off of than others?
Absolutely.
Could you discuss that a little bit? And if you want to sit down in between some of my questions, no, that's, yeah, no, sorry, but.
Friction ridge detail is very, can be very difficult to process and develop. So typically a smoother surface tends to lend better to leaving that residue. Some people leave really good fingerprints and other people do not. Paper is traditionally a very good surface. A textured part of your car dash might not be. So it's a fragile thing that you're trying to develop. And the smoother and the easier it is for that transfer, the more luck you'll have in developing something that's suitable.
So for example, a flat surface might be better than a rounded surface. Would that be correct?
Depending on if that rounded subject or rounded item is textured, like you can have a light bulb, which is a really great surface, even though it's rounded, it's still smooth.
Okay, so smooth more than anything.
Exactly. And dirt, if there's grime or dirt on a surface, that can impede leaving that residue.
So, and just now I'm going to refer back to the report. Item number I2, where there was some friction ridge detail that was suitable for analysis, where was that print from?
The latent lift card was marked outside front driver window.
And you weren't present taking these prints from the vehicle, correct?
No, I was not.
So you're relying on what the card says to make this chart?
Yes, it's in quotations, which means I took it directly off of. The lift comes on the front of the index card, and then on the back is where the agency will write case number, date, item description. Sometimes we get a little picture of what it looks like. Mostly it's the case number and then some type of written description as to where they took it from.
And then I'm just turning to page 2. After you determine something is suitable for analysis, what do you do next?
So once I've decided that I'm going to take it to the next step, which is comparison, I will look to see if known standards have been submitted. And a known standard is nothing more than an intentional reproduction of the friction ridge skin on your fingers or your palm or the bottom of your feet. So it's actually either, well, it used to be ink, but they don't ink anymore. They use a computer system that captures your ridge detail and then turns it into a fingerprint card, a black and white fingerprint card. So I look to see if standards have been submitted. And if they have, I'll do the comparison between the questioned impression and the known standard.
Were standards submitted in this case?
Yes, they were.
And what standards were submitted in this case?
So you'll see that in the second chart down. It says that the suitable friction ridge detail was compared to the following submitted and obtained. So the submitted are the ones with the item numbers, item J, K1, and K2. And then the SID number is a fingerprint card that I got out of our automated fingerprint identification system.
So you had, just just in plain language, standards from Betty A. Hannell and Timothy Luther Olson for this case. Is that correct?
That is correct.
Okay, so then we were talking about you look to see if you have standards. Then what do you do in your process?
So then just like the latent lift got scanned, the standards get scanned if they're submitted, and then they get pulled up on my large monitor, and I start looking for those minutia points in the question. So I pick out 2 or 3 points in the questioned impression, and I look for their unit relationship to each other, and then I go over to the known standard, and I go finger by finger all the way across, trying to locate that same target group. Once I find the target group, I can expand the search and keep searching until I feel I've made a conclusion, and that conclusion would either be identification, exclusion, or no identification, no exclusion, because I need a better card.
In this case, were you able to make any conclusions?
Yes, I did.
And what conclusions did you make?
You will see that in the bottom chart. It is an identification. So FRD I2, FRD 1, I identified to the right ring finger of Timothy Luther Olson.
And could you go through the process that you did specifically for this case to make that identification?
So like I said, I will have taken the questioned impression, and using Photoshop, we mark it with green, yellow, or red dots, and I'm marking where those minutia points are on screen. And so then the questioned impression gets marked up, so then I can see my target group, and then I pull them up side by side, and then I try to locate a target group on the known standard. If I don't find the target group, I go to the next finger, and I do that through all the fingers. If I find something that looks like my target group, like I said, then I can go ahead and continue that comparison. If I find enough data that supports an identification, that's what goes in my notes, and then it gets verified by another qualified examiner.
Is there a minimum amount of points or data that you have to have in order to make a conclusion?
Not in the United States, no.
For you, is just 1 data point enough to make a conclusion?
I would really have to see the latent print.
So it can depend. It might be enough. Why would it be enough if it was just 1 data point?
There are, like I said, some of those ridges can stop abruptly. Sometimes they split into 2. If I ever saw a ridge that split into 5, that would be almost unheard of. So there are certain minutia points that are more regular on everybody's fingerprints. So an ending ridge or a bifurcation, meaning a ridge that's running along and then just splits into 2, is a pretty common minutia point. Then you start getting into dots and islands and trifurcations, and they do all different things, and they have a rarity to them.
Do you remember how many data points you had for this case?
No, I don't.
No. But you were able to make the positive identification?
Yes.
And then was this report verified by one of your colleagues?
The identification was verified, and then the report is tech reviewed and administratively reviewed.
Is that information indicated on this report?
The verification is not. The tech review and the admin review is.
Your Honor, I'd like to object to this questioning. I've never denied being with
Mr. Olson,
Betty.
Mr. Olson, you have an objection,
Right.
and that was to the answer and not to the question? Is that?
Just to the entire line
I
of
don't need
questioning.
explanation. I'm just asking you, was it, to the entire line of
Just to
questioning?
the entire line of
Okay,
questioning.
all right. State, I don't need a response for this really, but if you want to put something on the record, you can.
That's okay.
Okay, objection overruled. Please continue.
Thank you. So all of this was tech reviewed. That's correct?
That's correct.
I have no further questions. Thank you.
Okay, Cross,
No, I have no further question. I've never denied being with Betty or in the car.
Mr. Olson. Okay. Thank you. Ms.
Thank
Duffy,
you.
you may step down. Okay, State, please call your next witness.
Yes, the state calls Janice Molly.
Malley. My first name is spelled Janice. Last name is spelled Mally.
Thank you. Ms. Malley, how are you employed?
I'm employed as a DNA analyst at the Wisconsin State Crime Laboratory located here in Milwaukee.
And how long have you been employed as such?
I have been employed at the laboratory since May of 1990, which is longer than we've been doing DNA testing.
What did you do before you did DNA testing?
Prior to DNA testing, I performed serology testing, which involved ABO and enzyme typing on blood and semen stains.
What type of training do you have to become a DNA analyst?
As far as my educational background, I have a Bachelor of Science degree in medical technology, which I obtained from Marquette University. I have also completed additional college level coursework in genetics and molecular biology at the University of Wisconsin Milwaukee campus. And then throughout the years, I've received on-the-job training at the laboratory to qualify me as a DNA analyst.
Because when you graduated from college, DNA analyst wasn't a thing, is that correct?
Correct. I started off as a forensic serologist, and then as technology evolved, the laboratory started doing DNA in the mid-90s. We started off doing one RFLP DNA analysis, and then in the 2000s, we transitioned to performing STR DNA analysis, which is what we're currently doing.
Thank you. And just so we're all on the same page, what is DNA?
DNA is an acronym. It stands for deoxyribonucleic acid. Basically, DNA is found in all cells throughout the body that have a nucleus or central core portion of the cell. The DNA codes all the information that is necessary to make you who you are, and half of your DNA is from your mother and half comes from your father.
And when we say DNA analysis, what actually are we doing?
We do STR DNA analysis. STR stands for short tandem repeat, which is descriptive of the locations that we look at when we do our testing. We look at regions in the DNA that are characterized by short sequences of DNA that randomly repeat themselves. We look at a total of 23 regions when we do our testing. And each person can express one or two types at each location that we look at, depending on whether or not they receive the same type or different types from their parents.
And in a criminal investigation, why would we do DNA testing?
We do DNA testing. The SCR DNA testing is used to discriminate DNA between individuals. Identical siblings will share DNA profiles, but any other individuals would have different DNA profiles.
Thank you. And then do you remember doing analysis with the case name Betty Hannell?
Yes.
I'd ask that the deputy bring up exhibit number 118.
All those right now.
118. Does that report look familiar to you?
Yes.
Yes. Why?
This is a copy of the report that I issued for crime laboratory case number R23-450 on July 19th of 2023. It has my signature on it.
And how many pages is it?
The report is 5 pages long.
Thank you. I'd ask that exhibit 118 be moved into evidence.
Any objection?
No, Your Honor.
Received.
And Your Honor, may I give an exact copy of the exhibit to the witness for ease of testimony?
Yes.
Thank you. Yeah. Permission to publish?
Yes, you may.
Thank you. Ms. Malley, I just want to walk through this report kind of piece by piece. I'm showing you the top of page 1. Could you tell us about the information at the top of page 1?
The information on the top of the report includes the date the report was issued, the case number that the report was issued for, the report number, the agency case number, as well as the submitting agency address, and then my name as the analyst who worked the case. There is an initial and date stamp just below my signature, which is that of the analyst who performed the technical review on the case prior to it being finalized, as well as a signature of the designee DNA supervisor who did the admin review on the case.
Thank you. And I'm going to go to the lower half of this page. What information is on this lower half of this page?
The very first section is just a listing of the items that were examined in the DNA analysis unit of the laboratory. The table underneath the screening heading describes what items were prepared for analysis and what the associated sub-designation number is of each item.
And why do you associate item numbers with objects?
When the case is first brought out to the laboratory, it is assigned a laboratory case number, which is the R23-450, and then each item within the case would be assigned a letter designation as it comes in.
Do you recall getting these items from the Franklin Police Department?
Well, I was not the person who received the items. They were received at the front desk by our evidence intake people, and then they would issue a receipt to the submitting agency.
And then so how do you end up receiving the items?
The evidence TAC would store the evidence in a locked location within our unit, and then the analyst who actually examines the evidence would take custody of the evidence. I was not the analyst who screened the evidence. That was done by another analyst. I did the data analysis and interpretation for the case.
So let's keep moving through the report. We talked about the middle part here. What is the box and the columns right below that?
That table just has a listing of the samples that were prepared for DNA, the item that it was taken from, and then the cutting itself is given a sub-designation.
And what items were prepared for a sample?
The swabbing was taken from the interior of the hat. The hat was item A. The swabbing was sub-designated as item A1. Swabs from the lip of an orange mango bottle were cut for analysis and sub-designated as item D1. Swabs from the lip of a milk bottle were prepared for analysis and sub-designated as item E1. Swabs from a toilet seat were prepared for analysis and sub-designated as item H1. And then the buccal swab standards were prepared for analysis and sub-designated as item F1, G1, and L1.
Your Honor, I'd also like to object to this line of questioning as it's repetitive. Mr. Olson's already claimed you, Ms. Hannell.
Mr. Olson, I heard your objection. You don't need to go into any more detail than that. State?
I would like to keep continuing.
Okay, objection is overruled. Please continue.
Thank you. What is a buccal swab?
Buccal swab is it looks like a Q-tip, and basically it is used to swab the inside cheek area of a person.
And why is that done?
That would be the reference profile, so we can develop a reference DNA profile from that person.
Thank you. And then I turned to page 2, the top of page 2. Could you tell us what that is? There's a table at the very top that summarizes once the samples are prepared for
DNA analysis, they would be extracted and then quanted. And this quanted is to determine how much DNA is present within the sample to see if we have enough DNA present to go on and do the further testing. So this table is a summary of the quant results that were obtained. So there's 3 columns on there, well, actually 4 columns. One column contains the listing of the samples. The second column, entitled human DNA, will state if the DNA was detected, and it will say present. For A1, D1, E1, it says present. For H1, it's present limited, meaning that there was DNA was detected, but it was of so low of quantity that there wasn't not a sufficient amount to go on. There is also a column entitled male DNA, our quant kit. It tells us whether or not any male DNA is present. And so it would either say present or not detected. Or in the case of standards, we don't quant the standards, so they are listed as being not applicable. And then the further testing columns indicates if the sample went on for STR testing.
And then the column below, it talks about autosomal and STNR DNA results and conclusions. Could you talk about that?
This section is a summary of the DNA testing results. So for the standards, obviously we have obtained single source profiles, which is what you would expect to obtain from a reference sample. And then this section of the report then also goes on and lists the typing results obtained from the evidentiary samples as well.
When we talk about a single source profile, what is that?
A single source profile means that the DNA profile is consistent with just having come from just one person. So when you look at the profile, you would expect to see no more than 2 types at each genetic location tested, and those types should be in relatively, they should be well balanced, so equal in peak height.
And so for those buccal swab standards, that's what you found in this case?
Yes.
Let's talk about now the swabbing from interior of the hat, item A1. Could you talk about that?
I obtained a single source male profile from the swabbing taken from the hat. And of course, the profile was then compared to the reference profiles from each of the 3 individuals. Betty A. Hannell and Brian M. Schuster were excluded as being a contributor to that profile. The profile was found to be consistent with the profile developed from the standard from Timothy Olson. And whenever we have, which indicates he's included as a possible source, and whenever we report out an inclusion, we also report out a statistic to lend weight to that conclusion. So the statistic we calculate for single source profiles would be what's called a random match probability. So for this particular profile, the probability of randomly selecting the observed DNA profile from a population of unrelated individuals is not more frequent than 1 in 1 quadrillion.
Does that ratio ever change?
Well, that random match probability is the statistic for that particular profile. I think you might be confusing a random match probability statistic with a likelihood ratio statistic.
Perhaps, or for example, if the DNA profile wasn't a single source and it was something else, could you talk about that?
If the DNA profile was not a single source profile, we would not be reporting out a random match probability statistic. If it were a mixture profile, then we would be reporting out a likelihood ratio statistic.
Again, I'd like to object to this line of questioning. It's repetitive. Mr. Olson's already claimed to know
Mr.
both
Olson, you don't
Mr.
have to go into
Schuster and
detail explaining your objection, and I've already ruled. Once the court makes a decision, you have to accept that. We move on. Your objection was already overruled. Continue, please state.
Thank you. So single source profile is the top with the hat, and then we were talking about likelihood ratios. What else is, when you do a likelihood ratio, is that a different type of testing?
It's the same type of, it's all STR DNA testing. It's a different form of statistic. So if for mixture profiles, we would be reporting on a likelihood ratio statistic.
Thank you. Did you also have mixture profiles in this case?
I did.
And in fact, is that the next box down?
Yes.
Yes. Could you talk about that, please?
The next item is the swabs from the lip of the orange mango bottle, item D1. That profile was a 2-person mixture. There was at least 1 male present. And then, as I said, for mixture profiles, we calculate a likelihood ratio. Basically, a likelihood ratio is a ratio of 2 probabilities. The probabilities of observing the evidentiary profile under given two different explanations for that profile. One explanation would be that the DNA profile originates from the person of interest and 1 unknown person. The second explanation would be that the person of interest is not included as a contributor and it comes from 2 unknown people. So the likelihood ratio is a ratio between those probabilities. The value of the likelihood ratio can range anywhere from 0 on up to infinity. A value of 1 would indicate equal support for either of those explanations. Values greater than 1 would indicate support for the first explanation, the explanation in which the person of interest is included as a possible contributor. Values less than 1 would indicate support for the second explanation, the explanation in which the person of interest is not present in the mixture.
Were you able to make any conclusions regarding this mixture profile?
Yes, when the mixture profile was compared to the Betty Hannell, likelihood ratio of 1.0 times 10 to the 8th was obtained. So it is at least 100 million times more likely to observe this DNA profile if it is a mixture resulting from H1 than if it is a mixture resulting from H2. The conclusion from that value is that it's very strong support for inclusion. When it was compared to the profile of Timothy L. Olson, a likelihood ratio of greater than 1.00 times 10 to the 15th was obtained. So it is at least 1 quadrillion times more likely to observe the DNA profile if it's a mixture resulting from H1 than if it's a mixture resulting from H2, which again is very strong support for inclusion. When that mixture profile was compared to the standard from Brian M. Schuster, I obtained a likelihood ratio value of 0, which indicates that it's not possible to observe that DNA profile if there's DNA present from him.
So in kind of more plain terms, there's a very strong support for inclusion for the DNA of both Betty Hanel and Timothy Olson on the lip of that bottle?
Yes.
Okay. Just wanted to make sure that I was following you because I know that that's a lot of information. Right below that box, there's some language down here. Could you tell us about if we're transitioning to something else?
Yes, the underneath that table, there's a bold header for the next item, and that's the swabs from the lip of the milk bottle item, which is item E1.
And then I'm turning to page 3 of 5.
Yes, again, this is a table that has the likelihood ratio values listed when the comparisons were made to each of the 3 individuals. A value of greater than 1 times 10 to the 15th was obtained for both the standard from Betty Hanel and the standard from Timothy L. Olson, which again indicates very strong support for inclusion of both individuals. And a likelihood ratio of 0 was obtained when Brian M. Schuster was compared to the mixture profile.
Did you do analysis on any other items for this case?
No.
No. And then pages 4 and 5, what type of information does that contain?
Pages 4 and 5 is a technical appendix that offers further explanation regarding statements that you can find in the report.
No conclusions or analysis in those pages?
Correct.
Thank you. I have no further questions.
Cross?
No questions, Your Honor.
All right, thank you, ma'am. You may step down.
Thank you. Thank you.
All right, State, please call your next witness.
The state has no further witnesses, Your Honor.
State rest subject to rebuttal.
State rest subject to rebuttal.
All right, thank you. Members of the jury, I'm going to release you for a break. Plan for Do you intend to call anyone?
So again, I gave a list to Attorney Wazalewski, and he said he was going to subpoena witnesses, and there was no final pretrial. He never did anything on my behalf, so there was no subpoenas out. I mean, the only ones now that I would like to subpoena or question as my witness is also Betty Hanel, and I wanted to recall Michael S4. The reason, and one of the reasons I think I should be allowed to. Can I finish?
No, you cannot. I just want to know how many, the number of witnesses. So that would have been 2, and subpoenas did not go out. What about your own testimony? Do you want to testify?
No, I do.
Just wants to know if you would as any other witness, and then you have to answer, at the beginning, give a narration, or you would. Yeah. Good news is you get to tell your story. Bad news is questions about all the things that you. So, we're right.
So the judge, Jonathan, made him have counsel next to him for this exact reason, just in case he did have any questions. But he's not allowed to help unless asked.
Jury instruction, yeah.
So he doesn't file motions, he files the motions himself, which is surprising.
I mean, how is that going to help you? That's what the judge is.
Okay, great. Thank you. Thank you so much.
Yes. Yes. instructions and then after I testify unless you have other witnesses to call, which I don't see. Pressed and I don't know what you do. Every kind of observation you do. So evidence is closed. The judge will give instructions and the judge. Yes. We're going to have a meeting about the jury instructions, and they're going to have readings that the judges can't read. 5 counts, 4 different charges. The 2 hours. I don't know how long you're going to take. That's entirely. I don't know that either. Send your message. Are we off
We're still on the record. I'm waiting for an answer.
Your Honor, I believe Mr. Olson is leaning towards testifying. He has raised 2 questions with me. One is if he would be allowed some time to prepare. I'm not sure what he proposes to do in any time allowed to prepare, but he's asking for it. The second issue he raised is, would he be then testifying in a narrative form? Would I be directing him? Would someone else be directing him? I just, he wants to know how it would work as a practical matter.
Okay. I don't know what time he's requesting and what exactly he intends to use that time for. So there's that. Okay, what is it? Yes, that's
just to prepare to respond to any questions to all to the charges, to each one. There's a lot involved here, and so one of the reasons is a lot of the documents that I have been rustled around back and forth and are all in disarray. So I have to collect myself, and I just want to get together and go over everything so I can have in my head ready for any questions that are answered to me from the state. And then also, am I going to be just telling my own story?
I'll get to the format in just a minute. How much time? Yeah, sure. I'll get to the format in just a minute. How much time are you asking for?
I mean,
it's already already 2 p.m.
So, I mean, honestly, I would need at least an hour to prepare myself for both. I mean, just one maybe, but for both, for sure, an hour. I mean, the state, and then whether Attorney Wasilewski is going to be, asking me my story or however that's going to work.
All right. So you're asking for an hour break, effectively, and with respect to the format, you may testify in the narrative form. However, though, it's not free range to say whatever you want. The court's orders on what's limited remains the full force and effect. As you may recall, I ordered that not just you, but anyone, not talk about judicial misconduct, attorney misconduct, any other grievances that you believe you have against anyone. That's not relevant and cannot be brought in. In addition to that, I reminded you, as well as the jury when we did voir dire, as well as the preliminary instructions, what those charges are. If what you want to say relates to or is relevant to those charges, the 5 charges that have been filed against you, then you may do so with respect to the relevant time period. Okay, we've heard a great deal of what that relevant time period is. I would expect that you'll stay within that relevant time period. But now I'm saying all of this relative to the format with the understanding or assumption that you follow what I'm saying and you understand that there are boundaries you cannot cross. If you try to cross those boundaries and violate the court's orders limiting what you can and cannot say, I will cut you off and I will no longer allow the narrative format. So I think we could proceed. It's probably easiest to proceed in narrative format, but with those rules in place. Does that make sense?
I mean, I object to the.
Let me ask you differently then. Are you willing to comply with those rules if the court allows you to testify in the narrative format?
I mean, I'm not trying to be argumentative, but I have the right to testify if I so choose so. But I mean,
it's a yes or no. If you're willing to comply and you will comply with the court's rules, then I will allow you to testify in the narrative format. If you choose to testify, if you find and if you believe, you don't have to answer me, but if you believe that it'll be challenging for you to do so, then the best course for me is to not allow the narrative format.
No, that's not what I'm saying. I'm going to do the best of my ability to say what I have to say without causing any issues in the court.
You can say what you want to say within the boundaries the court has set in its rules. Are you willing to do that?
I mean, yes, as far as I know, I don't think I need to go through any boundaries that you're referring to. I mean,
okay, so with respect to your decision to testify or not testify, what is it?
So just so I'm clear, when I'll just be narrating myself what happened, and there will be nobody directing questions at all. I'll just be narrating what happened per each case, each charge, and then when I am being questioned by the state, I need to know, is Attorney Wazalewski allowed to object on my behalf?
No, he does not represent you. He is standby counsel. The only time that he's able to, in a sense, actively participate is if you are removed from the courtroom and he reads your questions to the witnesses.
So I thought that anytime I wanted, that if I wasn't able to continue, he could step in. That's why you appointed him on as standby. Is that correct? No?
Your understanding is wrong. What you can do, and I understand your question, is that during examination, if you believe a question is improper, you can simply, before answering, indicate that you object and indicate very succinctly and in a short fashion the basis for that objection. And then I will make a ruling. So while you sit there as a witness, if you believe a question is improper, you may object, provide your short basis, let the state respond, and then I'll rule.
Okay.
Do you want some time to think about your decision before you tell me what your decision is? I can, okay, just answer yes or no. And then
just give me, I need to be clear on everything.
So
I'm
let's
going
go
over
off the record,
things right
and
now.
it's 2:08 right now. Let's plan on coming back, let's say maybe 5 minutes. Would that be enough time?
Sure. And is it okay if I stay here and go over these things with?
My intention is to leave the courtroom so that you can talk with standby counsel.
Okay.
If you prefer, they can this morning. Yes. And the third motion is the state's motion. Okay.
If it's that, move to dismiss for lack of evidence.
Your Honor, I also have a motion.
Okay. Sure. So let me make sure. The first motion, if any, motion or motions, if any, I'm inquiring, is at the close of state's case in chief. The other motion is defendant's motion that he's since filed, and that was from this morning. And then state, you have another motion?
Yes, Your Honor, I did file an amended information this morning because count 2, it was the wrong address in the amended information I filed earlier this week. I saw your jury instructions have the correct address. The original information had the correct address. So I think now after the testimony of the witnesses, the information should be conformed to the evidence 971.29. So that address in the information I filed is the address of Walgreens, which is the count that the state is going to ask the jury to convict. And it was the information we were all working on for the entire trial.
Okay. That's your motion.
Yes,
I'll circle back to you, but one thing at a time. All right. Mr. Olson, you indicated that you do have a motion at the close of state's case in chief. What is that motion?
I'm sorry, I didn't hear you, Your Honor.
Okay. There are 3 motions. Well, possibly 3. 1, I'm inquiring if there are any motions at the close of state's case in chief. The second motion is your motion you filed this morning. Yes. And the third motion is the state's motion, okay, which Idiot Sadowski just placed on the record, but I'm going to circle back, okay? That's why I did not turn to you for your response. So as to any motions at the close of state's case in chief.
Yes, so I want to motion the court to dismiss for lack of evidence. What was it? So there's lack of evidence for all 5 counts, but there's in each specific count there's more detailed reasons for the motions. Do you want me to go into each one right now?
Sure. Yes.
Okay. Just give me one. Can you give me 1 second? We were just going over that right now. So. Okay, number 1 for the age enhancement. Witnesses never gave their age as far as any enhancements.
Count 4 and count 5.
1, 2, 3, 4, 5. All right, so 4 and 5 were released with intent, correct? Okay, I just want to make sure it's correct on my sheet here. And then on obstructing an officer, they never proved lack of evidence, insufficiency of the evidence that there was any obstruction of anyone. As far as, where's this page? And the state clearly didn't meet their burden of proof with regarding count number 1, that the alleged victim was confined forcibly or secretly confined with the intent. There was no proof of intent ever. No proof that she was confined or held against her will forcibly. I mean, there was too many times that this that she could have just drove off. I mean, this isn't this we were together, so this isn't the state did not prove their case. It's complete insufficiency of the evidence, including the victim perjuring herself and anything else. Okay, all right, and then for count, which one was the one? Garage? The garage? Oh, okay. So since so for count 2, there's insufficiency of the evidence because we were together and I used the card in her presence with her permission numerous times while we were together. I believe there was even a store we went in together. So there's definitely no proof of using it without anyone's consent. I want to take a look at this page really quickly. There's no proof that I acted without authorization.
Is that it?
Oh, just a second, I'm just reading this really quickly around. I'm trying to go over this as fast as possible.
For the record, he's reviewing jury instructions.
Yes, so I actually bought some items for Betty at her request. Just there's no intent here whatsoever. And the proof here is actually that some of the times, like Walgreens, I was in there 20 to 30 minutes. And
Mr. Olson, it's sufficiency of the evidence.
Okay.
We're not testified.
All right.
Okay, this is at the close of
All right.
state's case in chief.
okay, there's no proof then on intent. And like I said, since we were together, they couldn't prove the first count number 1 because we were together. That I used it in her presence. I used the cards in her presence and at her request and with her permission. So I'm requesting that would be dismissed also on insufficiency of the evidence. And count number 4, is it number 4? 4 is the garage burglary. Are you sure?
Yes.
Yeah.
That's the garage burglary. Count 4 is the garage burglary.
Okay, let me see. Where's your, let me see that right there so I can just keep. Okay, so in this count number 4, this is the garage. Regarding the garage, I have a 6th Amendment right, according to Article 3, also to face the injured party. And since the injured party was not here, I believe that charge should be, that one's a no-brainer. That one should be dismissed for insufficiency of the evidence and unable to face my accuser. I don't have any case laws on that, but that one's pretty simply dismissed. Was not able to question and face my accuser, and the right to face the injured party is in Article 3 and 6th Amendment, U.S. Constitution.
Thank you. State your response.
Yeah,
And any motions.
yes. Please let me know if I missed anything because it was a little bit hard to follow. For count 1, I think that in the light most favorable to the state has met its burden. Count 1, especially, there is no, a person is not confined or restrained if she knew she could have avoided it by taking reasonable action, and a reasonable opportunity to escape does not change confinement or restraint. Betty testified that she was basically held at gunpoint and was terrified to get out of the car. Additionally, regarding secretly confined, Mr. Olson went into several establishments, but yet when Betty had to use the restroom, he made her use the restroom in an alley. He was hiding her. He wasn't letting her go. So I think in the light most favorable to the state, that is adequate. The count 2, there's no testimony regarding any sort of permission given by Betty for Mr. Olson to use the card. I don't think there was any issues regarding count 3 that were brought up. Counts 4 and 5. The issue, I believe, that is count 4. Christine Endall stated she was taking care of the house for her disabled brother, and that she testified that no one had permission to take anything out of the house. She testified that her brother was in the hospital and that she was a caretaker for the house. I think that is constructive possession. She is still the injured party. Jan Endall is now deceased, and that is now was her residence for a time as well. And regarding counts 4 and 5, the age enhancer, that isn't included in the jury instructions, and I believe that's a penalty enhancer. So the state would argue that that's a question for sentencing, but it is a newer enhancer, and there's no annotations. But if I'm incorrect on that, then I understand that those enhancements can be dismissed, because I agree that the witnesses did not state their ages.
All right. With respect to defense's motion for dismissal for lack of sufficiency of evidence at the close of state's case in chief, first I'll start with what I think effectively the parties are in agreement with, which is that there was no testimony relative to ages for the purpose of the penalty enhancer. While by operation, hence the name enhancer, it does enhance at sentencing with the exposure of incarceration, but nonetheless, there has to be a factual finding or evidence that in fact those alleged victims are elderly persons. And I gave a draft of the jury instructions, which I think we'll finalize. But my reading of it is that that's still a factual finding, although the result of that is it goes towards the exposure of that the defendant may have relative to imprisonment. And so the answers are dismissed. Okay, defense's request and the answers are granted, and they are dismissed. With respect to count 1, 2, and 3, 4, and 5, I'm in agreement with the state as to the evidence that's come in so far. Certainly, there is sufficient evidence here to continue the case and send it to the jury. And so I find that the state at this point of this trial has met the burden. There is sufficient evidence to continue the trial. That's the decision of the court. Now, moving on to Mr. Olson, and we could do this differently. I can address state's motion because I think that one's probably a little shorter. So why don't we do that? Because Mr. Olson, your motion is a little lengthier. Your motion from this morning.
Okay, real quick. So the motion from this morning, there were also pictures that were supposed to be added from the jail. I asked.
Okay, hold on. I'm going to put your motion last because it's probably going to take the longest. Okay, that implies that you're going to get more time. That's what you would want, correct?
Sure.
Okay, so then let's address state's motion. State, as to your motion.
Yeah, that was a motion under 971.29 to conform the evidence to that at trial, specifically related to count 2. It was just the address is changing. I did friends with the copy this morning, and then I filed it as well. So I just asked that count 2, the address be conformed to the evidence in trial.
Okay, Mr. Clerk, is it pulled in now?
And if I may just clarify from my own understanding so I don't misexplain it to Mr. Olson, the only change is the 4 address digits before West Rawson in the charging portion. Is that correct?
And it changes it to the city of Milwaukee.
Oh, okay. So
I don't have the amended information. Okay, I see it now. It's pulled up. Count 2 now reads relative to the address 3233 West Rawson Avenue, Wisconsin, in the city of Milwaukee, Milwaukee County, Wisconsin. Is that correct, state?
Sure.
No, I'm sorry. That it should be.
Yeah.
No, hold on, Mr. Olson.
No, I'm sorry. It should be 3233 South 27th Street.
Okay.
So I'd ask to orally amend that, please.
3233 South 27th Street.
Oh.
In the city of Milwaukee, Milwaukee County, Wisconsin.
Yes.
Your Honor?
Yes.
May I, so I'm requesting that this. Wait a minute.
she's saying. Oh, she's changing it. 3233 South. The correction is to 3233 South 27th Street.
Correct.
And the city is Milwaukee and not Franklin.
Correct.
So I believe this, does this change? I'd like to challenge the jurisdiction if they're changing from Milwaukee to Franklin to.
Whose jurisdiction? The court's jurisdiction? Mr. Olson, answer the court. Whose jurisdiction are you challenging? I am not sure I understand.
Well, I was under the impression that it was changing cities. So I was challenging the personal jurisdiction. It's from one city to the next.
Okay, well, I'm not persuaded by that because you are in Milwaukee County, and that's the extent of this court's jurisdiction. Okay, so with respect to count 2, the address is as stated by the state and shall be reflected as such for all purposes of the jury instruction, the charge offense, the location in the charged offense and whatnot, and it's orally amended. Okay, so that takes care of that. Now, arriving at Mr. Olson's motion, let's go off the record because given what you just stated, Mr. Olson, I want to make sure that what was scanned in and what was provided. So what we have is the scanned documents in a disk, which the state did not need to look at because your representation is that that is, I'm sorry, what was that disk again?
The disk is a recorded jail call between myself and a private investigator, Thomas Fisher.
Right. Okay. Yeah. So given your representation, the state did not need to see that disk.
And
I will have I'll take that right now. And then you said there's additional support.
Yeah, there's pictures taken by Sergeant Wilburn. He suggested I take because of the severity of my wounds and having to go to trial with those wounds. He suggested I take these pictures for my own evidence. And he has those on, I believe, a jail file or some type of video
so
camera.
Let me ask you the question. These pictures that were taken to support your motion for, I think your biggest request is for mistrial, but in support of what you're asking of the court, these pictures were taken this week, correct? When trial started?
Yes.
Okay, no, stop.
5/11.
No, I have
Sorry.
I have a process to all of this, and this is why I'm asking you directed questions. All right, so are there any other pictures, and I understood you to indicate that there are only pictures, any other pictures other than those from this week, whether they were taken in the jail or somewhere else, other than this week when I have had face-to-face time with you in court that you feel and you believe should be part of your motion?
As I don't know if Frater took any pictures, but I know they took CAT scans of the new wound on my.
Okay, Mr. Olson, but that all happened from Monday, okay?
Okay.
From Monday to today, correct? So from March 9th to March 13th are all these pictures that you want to make sure it's part of the record and support your motion?
Yes, those.
Okay,
Those are
so
the
then
ones.
for my determination or deciding of the motion, it is not entirely necessary for me to see those photos, although at one point, for purposes of appeal, it should be made part of your motion. But I don't need to see those pictures because you've been in my court every day this week, and I've seen you, and I've seen during the start of this trial that you had a head injury. I also seen the progression of that injury. And given my visual of you this entire week, I don't believe those pictures for my purpose is necessary, but for purposes of appeal and ensuring that the record is complete, yes, those can be filed. However, though, when you make reference to your injuries in support of your motion, clearly articulate that and indicate so, and then I will allow you an opportunity to add those pictures to the file, to your filing, so that way you don't delay us any further.
Okay, so how do I add those in then?
Later on, you can provide those pictures. First, show the state, provide those pictures to Mr. Clerk, and we'll file it and make it part of your motion. But I mean, it's been the same ADA. I've been the judge who presided over this trial this entire week. We've all seen you. So if you want to talk about your injuries and what you look like, I think everyone has seen that.
Okay, I just wanted to make sure it was in for.
No,
for
I
anyone
want to make
else,
it very
yeah.
clear. It is not my responsibility, and it is not Mr.
No,
Clerk's
I never
responsibility.
said that. Sorry.
It is not Mr. Clerk's responsibility to say, hey, Mr. Olson, make sure you get those pictures in. Hey, Mr. Olson, where are those pictures? Hey, Mr. Olson,
never
are
said
they
that.
5 pictures or 10 pictures?
I
I just want to
never
make
said
sure that you understand that it is not the court's responsibility for you to make sure that those pictures are filed. But in making sure that we can move this along, I will nonetheless allow you to make reference to pictures, okay?
Really quick, Your Honor, I just wanted to object to the you dismissing number 4 in that I didn't get to respond to her response about Christine Endall being a caretaker. I questioned her once and asked if she was the owner or the
Olson,
injured party.
this is not back and forth, okay?
I can tell.
I've already ruled.
Oh my God.
Do we have the laptop set up in the back for remote viewing? Okay, because you're about to be removed, okay? This is your last straw. The bullpen is now set up for you to view the rest of the trial on Zoom. I made a decision. You don't like it, but you still have to move on. You can appeal it. All right, now we're losing time. Mr. Olson, as to your motion, I've read it. Now, while I read your written motion, I think 7 pages, I did not go through the supporting documents. And so, as is the practice, I will allow you to place on the record as succinctly and briefly as you can, because I already read your motion, the basis for your motion and support thereof. So go ahead.
I have to get the documents together really quick, Your Honor. Like I said, they were all disheveled, coming back and forth. Oh, you got them right there. Yes, I agree. Yeah, sort of. They're all. This is a disaster. Just bear with me for a moment, Your Honor. I have to just get them in order. They're all here.
Attired in jailhouse clothes rather than civilian or street clothes, which involves also your the medical emergency that you created, in which the deputies had to take you down to see a nurse as quickly as possible, whereby in doing so, at least one, if not several jurors saw you in your jailhouse clothes. Did I get that correct?
Yes, Your Honor.
Okay. Anything else you want to elaborate, given that summary? So I know that you're asking for mistrial, and you provided those bases, and I've summarized those bases.
Well, that's just part of it, right?
Okay, so what else am I missing?
So just look, I'm almost done. Can I just gather all of them so I can go through it?
I'm going to give you a few more minutes, but you were so adamant on this motion being heard by the court. And now that you've been given an opportunity, and by the way, this was from yesterday, you were so adamant that you'd be heard on your motions. And I told you more than once that you are to prepare your motion. And this is one of the main reasons why I had you put it in writing. Because if you didn't do that, your thoughts would be all over the place and you'll be talking for hours on the record. And yet, now that you have the opportunity, you're still not prepared to move on your motions.
I am prepared. I had to have a copy. So when I gave you my original, the copies that I was given are all completely out of order. So I'm just trying to get one of the copies together so I can go through it. I just got it from the law library officer copy this morning.
Okay.
So I had.
We're going to go off the record. I'm going to give you 5 minutes to collect your thoughts and put your motion in a fashion or order that you understand. When we come back on, I'm going to give you an opportunity to make.
Okay. So you had brought up the grounds. There's I believe 31 grounds that I brought up that have arisen before and during trial. I believe that these are egregious constitutional violations that surpass being committed with malice. I have not been allowed to speak, not only during trial but before, or object, put things on the record. Your deputies were texting about my case in front of me, talking about texting in front of my case during the trial. I think that is automatic mistrial. We don't know who they're talking to. They have, the ability to hear everything going on in trial, and no one is going to question them because they're police officers. So I think that is one of the main things here that is pretty alarming. And the clothes, before I was even allowed a chance to change, I was being paraded through the front, and this was before any medical emergency. And I never refused to change into my suit clothing. I was incoherent from throwing up for 40 minutes, which you could see it was all over my clothes. I could have easily been changed in court staging instead of when the medical emergency happened here in the holding cell. There was 2 medical emergencies. So I was brought through in front of the jurors numerous times, and that was before the medical emergency. I ran into jurors 4, 2, let's see. So I don't know their numbers from before, but now where they're seated, juror number 4 in the first row and juror number 2 and 3 in the second row. I don't know their actual juror numbers, and that's who I ran into in the elevator. They were coming into the elevator, and I was in the wheelchair in front of the. Sorry,
can you point out where those jurors are seated?
So first, wait a minute. In first row.
No, I have the seating chart.
In first row, 3 and 4.
Well, I'm sorry.
In the first row,
seat.
Yes, the seat. So from there, 1, 2, 3, 4, 5.
Okay.
Number 3 right here. I believe that is her. Actually, that's her. I think that was her.
Her number 3.
I
yes.
believe so. And then 4, who was actually
the seat.
7.
The 4th seat. Yeah, that's her 7.
Second row would be 2 and 3, and I don't know their
19 and 30. And you're counting from the right? So 1,
Yes.
2, 3, 4.
And
Okay, so hold on. So if it's seat number 2 and seat number 3, that would be juror 19 and juror 30. Okay.
That's the second row, just to be clear.
Yes.
Okay. And just to be clear, also, I seen juror number 3 was by herself in the hallway when we went by her, and then the other 3 that I listed were talking about the case, and you could hear them texting about, or they were talking about texting and getting Facebook notifications that it was one of their first notifications. And those 3 were together in front of the elevator. They were trying to get in the elevator, and I was in front, so they couldn't get in. So they went into the stairwell, and it was chaos. Okay. I also have here that I believe a medical emergency, the fire department should have been called from here. Instead, they weren't. No concussion protocol was followed for when I puked for 30 minutes, and that was happening in front of people. There was puke all over me. I had a concussion that caused me to be incoherent in the courtroom, and which is why I never refused to put on my current clothing. I just was kind of incoherent from the constant puking and the dizziness. Let's see. I was never given the medication that was supposed to be given to me 3 times daily for this dizziness, nausea, and vertigo, which was supposed to happen. Since the 5th through the 12th, I was only given it 3 times. It should have been given me 3 times daily. And then because of these incidents, the documented seizure, mild traumatic brain injury, as the doctor stated, and possible trouble with memory, which is stated in the documents here from the doctor, and not being able to think clearly, not being able to focus over possibly the next week, 3 days to a week. And that one happened on Friday, one happened on Monday, and these are documented in the CT scans. I was not able to completely self-represent myself, which I would have asked standby counsel to take over, but according to standby counsel, you denied to allow me to do that, which I don't know why, but I'm objecting to that now. Also, there was no pretrial, which is huge because there were numerous things I was missing, and I just wanted discovery. I didn't have discovery so that I could be prepared. I have no problem going to trial if I'm prepared and given the opportunity to prepare. I was never given all discovery since day one, especially the phone download. This has been hard, and my motions, most specifically numbered 1 through 11, which were never heard, and those were the most newest motions heard, or not, I'm sorry, the newest motions that I submitted, and those contain motions that I requested 2 motions and demand for discovery and inspection, which I listed what I couldn't access, and that someone had tampered with one of my flash drives, and requested the courts to investigate the jail for the tamperings. There were officers that were handling my discovery that shouldn't have been. One of the most important motions is motion 11, which I requested to subpoena the phone records of Betty Hannell to prove that there is a text missing. And I've been trying to subpoena these phone records since 2023, and none of my lawyers would subpoena these records either. 7 attorneys, which is why I fired them. It's not because I'm not easy to work with. I asked for one simple motion to be filed, and it's a motion template. Anyone could file it. And it's fill in the number, fill in the phone company, fill in the name, and they subpoena the phone records, and we could easily see that there's a text missing. And this was one of the most extremely important parts of my case here, because I've claimed all along that these texts existed, and I know I called the media the second day I was arrested and spoke to one of them and told them about these texts. And there are other motions throughout there which I asked for dismissal on numerous reasons. Prosecutorial misconduct was huge here. DA Sadowski completely corrupted my defense on December 23rd, and that was the 3rd PI I had tried to work with. When I called him on a recorded jail call, I was in shock that he told me that he had talked to DA Sadowski about my case off the record at an alcohol-induced party. This is all on CD, and I sent this out to the media and the U.S. Supreme Court, numerous other, and that she was going to give him a letter to come see me, and that she was going to give him my discovery, and I hadn't even hired him. I was in shock, and this right here probably put my whole trial into chaos, because I had to come by myself with no discovery, no private investigator to investigate or help me prepare anything. They were going to subpoena phone rerecords, help me.
Also, you got to wrap it up.
Okay. Well, there's a lot here. There's a lot happening. I'm going to try and get through this quicker. So there were 11 motions that were never heard. No pretrial witness list wasn't provided to me until 3/11/26 during trial, so I wasn't able to prepare for witnesses. I was never given e-file documents as requested, and Attorney Wasilewski has them readily available at any time. Brought me copies to the jail. Communications between the state and my attorneys, whoever judges, clerks. This was also very important because it would show that there was exculpatory text given to Attorney Conradi on February 14, 2024. And it would show that the email text between Attorney Bashin and Sarah Sadowski.
Minutes, and then you got to wrap it up. It's 3:08. Every time I'm cutting you off.
Standby counsel also refused to help me before and during trial, which I don't know why he was made standby counsel. You also corruptly appointed him. It should have never been done that way. The public defender's office should have been in charge of appointing my attorney. This is the second time this happened to me. Judge Childs did the same thing through Thomas Reed, giving him instructions to appoint Gary Clayhorn. Judge, let's see, and I'm not sure why the trial wasn't postponed due to my concussion and lack of discovery and everything else. Let's see. And then, so most recently, there's been more jurors going in and out through the hallways. I know that I've ran into, and then I've noticed talking about the case, because I don't think they're paying attention, but I am. And so there's now 4, 5, 6, 7, 8 jurors that are, okay, there are now 8 jurors in the front row, 2, 3, and 4, jurors 1, 2, 3, and 4 in the second row, and juror number 3 in the third row. So that's 8 jurors, not including the ones I listed before, but I believe those were already listed. I have a conflict of interest with Judge Yang, D.A. Sadowski, Attorney Wasilewski, due to 3 probably each lawsuits pending against the 3 of you. 3 are torts and 3 are 1983 lawsuits. 1 is already administrative hold. My witness list was never subpoenaed. I have not been allowed to shower or shave for trial.
Your time's up. State your response, please. I guess if this helps you, let me say this for the record, that some of the motions, and some of the motions aren't really motions, they're a basis, but for what it's worth, there are a good number of motions or a number of asks of the court that I construe as the defense's request for reconsideration of past motions or past requests of the court that have already been decided by the court. And as presently presented to the court, I don't find that Mr. Olson has presented a basis to reconsider past decisions. Insofar as it relates to defense's motion for mistrial based on new information, and that being since the start of this trial, I think that warrants a thorough response from the state. But aside from that, and I'm going to give the state an opportunity to place their response on the record, but aside from that, many of the asks, requests, and justification for those asks are from past decisions, past pending issues before the court that the court already decided. So state, with that being said, I hope that narrowed it down a little bit for you.
Yeah, that does. And so I think that, and correct me if I'm wrong, Your Honor, because what I narrowed this down to then is the allegations for mistrial of the jurors seeing Mr. Olson in the hallway. That would be one of the issues. Regarding that, one, I think we would need to ask the deputies, because it's my understanding that their process is to make sure all the jurors are in the jury room before they move Mr. Olson around. So I don't know if that happened or didn't happen. Two, Mr. Olson was in jail orange in a wheelchair during day 2 of trial. So I think the cat's out of the bag whether he was in custody or not. So even if they did see him in any sort of in custody apparel or being transported to the court, I don't think that's a basis for a mistrial, because Mr. Olson refused to change out of his jail clothes on day 2. And then for his allegations regarding not being offered and being rushed and being pushed out here, that is not true. And Your Honor can attest to that. I think you asked specifically a number of times at every break if he wanted to change. And either I think that day there was no response. He refused to engage with the court. He refused to engage with the deputies. There was no response regarding that. It is up to jail protocol to decide what sort of medical assistance Mr. Olson needs. So again, the state is at a point that is not a mistrial. Regarding individuals communicating about the case, it's being live streamed. Everyone is communicating about this case. There is no, everything, even some off the record conversations have been picked up by the hot mics, so to speak, that my colleagues have told me about. So I don't think that would be a basis of mistrial, because I have no idea why. Additionally, there's no case law saying like why this would be a mistrial. So then I circle back again to the only actual issue would potentially be the jurors. However, Mr. Olson also claims that he has
motion filings until January 7, 8 through 11, I believe it was. Didn't even arrive.
I don't know what happened there. I think the stream just went, they went, shut the fuck up and let's move on. So I don't know what happened.
Into the court filings until January 21st. So there's this, what she's talking about is just pure lies. And the rest of the if I'm to address the new things as far as per trial, I was not given any time to prepare for a trial with discovery. Even after trial started, I was even limited even more by being put in the hole. Even though I'm still GP, I have on my property, which is rare, in the hole. I don't have anything to prepare for any trial. I've never had anything to prepare for a trial. I've never been able to research anything, and because I can't research discovery that I don't have. This could have easily been solved with just giving me things.
Yeah, it's, last word. You've got 2 minutes. It's 3:18. At 3:20, I'm going to cut you off.
Okay, so as I said, all of this could have been easily solved years ago with just giving me all the discovery. Even could have been given to me in paper. All of discovery, the phone download, and the e-files. It's pretty simple. He's got my file from the public defender's office, which has things. I've asked for this. The communications, I have a right to the communications between the state. She just doesn't want to give them to me because it clearly proves really evil prosecutorial misconduct that she does not want me to see. Because then that's why I haven't been turned over. I have a constitutional right to see the e-files for sure, which is why I went pro se against my own. I did not want to go pro se. Attorney Wazalewski refused to help me. He didn't want to go to trial. He didn't want to do anything. He just, I don't know how I could have solved this whole issue here, but this could have been solved by the state, the court, whomever. Give me everything I need. 1 minute. Also, from what I was told from hospital staff, which was very odd to me, and this is all linked here. I have the injuries are not, these are diagnosed from the doctor's pictures. There were serious injuries. So I'm in the second one, the lump on my head was like this, and it spread out through my face and went down through my eyes. I was found in my clothing. They had to cut the clothing off at the hospital because I had defecated on myself and urinated on myself from a seizure, and that's how it hit my forehead. I'm assuming on a table in the room. I don't know because I don't remember. But I was also told by hospital staff that, Your Honor, and maybe a deputy also contacted the hospital in an attempt to rush me back so that I could go through trial. And this was happening numerous times throughout the day, that the deputies were called out to speak to the doctors and nurses about my medical conditions and when I was going to be back in court for trial. And
You're done, Mr. Olson. Actually, I gave you 1 extra minute. It's 3:21. Okay. Insofar as it relates to your motion for mistrial on the various grounds that you have placed on the record, starting first with final pretrial. Pursuant to Wisconsin Statute 802, the court has the authority to manage its calendar. Final pretrial is permissive, and that is a time or a milestone in the process by which the court would be apprised of what the issues are going to be at trial, and to ensure that the parties can present say it this way, that the court can, in an expeditious and orderly manner, ensure that the trial proceeds. That's the purpose, the general purpose of a final pretrial. And again, I'm reminding you that final pretrial is permissive. I have the inherent authority to manage my calendar and to move things along. But even so, as the state pointed out, pursuant to the court's scheduling order, a final pretrial was scheduled. And that scheduling order, document 108, shows that a final pretrial was scheduled for January 9, 2026 at 9 a.m., which was not held on that day because the court granted the state's request to adjourn that final pretrial. Then that final pretrial was rescheduled to January 14th. A bulk of that time on January 14th, if not the majority, if not the entire time, was taken up by you, Mr. Olson, because you had motions that you were putting before the court.
Oh.
And so that's not grounds for a mistrial. Now, as to the deputies talking about the case and texting, as I gave you by way of example, that there are things about their protocol that I don't know, and I can't expect you to know either, including how they communicate. My understanding from now having talked to the deputies about protocol, not specifically about your allegations, but just to understand protocol, that it is part of their protocol to use their electronic devices to communicate. With respect to your jail close, as you may recall, voir dire did not start until Tuesday. Monday morning, I, along with Mr. Clerk, made phone calls or sent out emails to find you clothes, civilian street clothes, should you decide to change into it. When that was secured for you, and that was provided by the State Public Defender's Office, ultimately, later on, you ended up with 2 sets of clothes, which were and still remain at your disposal. But because of your medical emergency, the deputies, of course, then had to take you to the hospital, but that's later on. So going back to Monday, we couldn't start the trial because of your head injury. And while that was all happening, I, along with Mr. Clerk, did try to make arrangements to have street clothes secured for you, and we were able to do that. The SPD was very helpful in making sure that that was available to you. Now, when we started your trial and you then engaged in your antics and had your medical emergency, because it wasn't known, it was hard for any of us to determine, one, because we're not medical professionals, but to determine if you were actually if that was a genuine medical emergency or if you were faking it. We really didn't know. Nonetheless, it didn't matter because the deputies took it seriously and they took you back to jail to be met with a nurse to ensure that your medical condition was dealt with. During a medical emergency, they had to whisk you out of here in your wheelchair. They did the best they could. And in that, during the course of that action, if jurors saw you, that was during an emergency. Your health and your condition was the most important thing, and they did the right thing by addressing that first. You put us in that position, and your safety and your medical condition was all of ours, mine and the deputies' utmost concern. With respect to running into jurors, and that being jurors 3, 7, 19, and 30, with respect to Facebook notifications, you make allegations relative to Facebook notifications. I really don't know, and receiving a notification is not the same thing as talking about the case, which the court was very clear on and has repeatedly instructed the jurors not to do. They're all deemed to have been and continue to be complying with the court's order. Aside from your allegations that perhaps some of them have received Facebook or social media notifications, is not the same thing as you providing evidence that, in fact, they've been going against the court order of discussing your case. And so, and then the other thing, relative to the jailhouse clothes, repeatedly you've been given the opportunity to change out of your jailhouse clothes and into the street clothes that were provided to you. Every day I inquire with the deputies if an opportunity has been given for you to change into your clothes, except for today. I thought that they would have done that before they brought you in, but then you needed that time to change back there, which is fine. But other than that, I always inquire with the deputies if you've had an opportunity to change into your clothes, and you remain able to do so, and you have done so since, I believe, Wednesday. So considering the arguments of the parties, considering the evidence before the court with respect to your motion for mistrial on those various grounds and basis, it's denied by the court. And thus your motion has been decided. Court's made a decision. We're going to move on.
Okay,
it's now 3:27. No, I've made a decision. We're going to move on.
I just want to object for the record.
Let's check in with the jury and see if, oh, I'm sorry. Before we check in with the jury, I still have to ask you with respect to your decision to testify or not testify. Mr. Olson?
Excuse me? Yes, Your Honor.
You do want to testify?
Yes.
Okay. So have you had enough time to think that through?
No, I haven't had any time to prepare for that. I thought I was going to have time.
No. Have you had enough time to think about whether you want to testify or not testify?
Yes.
Okay.
I went over that with Attorney Wadsworth. Yes.
And okay, so you did go over that with standby counsel.
Yes.
You understand standby counsel does not represent you. He's not counseling you, although he may provide information for your consideration, such as why the court would want to do a colloquy with you as to your right to remain silent.
Yeah. Well,
it's a yes or no. Did you have that time?
He wasn't removed in another standby.
Mr. Olson, I'm going to redirect you because you are on your last draw here, and it's now 3:29 p.m. on a Friday, and we are expected to have a snowstorm Sunday or maybe even Saturday. My question to you is, have you had enough time to think this through?
Yes, Your Honor.
And your decision is to testify, is that correct?
Yes, Your Honor.
You understand as best as you can the pros and cons of testifying and not testifying?
Yes.
Okay. Did anyone make any threats or promises? Actually, you know what? I'm sorry. I didn't swear you in. I have to swear you in and then ask you these questions. Let's have Mr. Olson sworn in. Mr. Olson?
I'm sorry, I didn't hear you. Okay. Yes.
Okay, Mr. Olson, have you had enough time to think about your decision to testify or not testify?
Yes.
Okay. And as I stated before, Attorney Wazowski does not represent you and would not be counseling you on your decision, but he is available and accessible to you for purposes of information. You understand that?
Yes.
Okay. And did you have time to then also talk to Attorney Wazowski relative to information?
I mean, I would have preferred a lot
Yes
more
or no?
time. Yeah, sort of, yes, I guess.
Okay. And what is your decision? Do you understand the pros and cons of testifying versus not testifying?
Yes.
Okay. And you understand that if you chose not to testify, your silence cannot be used against you.
Yes.
Okay. And what is your decision?
And I will testify on.
Okay. And that's it. Your decision is to testify. And you understand that there are rules relative to your testimony that you must follow. And I laid out those rules before. You understand you have to follow those rules.
Yes, Your Honor.
Okay. And if you don't follow those rules, I will stop your testimony. Do you understand that?
Sure.
Okay. And do you also understand that while you're testifying in the narrative form, if the state has an objection, you are to stop talking to allow me to rule on that objection before you proceed with your testimony. You understand that?
Yes.
Okay. Did anyone make any threats or promises to get you to make that decision?
I know.
Okay. All right. Well, then the court will find that Mr. Olson has knowingly, intelligently, and willingly made a decision to testify, understanding the pros and cons of doing so. That's
Your Honor. Oh,
yes, Mr. Olson.
So before I was going to answer yes or no, I wanted to make sure that I was going to have time to prepare because it's going to be a narrative part on my part. So I did ask you earlier if I could have some time to prepare for that. That's why I wanted to ask you before I said yes or no, whether or not I was going to have that time to prepare for the.
Okay. It's now 3:32, and I think it is important that you be given some time to do that, acknowledging that a lot of this delay is caused by you, okay? But nonetheless, it's still important for you to have that time to collect your thoughts, especially because the court is allowing you to testify in the narrative form. It is 3:32 now, and with the impending storm, there's worst case scenario, there may be a possibility that the courthouse closes on Monday. I really don't want to do this, but I might have to, and I want to, with enough advance notice to the jury, let them know that one, we might go beyond 5. I can't imagine us going any later than 6:30 at most, latest. And I absolutely do not want to rush the jury at all. If we need to, then we come back tomorrow, Saturday. And so it's already 3:30. I'm going to give you that time you're asking for. I'm going to cap that time because I think the record is clear that you've had plenty of time, Mr. Olson, to devote towards the organization and the content of your defense, including your testimony. But you haven't made the most use of that time that you've had leading up to this point. And so while I am going to give you some time, I'm not going to give you unlimited time. Okay? I'm going to set a timer for you. And I think it's realistic for me to just simply advise the jury that we'll go beyond 5 o'clock, but no later than 6:30. And there's a very good chance that we have to come back tomorrow. And we come back tomorrow, it will be 8:30 rather than 8 a.m. It is a Saturday. I don't know what people's schedules are. This is assuming that I don't have any issues with jurors. They may have things going on in their life that makes it impossible for them to report for service tomorrow. Also, all of this being said, it's subject to approval from the chief. I've been in communication with him, but I don't have approval yet. These are ideas that I have out there. Okay, so that's the plan. We're going to go off the record so you can have your 15 minutes.
Your Honor, and that's why before I agreed to testify, I wanted to say I need at least an hour. This is I have to go over all 5 of these charges and prepare a narrative testimony.
Okay, for purposes of the record, state anything you want to place on the record.
I object. He's been here sitting, listening to all of the testimony, just like everybody else. Trials move. If he wanted to testify, he should have been preparing for the entire week based on the testimony. There was only half of Detective Zaleski and 2 witnesses today that basically testified off of reports. I say we go now and give him 0 time to prepare. And especially testifying in a narrative, testify. All of the exhibits are there. You can take them out, go one by one through them. I would say give him 0 minutes to prepare. I think 15 is reasonable, as Your Honor suggested.
All right, I don't need a response from you, Mr. Olson. I'll make my decision right now. Given how slowly this trial has progressed, given the ample of time that we've taken breaks, numerous accommodations made for above and beyond for Mr. Olson, including the court going above and beyond to ensure that Mr. Olson is given access to the law library this morning. All of these things and all of these times were available for Mr. Olson to use as he deemed appropriate. And apparently, he decided what he decided, and he did what he did with the time that was available. The court is in no position, nor the court would ever take up the job of telling Mr. Olson how to work up his defense and how much time to spend. Thus, the court finds it appropriate under consideration of the totality of the circumstance and given what transpired this week to limit the time that Mr. Olson can spend preparing his testimony. We're going to go off the record. 15 minutes is given. I'm starting the clock right now. It's 3:36. I'm going to make a call to the chief and see whether we can go to 6:30 and or continue tomorrow morning. If we continue tomorrow morning, it will be everybody report by 8:30. State?
Yes. just a reminder, we'll have to go through Mr. Olson's record before he gets on the stand.
That's true. Actually, now that he's decided, let's just do that. Mr. Olson, I already decided how much time you
okay,
get.
that's fine.
The decisions are made. You can appeal if you don't like. Let's talk about your prior convictions for purposes of you testifying. State, how many did you count?
I'm 13. Let me give you a little bit of background. He's been in and out of custody for basically the entirety since 1994. So while several of them are dated, it's generally because this is a continuing act of conduct, and a lot of them are due to credibility crimes, which I think is also important to consider. I'll go through the Wisconsin cases first. 2022 CM12 from Racine County, possession of drug paraphernalia, sentenced on August 30th, 2022. 14 CM603 Eau Claire County, disorderly conduct.
Objection, Your Honor. That is
Mr.
not
Olson.
me. That's not.
Okay, that's a third violation. We're going to have you removed. Turn on the Zoom in the back. Okay. Let's go off the record and have Mr. Olson removed. This changes things a little bit.
This is just turning into an absolute shit show right now.
Mr. Olson, we're off the record. Don't talk.
Just let me know it's not the case. Mr. Olson. Just talking to my attorney.
Cops were collected and sent to. Okay. Phil, you ready?
Yeah.
We're back on the record outside the presence of the jury. Mr. Olson now joins us in the courtroom. And it's been about 15 minutes, close to it. Right. Mr. Olson, I'm going to ask you whether you are going to follow the court's rules of decorum. And if you promise that you will and you can, then I will allow you to remain in the courtroom and we will proceed with the trial. So my question to you is, can you and will you follow the court's rules of decorum?
I didn't realize I broke them, Your Honor.
And you did, and I am telling you that you did. So my question to you is, can you and will you follow the court's rules of decorum?
I mean, as I said, I didn't realize I broke them. I'm objecting.
It's a yes or no answer.
I mean, I'm doing the best that I can under the circumstances. So
If I don't hear a yes, then I will have you removed. But if you're willing to follow the court's rules and you can and you will follow it, then we can proceed. Can you and will you follow the court's rules of decorum?
I guess I'm at your, you know, I can't argue anything with you. It's you're the boss. Yes, ma'am.
Okay. Having heard you indicate yes, you will and you can follow the court's rules of decorum, we will proceed. State as to prior convictions.
I stated 2022 Racine. I was talking about a 2013 case, and had Mr. Olson waited to the end to respond like he should have, I would have been drawn to my attention that that was a different birth date for Timothy Olson. So that one I can take off the record.
Is that the 14 CM603 Eau Claire?
Yes.
Okay.
So that one. Then the next one is 2006 CF 5944, operating a motor vehicle without owner's consent. Sentencing date January 9th, 2009. That was 4 years in prison. 2005 CM 913 from Dane County, resisting and obstructing possession of drug paraphernalia. 2005 April 13th of 2005. Dane County, possession of cocaine, second or subsequent. Sentenced on April 13th, again 2005.
What's the case number?
05 CF 273. 2002 Milwaukee, that was a theft conviction. 02 CF 5331. I don't have a sentencing date on that one. Milwaukee cases, as you know, were converted, so some of the older ones are difficult to find on CCAP. 1997 CF 608, Kenosha County case for escape. Sentencing date October 9th, 1997. He was sentenced to 5 years of probation. 1997 CF 474, another Kenosha case. September 17th, 1997, sentenced to 3 years of prison. That was a theft, false representation conviction. 1997 CF 975195 in Milwaukee. That was a forgery case. That was a converted case, so it's unknown what the sentencing date was. 1994 CF 267 in Kenosha, a forgery uttering. September 4th, 1997 was that sentencing date. And then the rest is his Illinois record. 1999 CF 3052, a theft, which was a felony 3 conviction. July 6, 2000, he was sentenced to 3 years of imprisonment. 2006 CF 4803, burglary, a felony 2 conviction. January 24th, 2007, sentenced to 5 years of imprisonment. 2012 CF 336, larceny, a felony 3 conviction, October 4th, 2012, 2 years of imprisonment. That's all.
Thank you for your permission.
Is that 11?
I count 12.
Your Honor,
I'm sorry, that's correct. The 22 CM 12, Racine.
Yes.
Okay, yes, that would make it 12. All right, now, Mr. Olson, as to your response on these convictions.
Well, so as far as the most recent that was listed in Milwaukee, which is 2006, for the record, that case was brought back into court, and the judge, I had an agreement with the court because it was the charge was operating without owner's consent, but I agreed with the court not to pursue misconduct in that case because I had permission to use the vehicle, and the alleged victim actually did say that I had permission. So because I should have never even been charged to begin with, and there was some other issues with the district attorney. There was a district attorney that actually was fired because of me. That was on my representation, K. Richard Wells. He was fired from the DA's office specifically because something he did in my case, and then he became my defense attorney. And I didn't know that had all transpired. So, having said that I was not guilty of a crime and misconduct from the district attorney that was defending me, the case was changed from 5 years consecutive back down to 3 months, and I was released immediately when the judge seen that case. And I thought the case was what is that called? Sealed. I thought it was sealed after that, but
So there was a conviction.
there was a
You were
conviction, but
sentenced.
it was changed from 5 years consecutive to 3 months on the grounds that I wouldn't pursue misconduct and sue.
Okay, well, what about the other ones? The other cases?
So I guess I would object to all of them necessarily being relevant. You have to say. Yeah, some are definitely way over 20 years old, maybe 30 years old. There's only one that's within the last 10 years, and I believe that's a misdemeanor. I don't even know if that listed misdemeanor.
State, if the cutoff was 10, give me the cases. So anything older than 10 years, don't give me those cases, but just cases within the last 10 years. And let's just be clear, within the last 10 years of 2022.
It would be the larceny.
What's the case number on that one?
That's the Illinois case, 12 CF 336, and the 22 CM 12 from Racine.
For possession. And that gap in time is explained by Mr. Olson serving time?
Correct. For example, in 2006, he served 5 years of imprisonment in Illinois, which would bring you then to 2011. And then he immediately committed the larceny, where that was 2 years of imprisonment. And then there is some gap after that before 2020 and then to 2022.
Your Honor,
Okay. Yes, Mr. Olson.
So no, I was sentenced to 5 years, but in Illinois that doesn't. So you're actually eligible. That gets cut in half immediately, and then you get 6 months more good time. So it's 2 years, and then I earned another 6 months of good time. I actually only served a little bit over a year, and then I was brought back here to face that ridiculous step of a vehicle charge. And so I was only from, and I think I was released, I don't know, 2000. So I did a little over a year in Illinois, and then I sat here for a year. And so it was not very long.
I'm ready to make my decision. There are various factors for the court to consider in balancing consideration of all of this information as to ultimately what number of convictions may be used for attacking the character for truthfulness. These factors include the lapse of time between the convictions, rehabilitation of the person convicted, the gravity of the crime, and involvement of dishonesty or false statements in the crime, as well as the frequency of convictions. And I think the factors that probably stick out the most here are going to be the frequency of the convictions, as well as the lapse of time, which is explained by the state in that during the times when there were no convictions, that was a time when Mr. Olson was serving time in custody. Given the state's explanation of these convictions, and as outlined by the state, the court is persuaded that the appropriate number of prior convictions for attacking character of truthfulness is 12. So that's what we're going to go with. Now, Mr. Olson, if asked, if you ever been convicted, the answer is yes. How many times? The answer is 12. You stray from that and say something else, that would open the door. You understand that?
Okay. May I comment?
Do you understand that?
Yes.
Okay.
Yes.
Yes. What is it?
So from 2012 to when I was arrested in 2022, there was no arrests, and there was 10 years there that there were nothing happening between that time. There was.
Sure, and I'll explain the 10-year that I asked the state about There's no fast rule that it must be 10 years, but usually that's my starting point. And when the state explained, which I inquired about those gaps between convictions, it wasn't because you were out there and being a productive, law-abiding citizen. It was because you were in custody doing time. And so while 10-year is usually where I start, it's not a mandatory consideration. Okay, that goes towards the lapse of time between convictions, and that's just where I start. 10 years. It doesn't mean that I'm bound by 10 years. Okay, so now that I made my decision, we have to really move on. It's 403. Lastly, this is how we're going to proceed. Because of the loss in time and the fact that this is Friday, it's Friday and it's 403, we're going to go to 5:30. When the jury is brought in, I'm going to indicate so and inform them that we're going to go to 5:30 today, because during voir dire and during before I did my preliminary instructions, I believe I also instructed them that the courthouse operation hours. So they're operating on the belief that the court must be closed at 5. I will tell them that we're going to go to 5:30. Additionally, tomorrow morning, we are going to continue the trial if we don't finish. We will be in G55. G55. The deputies will bring you there, Mr. Olson. And my order will be that everyone report by 8:30. It is Saturday, although I would like everyone to be there at 8 o'clock. I think it's probably not going to be well received by the jurors. So I will reluctantly order that they report to the jury room for G55 by 8:30, which means hopefully by 8:15 they should be making their way through the courthouse security. I will bring the jury in and inform them about the 5:30. I will also inform them about tomorrow. That may have an impact on jurors who are available or not available. And we'll see what they say. As soon as I survey and see who's available, who's not going to be available, and if there's good cause to, I don't know, lose a juror, hopefully no more than 2, then we'll go into Mr. Olson's testimony. And Mr. Olson, I've already reviewed the rules with you, so you know how to testify. Any questions on what I just stated relative to logistics from state? And are you available to go to 5:30 and to report tomorrow to start at 8:30?
Yes.
Okay. And then Mr. Olson, you'll be in custody, and then the deputies will bring you. But Attorney Wasilewski, as for you, 5:30 today and tomorrow at 8:30.
I can make that work, Your Honor.
Okay. Now I've been told that we cannot go beyond noon tomorrow, so the only time we have is 8:30 to noon tomorrow, and we'll be in G55.
Okay, really quick, Your Honor. Am I still going to have the 15 minutes to prepare with Attorney Wasilewski for the testimony? I have to.
Okay.
I need his help.
That is true. I had hoped that maybe you would have already started on that, but that's fine. 4:06 right now, so 15 minutes. Timer starts right now, and then in 15 minutes, let's bring in the jury. Okay, we're off the record.
That one warning, and you're going to remove my entire right to testify. I'm going to do
Form, and then I'll turn to you for you to then. Do you understand that?
No, I object to that completely.
I gave you a minute or two extra, Mr. Olson. Okay, we are back on the record outside the presence of the jury. Mr. Olson, there is one other warning I do want to give you that I didn't give you before, which is that during the course of your testimony, if I give you more than one warning for failing to follow the court's rules relative to your testimony, you will forfeit your right to testify. I will then end your testimony, and then the trial will proceed. Do you understand that?
No, I object to that completely. You're violating every code of conduct you can think of.
Okay, you can object, and that's fine. But I'm letting you know you get one warning. After that, if I have to warn you again, that means that your testimony will be ending and has to end, and then we'll just simply proceed from there. Okay, so no, Mr. Olson, that's it. So what we're going to do next is also relative to logistics. You're going to testify from defense table. It's just going to be easier for you to testify there than to move you to the witness stand. Once you're done testifying, remove the jury and then bring you back. And the logistics is a little complicated. We're going late into the day, so you can just testify from that table. You will be sworn in before you start your testimony. I will let you know. Well, actually, I'll let the jury know that you'll be testifying in the narrative form, and then I'll turn to you for you to then commence your testimony. Okay. Yes, Mr. Olson.
So I need to know exactly what you're saying I can't say or do during this course, or you're going to take away my right to testify. You've already violated enough of my rights. I need to know exactly what you're talking about.
Sure. As I stated, and I've gone over with you before, you are to keep your testimony relevant. That means you cannot talk about the many grievances you have against the court, whether it's me or another judge. You cannot talk about your grievances against the attorneys, whether it's the state or prior defense counsel or current standby counsel. Those things are not relevant. You are to keep your testimony relevant to the allegations made against you relative to any time period. Okay, so we're not talking about when you were born. We're talking about the relevant time period as well. And so those are the rules. Also, part of the rule is that if there is an objection, whether you object or whether it's a state, you must stop talking and then allow the court to rule before you continue your testimony. If I remember, and I'll try to remember, I will tell you that you can continue your testimony. Okay, and that should be the cue for you then to continue. And again, if I have to give you more than one warning, you will forfeit your right to testify, and we'll end your testimony there. Any questions on those rules?
Well, I object. I think that's really fair. That one warning and you're going to remove my entire right to testify. I'm going to do my best to keep on track. I don't think I would need to speak about anything.
Well, and that's all you can do is do your best. That's all you can do is do your best. But what's important is that you have notice of these rules and that you can follow these rules.
Well,
That's all. We're done with the record. We're going to bring in the jury now. Yes, Attorney Wasilewski.
I have two things. First of all, you instructed Mr. Olson to stick to the time frame of the alleged offenses. One thing we discussed is the possibility of discussing before the offenses in connection with to what extent he may or may not have known Ms. Hannell.
I think but that still ties in with the allegation. So when I say the relevant time period, if those alleged acts or knowledge related to whatever may have occurred before the alleged dates of incident is relevant, then fine. It's first and foremost relevant, right? And then secondly, it's not a blanket instruction order from the court that he cannot testify about anything other than the dates of incidents. If there are other things that are relevant that don't fall on those specific dates of incident, fine. I think the guiding post here is whether it's relevant or not.
Okay, second question. If I'm to be seated right next to Mr. Olson while he's testifying, I think we both should know whether the court is allowing or prohibiting us to talk in the course of that testimony, because normally when you're in a witness stand, that simply isn't possible.
Okay, I thought that's a really good point, and I thought I was trying to be efficient, but I think perhaps maybe given that to minimize any chance of that happening, just simply put Mr. Olson in the witness stand.
Your Honor, I would object to that. This would be much easier here, and I will refrain from asking him any questions. You are right; it would be easier from here. I think that given the way that this testimony is going to be given, the only reason I would ask him a question is if it is to be mindful of going outside of your conduct you expect. So that's the only reason I would turn to him, to make sure that wouldn't upset the court. And I think that's a good thing to be here, and to make sure that I would ask him to stay inside that relevant area and without violating any.
Attorney Wasilewski, anything else?
I have nothing else.
Okay, and then State.
Your Honor, that was my concern too, was the proximity. I have to advise my witnesses what to say and not say, and then hope for the best when they're on the stand. I don't get to sit there and have them check to see if that's okay. And two, the credibility instruction itself allows for the jury to see the face of the defendant. And as I get an opportunity to cross-examine Mr. Olson, he's turning around right now to look at me. And so then I think that is just a very awkward situation as well.
Sure. Convenience and convenience is not going to trump, I think, your right, as well as your right to cross-examine effectively, and also to ensure that there is no blurring of the lines between Mr. Olson representing himself and standby counsel, and also, as Mr. Olson pointed out, so that he can follow the rules. And I certainly don't want to put him in a situation whereby, contrary to what he believes, he might actually be more prone to violating the rules than not, because he's seated at defense table. So for all those reasons, let's have Deputy Bruce, courts change its mind. Let's have Mr. Olson put in the witness stand now to get ready, and then we'll bring in the jury. Again, when we bring in the jury, the first thing I'm going to do is survey the jurors. And so, Mr. Olson, while you may be seated at the witness stand, just wait for my cue that you can testify. Okay, let's go off the record while we get Mr. Olson situated, and then bring in the jury.
Actually, Your Honor, may I use the restroom really quickly?
Is that necessary right now?
Yeah, probably.
Okay, take him to the restroom.
Okay. All right. Sorry.
Where could you have to go? State. Again, the deputies will meet with you and give you further instructions. Also, make sure that we have your phone numbers, and that you have our number, so that if something comes up, we can get a hold of you and you can get a hold of us. As you all may remember, we cannot continue until all 14 of you have reported. So that is important. And all week, you all have done that, reported on time as ordered by the court. So thank you. Okay, now Mr. Olson will testify in the narrative form, and thus that's where we will begin. So Mr. Olson, you'll be sworn in first.
If you could raise your right hand. Thanks, sir. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Just speaking to that mic. Can you just spell your first and last name for me?
Spell it.
Please. State and spell.
Timothy Olson, TimothyOlson. So this is going to be a little difficult narrating this, so just bear with me. So as far as, I'm going to start with Betty Hannell. So I it's been quite a while since this case, began. So it's going to be a little harder to recollect everything. So I met Betty maybe within 2 years before 2022, sometime around then. I was doing Uber, and I stopped at a restaurant bar. It might have been on 76th Street, somewhere in the Greenfield. I believe that's Greenfield, somewhere in that area near Southridge, somewhere out there. And it was, I was having a drink, and Betty was there, and we just spoke friendly. She had frequented this place, she told me, because it was a buy one, get one burger, and she liked to go there. I'm always very friendly and outgoing. she was very nice. We just talked. She told me a lot about herself, you know, that her husband had passed away and that she took care of her brother. I forget where she said that he actually lived. I think he lived in somewhere where they could take care of him. I know she had mentioned that her sister had passed away and that she was actually younger than her. And that, she also mentioned that her sister had embezzled all of her brother's money from an account. And I'm pretty sure it was the brother that she took the money from. It might have been another family member, but I'm pretty sure it was the brother. So excuse me if I'm wrong there. But anyway, I know that Betty had said that she didn't talk to the sister and that she had already passed away after that it all happened. I know she said she had always told me that her husband passed away sometime before that, and that they always had gone to Casa de Giorgio, and we talked about Rex, and this was even before I went there. I don't remember what else we talked about when we first met. We sort of kept in contact, but not really. I mean, I didn't really text her. It was not like there was no, like it wasn't anything sexual or anything like that. It was she was just a friend, and she was nice. We just talked, and I ran into her a couple times in that area because I was always doing Uber. I probably worked 12 to 16 hours a day, 6 or 7 days a week. And then, so I ran into her here and there. I ran into her maybe, I don't know, within a week of that date in 2022. And we had planned, she told me to meet her there on Wednesday, I believe. And she had to take her brother grocery shopping and she wanted me to meet her there. And I said, yeah, that sounds good. I had been wanting to go there anyway. I actually tried to go into this restaurant numerous times before, but they were closed on the times they said they were open for some reason. I don't think they got a lot of business. But so we had planned on meeting her, and she just said she'd get there as soon as she could. That day, I think they didn't open until the late afternoon. She had also told me she didn't want Rex to know that we knew each other because she felt odd because she went there with her husband a lot. She just didn't want to have to explain anything, I think. And I understood that. It wasn't a big deal. So when I arrived, at Casa de Giorgio, I walked in and I sat down at a table at first because Rex was by himself and I didn't know where he wanted me to sit. I would probably sit at the bar right away, but I didn't want to inconvenience him. So I sat at a table and I had a drink and I was going to order. And before Betty even arrived, I went and sat at the bar. I asked him if it'd be all right if I sat at the bar. I wanted to watch some sports. And there was actually another gentleman there also. It wasn't just me. And even before Betty arrived, he was sitting, I think, 4 or 5 seats down from me at the bar. So I had maybe 1 or 2 drinks I was going to order. I talked to Rex an awful lot. He's really nice, and we got along quite well. He talked to me about his business, and I was curious as his kitchen. I used to manage restaurants, and we talked about a lot of the food items that he served. And I think I had an appetizer, and it was really good. I think it was calamari, and he had made it a little different. He sauteed it in some sauce. Let me think. So I don't know how much time went by. It was a considerable amount of time before Betty even arrived there. So I talked to Rex and the other gentleman that was there for quite some time. Again, like I said, when before arriving there, Betty had explained to me that she didn't want Rex to know that we knew each other. There was a little bit more involved in why, the reasons why she didn't want him to know, but for testifying purposes, I'm not going to get into that information. I might reconsider that because this is very important. So, trying to remember anything else that she had told me. Well, she told me that her husband and her had frequented there. And she would show me the booth that they always sat in. She talked about Rex a lot. So when she did arrive, she sat 1 stool over from me. So we just started talking right away, and we just talked about, you know, all sorts of things. Her son, I think it was a laptop that she had just gotten, a new laptop or something. She had her Nook or whatever with her as well. I know she had talked about getting a new laptop and that she wasn't able to work it properly. Let me think what else. I know Rex came over several times and we were all talking together about the menu items, drinks, and I commented he made drinks really well. He was very polite, really kind. I think Betty ordered wine. I don't remember if she got anything to eat or not. But we talked for quite a while there. It was at least an hour, and I was probably there maybe an hour and a half before she even arrived. So I don't know what time it was at that point. But she was very uncomfortable in a way talking there in front of Rex. So to me, I started to get the feeling that that she was sort of attracted to me in a way. She had made comments, but she never made any. It never was out more than that. But I guess I got that feeling because she kept making it clear too that she didn't want Rex to know I was there. I knew her. But like I said, there was other reasonings for that. So we decided to leave maybe about an hour after I arrived. And again, she didn't want anybody to know that we had planned to meet there and we were together. But we went together like that, like a date. It wasn't a date. It was just friends meeting. And, you know, I know she didn't really have a lot of people she talked to. She talked to her brother, who she took care of. And that was really it. But at that time, I was also in a situation where I needed to talk to somebody, and she was nice, so she didn't mind.
Ms. Olson, you have to keep going.
I am.
Keep it along.
So I'm trying to get everything out. It's not easy. It's 4 years ago.
You've testified a lot about the relationship. Okay, now move on.
So we decided to leave, and we walked out together. But no, I'm sorry. Let me recollect. Okay, no, I wasn't sure exactly what she wanted to do. We didn't discuss if we were going to stay there. She did want to leave because of Rex and go somewhere else, but I wasn't sure what she wanted to do, where we were going. So we did decide to leave, but I wasn't sure what was going on, where we were going, what was going to happen next. We had never actually ventured out together. It was always just running into each other or briefly speaking. So when we got outside, I went around by her passenger door, and because it swung open all the way, and she couldn't reach it, so I went and shut it for her. And then I went around the other side and got in the vehicle. It was no surprise. And I didn't even completely shut the door because I was going to go back in and pay. And actually, I know this sounds a little odd, but Betty actually, I was having some trouble at the time, I guess, and Betty gave me actually $200.
Objection relevance.
What?
Quick response to that.
Well, as far as objecting to what she's saying,
Yeah,
I object. It's very relevant as far as what really happened.
Objection overruled. You may continue.
Thank you, Your Honor. So she had given me, I don't remember how much it was. I didn't count it. I honestly didn't even like accepting it from her. But it was an odd time. And she gave me the money, and she had given me a Thanksgiving card that she had bought me. And at the time also, she gave me a birthday card, even though it was well past my birthday, and said that she hadn't seen me, but she had bought the card for me. And, I was very appreciative. I think there was a Starbucks card in there that she had bought me. If I remember correctly. One of the cards, I believe, was like a music card where you open it up and it played music. Something like that. It was a little bigger, a little heavier. I think it was a birthday card. So anyway, I was about to go back in and pay. She's like, no, let's just leave. You can come back later. She didn't want anybody to see me get back out of her car, go back in. She said, let's just go. I said, are you sure? I didn't want to do that to Rex because he was really nice, and I wanted to go back right away and pay. And she wasn't wanting me to go back in. So I shut the door and we pulled out. She's kind of an erratic driver. She reversed like really far back into the parking lot, like all the way back behind the restaurant. And then finally was able to, because where she was parked at the restaurant, she was right in front of the driveway to exit out. She could have just easily went out, but she reversed all the way back. I thought that was kind of funny because she didn't want anybody to see us leaving together, and yet she reversed all the way back and then went forward again in front of everyone. I thought they had seen us, but I guess not. There was another gentleman that was there. I think he was exiting the building when we were pulling out. So from there, we were pulling out. I'm thinking we went, what direction did we go? So we weren't really sure where we were going. We pulled out and she turned left into the parking lot of a strip mall right there. It's we were just looking for somewhere to go. And I think that's where like Home Depot is or something. And there's a bunch of like restaurants in that area, bars. I'm trying to remember where we went from there. So I think she pulled out of that parking lot and turned onto South 27th Street. So we were, oh yeah. Okay, so she pulled back out of the parking lot, and we were facing south on South 27th, and she turned right and went back up. I think that's Rawson. I don't remember the name of that road right there where Casa de Giorgio's on. I think it's Rawson. And we headed towards 76th Street, I believe. And we were headed towards her house, and because she decided she'd just rather just go maybe have a drink at her house. She wanted to show me her house, and as we got closer, she decided not to go to her house because her neighbors were out, and I don't remember exactly where it was, but I think she must have been really close with her neighbors. So from there, I had, I believe, asked if we could, drive somewhere to a liquor store. I was going to grab something to drink for myself because she really didn't know where she wanted to go. She didn't like going very many places. I believe we drove around for a little bit, and I'm not sure exactly how we ended up. We just were driving, talking, and we ended up pretty far away from there. I think we went back towards like 27th Street and ended up on somewhere on the south side. And it was just like a little liquor store, I don't know, deli looking type place. I don't know the name of it. But we were just driving around, just talking. She was fine with that. She really didn't like to go too many places. As far as I know, the only places she went was the one that I originally met her at. I don't know the name of that. And then Casa de Giorgio, she didn't really venture out too many places. So I stopped we pulled up at the liquor store. It wasn't really a liquor store, like I said, it was just a store, like a local neighborhood store. There were plenty of people outside. She pulled up on the side of the building, pretty far away from the door. And there was people walking all around. I got out of the passenger seat and went in, and actually she thought I was just going to leave for some reason. She had constantly mentioned, you're not going to just leave, are you? And I said, no, why would I leave? I don't know. I think she was worried about because she had given me money that I was just interested in the money she gave me, and that I was going to leave. And it was very odd. So anyway, I went in the store and I got a few things. I don't remember everything. And I don't know, I was in there maybe 10 minutes. Then I came back out, we left. I don't remember where we went from there. Oh, okay, yeah, no, we went to I actually asked her if she could drive to a vape shop that I knew was there on South 27th, somewhere near, I'm trying to think where that was. don't know, maybe it was somewhere near college. It was on South 27th, the vape shop. They were closing. She pulled up and parked, and I went in. The guy was just closing. She was out in the car by herself. She had her phone. There was 2 sets of keys to her car. She was telling me about her car, so that's how I know that I think her son got it for her. So there were 2 sets of keys in the car. I went in to the vape shop for probably maybe 10, 15 minutes. Looked around, and the guy was kind of in a rush to close, so I just kind of left. And I believe we then, from there, we went up the road to another store. Also on South 27th Street. I don't remember the name of it. It was more closer to Ryan Road. I parked. There was a lot of cars there. It was pretty busy, and I parked really far away from the front of the building. At the end, or she parked. Sorry, she parked. It was a good distance from the door, and then I walked in and I got some items. I don't even remember what. So I don't know, I wasn't in there very long. I think I got some scratch off lottery tickets or something.
Your Honor, I'm going to object to the relevance of all of this.
You sustain. Do not talk about that. Continue on with your testimony.
Okay. From there we left. I don't remember where we went from there, but I know sometime during that time we pulled over and I drove. She didn't want to drive any longer. She was tired and she has a difficult time maneuvering around. Oh, I also wanted to state that she was not using a walker at that time at all. She moved around quite easily and didn't have a problem. She did have an issue with arthritis and pain. I know she had told me about that before. So I think I had taken over driving for a while. I think at that point I had contacted a friend and I went to go meet him somewhere on the north side. I don't remember exactly where it was. So I got out, went, and my friend's, I parked and she was fine, and I got out and went in my friend's car, and we left and went to his house, which was just right up the street. She just waited there. I wasn't gone long, maybe a few minutes, 5, 10 minutes. And I came back, and she was there in the car. It was right by a busy road. There was a store nearby, also right nearby. I don't remember the exact intersections. I think before I got back into the car, I sat and talked to my friend outside of the car for a while. We were a good distance away from Betty's car. And then I got in and we left. And I don't know, we drove around. I mean, we just drove around and talked. I was in, like I said, I was just in need of a friend to talk about. There was a lot of things going on with me at the time. So, we just, like I said, we drove around and talked a lot. From there, we went, I believe we ended up back towards the south side. I was just driving around anywhere. I wasn't even sure where we were headed. We had no destination. I eventually stopped at another gas station. I don't know how long that was.
Your Honor, I'm going to object to relevance again.
Sustain. Don't talk about that, but continue on.
I object, Your Honor. This is relevant because I went to a store and left and parked up the road and went back in.
I sustain the objection. Continue, though, with your testimony.
All right. So after leaving this store that I was in, I walked back up the block. It was busy, so I had to walk about a half a block to where I parked. It was a really busy area and busy store for some reason. So anyways, I had to walk about half a block back to the car. And I got in, we left. And so I don't remember where we went exactly after that. Just bear with me. This is very hard to remember. It's quite a long time ago. Okay, yeah. So we were looking for a place for. She wanted to stop to use the bathroom. We tried. So in that area, there's a lot of the gas stations don't have bathrooms, or they're not open, or they're locked because of whatever reason. Sometimes they just shut them and say because they don't want problems. Some of them are broken, and she couldn't wait any longer, so she asked me to just pull up in an alley so she could pee. And I really didn't want to because it was a really bad area though, where it was, but just wasn't comfortable with that. So she insisted because she said she couldn't wait. So I pulled up in the alley and she got out and peed, but I kind of like stood by and guarded, like, I don't know. I didn't really get out of the car. I kind of semi did and just made sure that nobody was going, near her or anything. I just had to make sure that she was okay. So she went pretty quickly and got back in the car. I had no idea that I think she said she used her sock. I did not know that. She did that. I would have found somewhere where I go to the bathroom so she could have used it properly, but she couldn't wait. I understand. I know sometimes women are like that. They can't wait. And I guess that's why I kind of understood that. And anyway, we pulled off. That was no big deal at the time. It was a little odd, but she's human. She had to go. So anyway, we pulled away from there. I believe we went to. I think we stopped at another restaurant.
Your Honor, we've been talking about going around in circles for now 45 minutes. I object to relevance.
Well, we went in
I'm going to
together.
take the objection under advisement, so I'm going to allow you to continue your testimony, Mr. Olson, but remember to keep it relevant. Okay, continue.
Well, so I may continue with where we went. Is that fine? Okay. All right. So I believe we went to Chili's after this, and that's also right near, or maybe it was Applebee's. That's right. No, it was Applebee's. It's off of, I think it's off of College, like 13th or something, somewhere over there. I think there's a theater over there or a hotel or something. Anyway, we went in there very briefly, but they were closing. And I don't know, I think I had one drink. I don't think she had anything. She was wanting to get something to eat. She didn't eat at Casa de Giorgio. I had like an appetizer, I think. So I was hungry as well, but they were closing, so we went in briefly and then we left. From there, I don't remember where we went. I'm trying to remember what happened after that. So I think we drove up Rawson again towards 76th Street or Highway 100, one of those roads. And we turned and I got gas at I don't remember what kind of gas station it was. But that was all on camera there. I think I got out and pumped, and there's a lot of people and police cars everywhere, people everywhere.
Mr. Olson, some of those details are not relevant. Okay, so stick to what's relevant. Continue your testimony, please.
So I got gas. If we filled it up, and I believe I used her card. She let me use the card, or I used the cash sometimes that she gave me when I went into numerous of these places. But when I filled up her tank for her, I used her card at this gas station. I believe after this, she asked if.
Objection. This is hearsay, Your Honor.
Sustain.
Oh my God. The whole night would be hearsay then.
And avoid commentaries, Mr. Olson.
Was Exhibit 90 some of the places where Betty was this exhibit part of this?
90?
Yes,
Map of Milwaukee, excuse me, map of Milwaukee area and chronological travel points.
for Betty Handles.
Exhibit 90.
Okay. So from that gas station, we drove.
Your Honor, I'm going to object under 90403 and ask to move on. Even if this is relevant evidence, it's been a confusion to the jury or a waste of time.
What?
Overruled. Continue.
So from here, we went to a hotel on Rawson and Highway 100. I don't remember the name of it. There's like a bar restaurant right across the street. So she asked if I minded if
Objection. Hearsay.
Sustained.
she gave me her card to go in to rent a hotel room. And when we got there, she changed her mind. It was, so there was more going on. So I don't know, we decided not to go there, and we left. I pulled off. I'm not trying to confuse anybody. It's just hard to remember.
No
everything.
commentaries.
All right. Okay.
Are you done, Mr. Olson?
No, I'm trying to remember exactly what happened after that.
Commentary.
Yep. No commentaries.
So after this, I believe we drove to, I'm trying to remember this. I believe we drove to the east side. I don't remember what time it was. I think we were on North Avenue. I remember turning around.
Objection. Relevance.
Overruled. Continue.
So we were on North Avenue in front of Jalisco's, I believe it is. And I turned around in a parking lot right there. I think it's a hospital parking lot. And we proceeded to go west on North Avenue. And I think we parked, we were going to go in somewhere on the east side. I don't recall exactly where. I think I turned right on Oakland Avenue. And then we parked, and I think we went to a bar or tavern over there. It's around the corner. I don't know the name. It's down another street, maybe right near there. We went in there briefly and had a drink. And then we left, I believe, I don't know, maybe it was around midnight at this time. I'm not positive. I don't remember what time we left Casa Georgia, but I don't think it was 3 o'clock. As others stated, but it could have been, but it didn't seem like that because I don't think we drove around that long. But from where we went to, I can't remember the name of the area.
Mr. Olson, you need to stop making commentaries. If you have statements you're going to make as part of your testimony, make those statements, but do not make comments.
Okay.
We do not need to hear your thought process.
So we drove from there to another area, south of the east side.
Your objection. Relevance. Driving around isn't part of any of the crimes.
Sustained. Okay, continue.
There were no crimes committed. I don't know what crimes were committed there.
Objection, commentary. Mr. Olson, you were instructed by the court to not make any commentaries, and that would have been argumentative with state simply based on their objection. You did not allow the court to rule on that objection in a timely fashion and also in an orderly fashion. Continue, but that's notice to you that you need to testify consistent with the rules the court has set.
Am I allowed, Your Honor, am I allowed to speak about where we went from there? Yeah.
You can testify to what's relevant and follow the court's rules.
Okay. I mean, to me, I'm
There's no commentary, and the court has made its decision.
So we went to another establishment on I can't remember the name of the area. It's south of downtown, not too far from there. It's a nice area. We went into another bar. It was a very busy area. And we went in somewhere over there briefly. I paid with cash. I don't know how long we stayed. We didn't stay very long. I think it was getting to the point of almost like most of the bars were closing. And
Objection, relevance. Sustained.
Okay.
Right, it's 5:28, so I'm going to stop it here, members of the jury. I remind everyone that this case is not concluded. Therefore, you may not talk about this case. You may not talk about your experience. I know that it is tempting when you go home tonight to talk to others, to share your experience, to share what you've heard, but you may not do so. It is improper for others who have not heard this case and do not sit there in the jury box with you to influence your view of the evidence. I do not know, but I would advise you to potentially plan for that. Yes, juror 20. Jury management is closed, but I can write you a letter on my letterhead if that helps you. Does anyone else need that? Now, that's not the same thing as jury management indicating so, because the clerk's office is responsible for that, and they have the ultimate. And what I'll do is, instead of holding you up,
I don't know what that means, guys, but that's
outside the presence of the jury, just one thing I want to know on the record is that juror number 1 did have her eyes closed throughout the testimony. I don't know what that means. Certainly she was still paying attention, I could tell, but she did have her eyes closed. That's noted. Okay, we're beyond the time that I'm allowed to go beyond. So, Mr. Olson, tomorrow morning we're going to continue with your testimony. And given how you did today, I'm telling you that I've already given you one warning. And tomorrow, if you fail to follow the court's rules relative to your testimony, I'm just simply going to end it. Right? You've incurred one infraction today already. Tomorrow you do it again. You're just done with your testimony. We'll see how you do tomorrow. Even if you don't incur another infraction or violation, I think given the length of your testimony, it might be appropriate for the court to provide a little more guidance or direction during your testimony so that you're not all over the place and that you're not interjecting so many commentaries into your testimony. As I explained, we don't need to know your thought process, okay? And the commentaries that you've made are not relevant and they're not appropriate. Okay, that's the court's that's the court's order relative to what you can and cannot do.
Okay.
If you didn't understand it before, and then I'm putting you on notice that a single infraction tomorrow will result in your forfeiture to continue to testify. We're way over the time I'm allowed, so thank you everyone. I'll see you tomorrow, 8:30 G55.
You know, really quick, may I say something?
No, you cannot. We're done. We're off the record. It's 5:37. Okay, after my
Sarah P muted me. So now we're jumping. Oh, I just got a notification to say I was live. That's nice, isn't it? Right. Now we're going into the final day. This is his testimony. I think a rebuttal and then also closings and also verdict. So I think a lot of this, I'm going to skip jury instructions and stuff like that. I'm not going to show that. But yeah, I'm going to try to skip the dead air.
State of Wisconsin versus Timothy Olson Jr.
Case number 22 CF 4696. Appearances, please.
Timothy Olson, pro se, appears in person in custody in street clothing. I would note he has a different shirt from the one he'd been wearing earlier in the week. Also appearing at council table is standby counsel John Vasilevsky.
Good morning to everyone. Bill, you can hear me? Okay. Good morning to everyone, and thank you for being here today on a Saturday. I understand all the jurors are here. And what I'm going to do is bring in the jurors and take attendance, and then we'll proceed. I'm reminding you, Mr. Olson, that you've already incurred one violation against the court's rules. As to your testimony, if you incur another one today, I will forfeit your right to testify, and then we'll proceed to the jury instruction conference and verdict forms.
Your Honor, may I?
No, I'm not done. Just misplaced my note. But because we're in a new courtroom today, things are sort of disorganized.
Hey man, just want to let you know that sometimes you gotta shut the fuck up. And this current time is just one of those times you gotta shut the fuck up. I don't think you're a bad person, I just don't want to hear you talking anymore. You gotta shut the fuck up.
That the rules relative to your testimony, which is allowed in the narrative form, is first and foremost to keep it relevant. And that secondly, if there's an objection, whether by you or by opposing party, that you are to wait for my ruling before you speak. There may be occasions when it's not necessary for me to entertain short, succinct arguments of the parties, and I'll just immediately rule. Other times I may inquire, but you are to wait for the court.
Objection, Your Honor.
Additionally,
Lack of foundation calls for speculation.
There is no commentary allowed.
Unintelligible. I don't understand.
For example, as I stated yesterday, the jury does not need to hear your thought process about what you're going to say and why you're saying it. If you have something to say relative to your testimony, just make that statement. Those are the rules. Is that clear, Mr. Olson?
Yes, and then can I say something, please?
Okay.
So the defense is not rested yet, and I'm considering calling a couple of witnesses, if that's okay. I would definitely like to recall Detective Zalewski, and I would also like to be able to call DA Sadowski to the stand, since she had off-the-record communications with my private investigator, a past relationship with DA Sadowski, and communications off the record with other court personnel, deputies by DA Sadowski about my case.
Okay, so,
and also, sorry, one more thing, I didn't mean to interrupt you. I do have another motion for dismissal and mistrial with numerous issues that I didn't raise yesterday. Some are based on some of the issues yesterday, but I'm also asking that this motion not only be submitted into the record and heard before trial is over, that they also be forwarded to Chief Judge Carl Ashley, DA Kent Laverne, Sheriff Anita Ball, the FBI.
okay, I'm going to stop you there because we don't have a whole lot of time today. I've only been authorized to have this room until noon. So I'm not going to pretend like you are the judge and you can take direction of how this case proceeds. I'm going to say that once, and I'm going to make it very clear. Okay. So yesterday, there's a process and procedure to everything. Yesterday, okay, after state's case in chief, pursuant to procedure, I entertained motions. The court made a decision. We move on. You'll have another opportunity to motion the court, but we're not there yet. Okay. So do not go on the record with those motions because now is not the time. All right, let's bring in the jury. I understand that given what you just indicated to me, Mr. Olson, you do have one witness in addition to yourself, and that being the detective. So after your testimony, I'll allow you to call that witness, and we'll proceed relative to your request to also call the prosecuting attorney in this case. What case law or legal authority do you have to say that you can do that in this very trial?
So I would
until you can provide that legal authority that allows you to do that, the answer is no, you're not allowed to call the prosecuting attorney in this very trial. That is all. That is all. I've addressed the witness lineup relative to timing, and now we're going to go on the record. Let's bring in the jury. Put your hand down, Mr. Olson. We're done. We're on the record in the presence of the jury. Good morning, members of where things are. As you may recall, yesterday, Mr. Olson was in the witness stand testifying, and that's what we will pick. Mr. Olson, make sure you speak into the microphone. Here's your time.
Oh, it is. All right. So I don't remember what time it was, but apparently it was around midnight that she created this account and phone number for us to communicate with. And then somewhere after that, I thought it was probably maybe after 2 a.m. I'm not positive though. It could have been right around this time that it says states here the UTC time of 6:49, which would translate into somewhere after midnight. But I think it was quite later than that. Betty did text me through this Google Voice number and asked me where I was at and if I was coming back. She also stated it, wanted to make sure that she said, you didn't tell Rex that we knew each other, did you? There was another text indicating that her credit card had a $25,000 limit, which I would not have known without her telling me. When I got back to the car, when she texted, I wasn't even aware that she texted. She showed me the text on her phone saying that she had texted me and wondering if I had got them through the Google Voice. So this is why I know the texts were in her phone. Also, she had informed me that the next day she had to meet her brother for Thanksgiving at Mater's.
Same. Next question. I'm sorry. Continue testimony, please.
Okay. So we were going to meet back up after her meeting with her brother at Mater's. I forget what time that would have been. She was going to go early as possible and then come back to meet me, and we were going to go out of town. We didn't necessarily know where, but just somewhere like northern Wisconsin, maybe. As I said last night, we went yesterday. Sorry, we went to several locations. Sometimes we paid with her card. Sometimes I paid with cash. I did leave a couple of times from the car, venturing out. She just stayed there in the car. I don't know if she drove around at all, but especially when she texted me. Throughout the night, she also made me aware that she didn't want me to leave. She did inform me that she had power of it.
Sustained.
Okay. I knew that she had power of attorney over her brother's financial affairs, medical care. From that night and other.
Sustained.
Well, Your Honor, I object. It shows that I had.
The court has made a ruling. Continue.
So sometime early morning, we had an argument. Wasn't like no violent argument, anything like that. Just disagreed on things, and this did happen throughout the night. And at some point was when I decided to just get out of the car. And she was going to go visit her. She was close to going to go visit her brother anyway around this time. She was going to drop me off somewhere else, but because of the argument, I just got out of the car and she drove off down whatever road that was. It was on the map. So before that, let me think. So before that, we had planned, like I said, on her. She was just driving me. It wasn't far from where I got out at, but it was just to the point to where I just wanted to get out of the car. And we were supposed to meet up soon after that. She was going to Mater's to meet her brother.
Sustained.
And then she was going to come back to get me.
Okay. Sustained. That part of the testimony is stricken from the record.
I object to that.
Okay. Members of the jury, we're going to take a break, and then we'll have you back when we're ready. Okay, I remind everyone this case is not concluded. You're not to talk about this case, and you are not to conduct your own research. We'll discuss this more on the record during a break. All right, thank you.
I would also like to place.
Mr. Olson,
Can I place something on the record?
another violation of the court's rules of decorum. Okay, we're going to go off the record and you're going to be returned to your seat, at which time we'll come back on the record.
We can't hear it. I did not hear what the state had to say there. The judge seems to be. Did he get chucked off or something? The detective's back on. This guy, I don't like this guy.
I'll allow it. You may answer the question if you know it.
So there's no audio, no audio.
I'll allow it. You may answer the question if you know it.
No. Through your investigations, was there any proof, video of Mr. Olson physically forcibly restraining anyone, not only Betty, but anyone in throughout this investigation?
I'm going to sustain that objection, but with the caution that, okay, actually, it's just going to be better if I remove the jury and then we'll bring you back. Okay, members of the jury, this case, that concluded. Do not talk about it. Do not conduct no research.
This is the lead detective. He's been called back on. I really don't like him. I think that he did a shit job here. I think they all did a shit job.
The jury, Mr. Olson.
I generally do believe that if he had a proper attorney, they would be exposed to how shit the job they actually did.
The state is correct that that was a leading question, but to the extent that the court can appreciate that you are pro se and you're not a trained lawyer, nonetheless, you're still expected to know the rules. Yeah, I think that's helpful in just us moving along. As you may recall, and I said it before, that it's not an exhaustive list of things that you can and cannot do during examination. And you are on direct of this witness because you are calling him. That on direct, you cannot ask leading questions. And I want to make sure that you understand that. It's been said so many times, but for purposes of ensuring that you have a fair opportunity, I'm reminding you yet again of the rules. And again, you are expected to know the rules. Is there anything about what I just said and how I explained things that do not make sense to you relative to your direct examination of this witness?
So, in my defense, Attorney Wesselski just informed me of the difference between questioning him as cross-examining or as a direct witness. So I will do my best to make sure that I form the questions in the manner that they're supposed to be formed. And if they are not formed in that way and I accidentally form them another way, the DA is more than welcome to object, but I will try and keep them that way. I would not do that purposely.
Well, and which is why we are having this discussion on the record outside the presence of the jury, okay? Rather than admonish you during the course of your examination, I wanted to redirect your focus to what's permissible and what's not permissible. Also, besides the fact that on direct you cannot ask leading questions, had this witness been called adversely and noted as so on the record, things could be a little bit different as well. I recognize that there are some things here that could, within the court's discretion, that the court can allow, and that's why I want to have both parties aware of where I'm coming from relative to all of this. Okay, but going forward, do you understand the boundaries by which you're supposed to operate, Mr. Olson?
Yes, but
okay, that's all.
Yes,
I just need a yes or
no.
no.
I mean, I don't have a lot of experience with.
Okay, we don't need to rehash history here. Okay, let's bring in the jury. We're ready. We are still on the record, but no one is allowed to say anything on the record at this time.
Also, just remember, this guy got caught in a lie. The detective got caught. He says he stated that the defendant had the conversation, pretended to be somebody on the phone. And when the defendant said, "Oh, can you show that then? Could you put it into evidence?" He goes, "Oh, I may have been mistaken." So I don't like stuff like that. People making shit up. But I think if the real attorney was there now, yeah, they wouldn't be doing some of the stuff they're doing. So defendant is a stupid dick anyway. But even though he's a stupid dick, I still like things to be done correctly. And I don't like this guy or the prosecutor. They're very smarmy and think they can get away with stuff when, yeah, they shouldn't. We should hold them all to account. Court's muted again.
So, Detective Zalewski, during your course of this investigation, did you or did you not find any video evidence or any other proof of Mr. Olson ever having a gun?
No.
Detective Zalewski, through your investigations of this case, did you or did you ever not find any evidence, proof, video of Mr. Olson physically restraining anyone, including Betty Hannell?
Proof of you restraining anybody? No.
Through your investigations, did anyone ever witness Mr. Olson actually taking anything from anyone? Did you or did you not?
Objection confusing.
Sustain. Re-ask that question.
Investigation.
Do you have any more questions, Mr. Olson?
Yes, Detective Zalewski, through your investigation, did you or did you not find any proof of Mr. Olson forcing Betty Hannell to do anything?
No.
Detective Zalewski, through your investigation, did you or did you not find any proof of Mr. Olson forcing Betty Hannell to drink anything?
Yes, through Betty Hannell's statement.
Did you find any video evidence? Did you or did you not find any video evidence of Mr. Olson forcing Betty Hannell to drink anything?
No.
Did you or did you not find any controlled substances in any of these bottles that you tested?
No.
Through your investigation, Detective Zalewski, did you or did you not find any video evidence that would prove that Ms. Handel and Mr. Olson were not actually together?
Objection, compound question. Sustained.
The done into So, Detective Zalewski, how many investigations have you done into kidnappings?
I don't know the number off the top of my head. I have investigated kidnappings before. It's not a common investigation.
I'm sorry, did you say you have investigated?
Yes, I have.
No number off the top of your head?
I don't know the number off the top of my head. It's not a lot.
Less than 5?
It might be around 5.
Okay, out of those investigations, how many times did you not use an interrogation of a defendant?
Objection, relevance. Sustained.
Okay, of those 5 or less alleged kidnappings that you've investigated, how many did you not completely investigate video evidence of?
Objection, relevance. Sustained.
May I object? And I just wanted to object and maybe rephrase the question so that it can be asked properly. Or
Yes, you may rephrase the question. Do not talk about the case and do not conduct your own research. Break. Plan for about 5 minutes, and when we're ready. All right, members of the jury, I'm going to release you for a break. Plan for about 5 minutes, and when we're ready, we'll bring you back. I remind everyone this case is not concluded. Do not talk about the case and do not conduct your own research.
Detective Zalewski, through your investigations, did you or did you not find any video evidence of Mr. Olson actually committing a crime?
Objection. Relevance.
Yes.
Well, I don't know that would be the right basis for the objection. Response?
Well, I object.
Okay, well, you're asking for a legal conclusion, which the witness is in a position to make, so the objection is sustained on that reason. Next question, please. Ask your next question. Mr. Olson, ask your next question.
Oh my God. During your investigation, Detective Zalewski, did you or did you not find any video evidence of Mr. Olson actually committing Did you ever find any video evidence of, or did you not find any video evidence of the burglaries that were alleged?
Can you repeat the question?
Through your investigations, did you or did you not find any video evidence of Mr. Olson being involved in a burglary of the RV that is alleged to have happened?
No, I did not find any video evidence.
During your investigation of the burglary of the alleged burglary of the garage, did you find any video evidence of Mr. Olson being involved?
No.
Ask your next question.
Oh my God. That's all I have for the detective, Your Honor.
Press. Detective, do you have to be physically touched to be restrained?
No.
No. Could you go over a couple other ways that someone might be restrained without being physically touched?
It could be the passenger in a vehicle unable to leave.
Would it be perhaps if someone alleged to have a firearm, would that restrain another person?
Yes.
Well, there wasn't video evidence of the burglaries. Were there other types of evidence that you were able to locate in this investigation?
Yes.
Could you tell us about some of the evidence regarding the garage burglary?
Is your testimony, the garage burglary, there was a red bike in the garage. That's the same red bike that Mr. Olson had in his custody when he was observed by Officer Frusti at 35th and Rawson, where he then fled and dropped the bike, where it was later recovered.
And then regarding evidence, objection to question, or
To his response that
you don't get to argue with the witness. You can object to the question. Let's move on.
and then regarding evidence of the RV burglary, was there any evidence located regarding that a recreational vehicle was burglarized?
Yes.
Yes. And was that evidence the items that were found on Mr. Olson when he was arrested?
Yes.
I have no further questions.
Redirect, or in other words, follow up to that.
nothing further for the detective, Your Honor.
All right, thank you, detective. You may step down. Defense, please call your next witness.
I would like to call DA Sarah Sadowski as a witness, Your Honor.
Not allowed. Anyone else? Does defense rest?
Just a second, Your Honor.
I've already explained procedure relative to when I'll take that motion. Does defense have any other witnesses to call?
No.
Okay, so for the time being, defense rests. Subject to rebuttal, is that correct?
Yes.
Okay. All right, thank you. Does state have any rebuttal witnesses? No. Okay. So members of the jury, I'm going to release you for a extended break, plan for about 30 minutes. There's some things I need to take care of, and then we'll bring you back when we're ready. Okay, I remind everyone this case is not concluded. Do not talk about the case and do not conduct your own research. Do not post about it. Okay, thank you. Mr. Olson, motions, if any.
Yes, I have it's a motion to dismiss based on many issues and for a mistrial, and requesting an investigation into the phone download specifically and prior to the end of trial.
There, and
Right.
I'm gonna try to direct you a little more and give you free range because I allow you to do that yesterday. You wasted a lot of time. You have two motions before me. One is for dismissal, and this dismissal I imagine is related to the close of all evidence. And so what's your basis for the dismissal, your motion for dismissal? And I'll remind you that at this point, it's sufficiency of the evidence. What's your basis for your motion for dismissal at the close of all evidence?
So besides this one, and
Okay, let me break this down. The way I understood what you just said is that you have two motions, one for dismissal and one for mistrial, correct?
yes, they're together. They're together in one motion.
I'm telling you to separate them. Okay, so there are two motions. There are two asks of the court. One, you're asking me to dismiss the case, and two, or in the alternate, you're asking me to declare a mistrial. Correct? Those are the two things you're asking.
Yes.
Okay. Now, as to your ask that I dismiss this case, what is the basis for that? And I remind you that it's sufficiency of the evidence. So let's hear it. What's your basis?
Okay, so the for count 4 again. I'm entitled to face the injured party, and I've looked this up. And caretaker, she claimed to be caretaker of her brother. That does not constitute ownership of the property. The injured party claiming damages or injury has to be present. That I have a right to face my accused under the 6th Amendment of the Constitution, and that person was not available in trial, was not ever able to be questioned. And again, I did ask his sister if she was ever owner of that property during that time. She was not. She's not power of attorney, anything like that. She was only taking care of her brother. That does not constitute ownership of a dwelling, and therefore those charges must be dismissed. I'm also, there's numerous, I wrote everything in a motion so I wouldn't take up the court's time in this manner, but there are numerous issues here that are extremely important that I think that the court needs to look at. I believe that there should be a completely separate hearing on the complete Brady violation, as when I did get time.
I'm going to redirect you. Sufficiency of the evidence. Okay. Stick to that. Given all the evidence that's come in, because both parties have rested, how is the evidence insufficient to sustain these charges so that the jury may deliberate?
So there.
You've explained count 4. What about count 1?
Count 1, there's no proof of any kidnapping.
Okay, and then count 2.
Okay, also on count 1, there's no proof that me and Betty Helen were not together and that we did not know each other.
Count 2.
Count 2, there's no proof of intent of using someone's card without their consent. In fact, it's just the opposite. We were together the whole time.
3, obstructing an officer.
There's definitely no proof of obstruction of an officer.
And then you spoke up about count 4 already. What about count 5?
So on count 3, I want to add that I was actually tased while going to the ground, and this would have been shown on the video. I've never been.
No commentaries.
Okay. And go ahead.
5.
And count 5, there's no proof that I did not know the defendant, and unfortunately, I was not able to testify to the fact that I stayed in that RV for quite some time.
All right. Now, give the state a chance to respond, and also the state has their own motion. State.
Thank you, Your Honor. I think that there was sufficient evidence to allow all charges to go through. Betty's testimony alone covers counts 1 and 2. The officers counts 3. Counts 4, possession of property under 971.33. What's sufficient? It's that sufficient that at the time the crime was committed, either actual or constructive possession of the general or property of any part of such property was in the person to be alleged the owner of. We had Christine Endell testify to the fact that although not the owner, she was aware that no one was going to take the property, did not have permission to take the property, and that she was watching the property while her brother was incapacitated. And that is also constructive possession of the property. So I think we have that covered as well. And regarding count 5, I think that there was also sufficient testimony that Mr. Olson didn't have the right to take or remove or be in any of the garage. Or I'm sorry, count 4 was the RV, right?
That's correct. The
Yes.
motorhome trailer.
Count 4 was the trailer. So please
So
switch.
count 4 is the building.
Okay.
And then count 5 is the motorhome, the
Count,
RV.
count 5 is the motorhome. He didn't have any right to be inside of the motorhome or take the property out of the motorhome.
All right. Again,
yeah.
as I indicated at this stage, with respect to motion for dismissal, it is sufficiency or insufficiency of evidence. I haven't heard the arguments of the parties. I'll start first with count 4 because that's where Mr. Olson started. But I agree with the state that given the evidence thus far, at a minimum, it is sufficient relative to the legal definition of ownership or possession. Thus, that count, there is sufficient evidence to move it forward. With respect to the other cases, Mr. Olson may disagree with the evidence. He may disagree with what the witnesses said, but that doesn't mean that evidence doesn't exist sufficient enough to submit the case to the jury. For all those reasons, motion by defense for dismissal is denied. Mr. Olson, now I'm going to direct you to your other motion, which is a motion for mistrial. Please place on the record your basis for mistrial. And I'm going to give you 5 minutes for that. Starting right now, it's 10:06. It is your motion, so I'll let you have the last word, but 5 minutes for you to put on the record your basis for that motion.
Okay. I believe the entire case should be declared mistrial because of the Brady violations. The 3 flash drives that I was given, or my attorney was given, I was given 1 by Attorney Bastion, 2023, and 2 here, and Attorney Watley can testify that none of those would function
Mr. Olson, I'm
properly.
going to interrupt you here for a minute, but you yesterday or the day before, this week is becoming a blur because of this whole entire circus. You already brought up your motion, and I entertained your motion for mistrial. Given everything that's transpired since then, is there new information to add to what you already made me aware of that I relied on in making my decision, which was a denial of your motion for mistrial?
Yes, I found on those drives since then that they won't open up because there's like some settings that were set on there for permissions, which clearly indicate malicious intent by someone, whoever made those files. And I could not open them up. So therefore, I have now, with the help of Law Library, enclosed them in an envelope so that they can be analyzed by DRP security services, who will analyze them to see how and when they were set up to the fact that I couldn't view them and that there were things removed and blocked, and so there will be time stamps to prove that this was done prior to being given to me and therefore violated my right and is a complete Brady violation.
But I thought that in court, in my presence, Attorney Wasowski gave you his copy of the disc. So what you had was Attorney Wasowski's copy, which in court, in my presence, the state opened and was able to open the Cellbrite download on her laptop. And again, it's a laptop, not a desktop.
Okay, so Attorney Wasowski just gave me his copy on the 4th day of trial, and when I took that back, it would not open their. So this is the problem with permissions, and I'm just recently finding this out from people who are experts in this type of thing, that it can be set so that it will only open up on certain laptops, not everyone's. So only certain users can open it. So when she opened it up on her laptop, not his, it's because there's permissions set for her to open it, not anyone else. She never opened up any one of ours. And the 2 that I've been given, the two that we were given before trial wouldn't function, and Attorney Wasowski testified to that. And that is what is important, that I did not have discovery before trial. That is a clear Brady violation and should be automatic grounds for dismissal of all charges.
Your next basis for mistrial.
And I was not allowed to access case law to provide for my motion yesterday. I was only allowed access to my flash drives, not the law library, which has been taken away from me from the tablet that I normally have in the jail.
I believe I heard that already. Continue.
Okay, all right. So I need to re-add that 8 of the 12 jurors have talked about my case in the library. I'm sorry, near the elevator and near the stairwells, all through the hallways. And I've continued to be brought through the front of the courthouse instead of back routes, which normally are taken any other time I've gone to court except trial. DA Sadowski is also communicating on.
Okay, continue.
So DA Sadowski is also discussing a case on her phone with friends, family, etc. in the middle of trial. From what I am also, let's see, and because of this juror misconduct, they are now all aware that I have requested mistrial for juror misconduct, because this has been all over the news, and this has definitely prejudiced the jury against me. It's poison jury. I can never come back from that.
Okay, time's up.
You didn't let me finish, though.
I told you how much time
you
had.
interrupted me. There's one here for judicial bribery.
I'm going to remove you from the courtroom for 15 minutes.
There's judicial bribery here going on.
One more warning, and then you will be removed, because that I haven't even kept count.
You didn't let me finish my motion.
I cannot tolerate your disruptive behavior anymore. I've made this sufficiently clear before we started and shortly after we started. Okay. Now I gave you enough time.
Didn't let me finish.
Okay. Let's remove Mr. Olson, and we're going to
DA
continue.
Sadowski is bribing the judge, and
Right, Mr. Olson.
this needs to be investigated by the FBI.
Oh, I'm sorry. We can't. Okay. We're back on the record outside the presence of the jury. With same appearances before with state and standby counsel as well as Mr. Olson. We've now reached the jury instruction conference and preparation of the verdict forms. I've already days ago provided a draft, and again, the emphasis then was that it was a draft of the jury instructions. With respect to the jury instructions, I don't recall exactly what I did.
I'm going to skip this bit, but I'll talk about jury instructions. I know some of it might be funny and stuff, but I just can't be asked.
At the time of entry.
Oh, she's reading them all now, so I can't be asked either with that. Here we go. These are closings, I believe. Here we go.
Thank you. Ladies and gentlemen, I believe I started my opening statements this way by thanking you for your patience in advance. And I renew that thanks now as we are here on a Saturday. I truly appreciate all of you paying attention and being patient through these processes. What a closing argument is just that, an argument. What I get to do now is summarize the events as they occurred, as the testimony showed, but in a way to draw it all together. Because again, this trial started on Tuesday. We didn't get to too many witnesses on Tuesday, but here we are on Saturday. One caveat, just like I gave at my opening statement, if you remember something differently, you are to go off of your recollection and your notes. You all had notepads again. They're taken away during arguments because what I say is not evidence. Again, if the law that I say is also not the same as what the judge read, the judge is going to give you a binder at the end of this. So you can refer back through anything. There's a lot of tools and tricks in there to figure out how to go through this process. So you get that entire binder at the close of evidence in order to start your deliberation. So I always like to put the ground rules on first. And then now let's talk about the state of Wisconsin versus Timothy Olson. Ladies and gentlemen, this was Betty Hanel's worst day of her life. You heard her say that on the stand. You heard her talk about what happened. She talked about how it now appears in her nightmares almost every night and why she's able to remember what happened in pretty good clarity, considering it's been 3.5 years and she is 82 years old. She talked through the details of what went on when she was awake. She stated she was in and out of sleep. She stated that she was driven around the city. But let's talk about how we went through and corroborated what Ms. Hanel said, right? First, you heard from Michael Four. Michael Four testified he was in custody. He admitted that. And he said he saw Betty waving from her car. He stopped and talked to Betty, where she was talking about how she was kidnapped, how she was held at gunpoint. She went through that process with Michael Four. You then heard from Edwin Roman. Edwin Roman just found a phone in the street. He found a phone in the street. It wasn't broken. He got into it. It was in working order. He tried to find the owner, couldn't find the owner. And then finally, the Greenfield police officers called him, specifically Police Officer Garrett Olson. Garrett Olson was one of the initial responding officers on the scene. So back on Wednesday, we heard from Garrett Olson. He responded to Grandpa Frank's, 3033 South 108th Street, talked to Michael Four, found the phone from Edward Roman. And everyone at this point was just trying to figure out what went happen. Again, some age bias with these officers. I think that was pretty apparent because they were sitting there talking about how she was just a confused old lady at first. But they still investigated. They then got the Franklin officers involved who appeared on scene. Franklin officers appeared on scene. We heard from Ms. Hannell pretty early on in this trial. Ms. Hannell, one thing, she told you she was 82 years old. I don't think there's any necessarily dispute that she seemed to be an older person. She walked in here with a walker. But sharp, was able to tell you that story, was able to go through those details, had very precise language about what she heard and what she saw. The credibility instruction that judge read is one of the ones that I would like to point out. Who here has something to gain or lose? Who here had precise knowledge, at least to the extent that she was able to recall when she wasn't being potentially forced to drink liquor in a bottle? Who here, 3.5 years later, was able to talk through what happened? Think about that as you're going through all of these events. She was caring for her brother, went to Casa de Giorgio because she had a troubling time with her brother for one glass of wine, which was her usual, and to read on that notebook that was found in that backseat of that car, right? Corroboration of what she said. It wasn't just any book. She remembered the notebook. She remembered the one glass of wine. The Chardonnay bottle. She said she only drinks Chardonnay. Chardonnay bottle found in her car unopened. Where does all this corroboration lead to? So she goes, she sits at the bar. She talks to Mr. Adrizi, the owner of Casa de Giorgio. She talks to him briefly, some small talk. She's known him for years. She's been going there since before her husband died. And then this individual, Mr. Olson, who she picked out in court, comes up to her and sits next to her at the bar, offers to buy her a couple of drinks. She says no. It appears to Mr. Adrizi that they're having some sort of conversation. He's working, though, bartending. He talks about another person in the restaurant. Going through this, when they leave the restaurant at the same time. And again, think of the different perspective of those individuals that testify. Is this an inconsistency? Or is this Rex Adrizi was bartending and he followed her out so it looked like they left together? Think about that. You, ladies and gentlemen, get to bring your common sense and experience in the door with you. You don't have to leave that out in the hallway somewhere. You didn't have to leave it at home this morning. You as jurors talk to people every day. You determine whether or not someone is lying to you every day. You determine the believability of people every day. You get to take that back with you into that jury room and use it. Don't leave that common sense at the door. You talk about this. Ms. Hannell then states she gets into the driver's seat, and then you saw her motion, hand in the pocket, like there was a gun. She admitted she never saw a real gun. She was terrified, absolutely terrified. Mr. Olson went from being kind and friendly to vicious. Ladies and gentlemen, one thing you also get to take into account is the demeanor of witnesses in this case, what they looked like when they testified, their reactions to questions. Don't ignore that either. You don't just have to take words. What they looked like and how they sounded is also very important in this case. Ms. Hannell talks about being made to urinate in an alley. Just to bring this up right now, I'll circle back to it later, but Mr. Olson also testified about that. Testified that she had to go right now because you know how women are. And then he also testified that, well, after she went in the alley somewhere on the north side, they then went to like maybe a Chili's or Applebee's down on the south side. So while he made her pee in an alley, excuse my inelegant language, they also then went, after that to some sort of Chili's or Applebee's on the south side. That was still open, but yet everything was closed. Just how that testimony came apart, again, ladies and gentlemen, the believability of that is for you to decide. Ms. Hannell testified too that her purse was maybe taken. She didn't know. She was a little bit confused about that, but she knew her credit card was taken and she knew her ID was taken. We heard from Officer Andre Nemish. Officer Andre Nemish was the person that talked to Ms. Hannell first. You saw his body cam. You got to see the demeanor of Ms. Hannell at the scene. You also got to see how she was moving. Remember Mr. Olson also testifying that she could walk just fine? You saw that video. I'd also like to say this is Exhibit 102. 102, I don't know if you can all see it, but again, as the judge said, if you want it, you can ask for it in the back. Exhibit number 102 shows a lovely pink cane. So clearly she was walking fine and that was just a decorative device left in the car, probably by Mr. Olson, right? So, ladies and gentlemen, think of all of this again, the credibility of what went together, going through all of this. You heard from Robert Hannell, again, talking about the demeanor of his mom at the time, what she's like, how she's certainly able to be around and lives on her own still. That's great. She knows what's going on. We discussed Mr. Adrizi a little bit, so in interest of time, I'll keep moving forward. Officer Friedbacher conducted that photo array with Mr. Adrizi, who also picked out Mr. Olson, signed that back of that photo, even though he had never seen him before in his life, was able to pick it out of that photo array. Officer Mark Hernan, heard from him. He also responded to the scene. He observed Ms. Hannell to be confused and sleepy, found the car keys under the front seat, and she stated to him that the drinks in there were not her own. The officers. Then when Mr. Olson saw officers a few days later, he ran. What did he run with? And I think what's important to discuss too with this is that when he ran, he had a bicycle that was taken from that garage, that building. Again, these jury instructions have a lot of legalese. That building is a garage. He also had those items from that motorized home, that RV vehicle that the Schusters testified to. The shampoo, the e-bike key, that is a motorized vehicle. So, and the personally identifying documents, card, The judge mentioned card used to buy things, credit cards. So there's a lot of legalese in these jury instructions to cover a lot of the elements. So again, make sure you read those when you get back there. But I think what we need to point out here is that he ran. He saw officers and he ran. He didn't say, Betty and I know each other. He ran. Let's go through this too. Detective Zaleski downloaded her phone. No evidence in the phone that they knew each other. Some Google voice messages that the defendant testified to, and that he talked about that while she was sleeping sometime in the middle of the night, Ms. Handel also created a Google voice account to find out where the defendant went and try to ask him to come back. That's the testimony that was put on the stand. Ladies and gentlemen, how feasible is that? How realistic is that? One thing in the photographs that were put into evidence of everything that Mr. Olson had on his person, those deep pockets, officers talking about how things were falling out because they couldn't find everything. One thing that wasn't found on Mr. Olson was a cell phone. Going through all of this, finding the map that goes through all over the city for almost 16 hours in every inch of the city in no discernible path. Talking about the burglaries that happened in near the area where Mr. Olson was arrested, very close together. Everything here was extremely close together. And then some more corroboration. We heard from 2 crime lab analysts. Melissa Groff talked about the fingerprint. Ms. Molly, this is one of the things too that corroborates what Ms. Handel said. She was forced to drink from those bottles. They were shoved to her mouth. It wasn't just Ms. Handel's DNA that was found on the lips of those containers. It was also Mr. Olson's. Mixture of those 2 DNAs. Ladies and gentlemen, Mr. Olson's testimony too, he wants you to believe that they were friends. He wants you to believe they had this relationship. He said that they were there for they knew each other for a couple of years before November 2022. Ladies and gentlemen, a couple of years before 2022 was 2020. So he also wants you to believe in sometime during 2020, they met while he was an Uber driver and a nearly 80-year-old woman was just out for 2-for-1 burgers. I remember 2020. I don't know if you remember 2020, but I'm pretty sure most restaurants were closed during the majority of 2020. Think of all of this. Think of everything, ladies and gentlemen. When you go back there, read the jury instructions, go through the elements. And at that time, ladies and gentlemen, I would ask that you fill out those guilty forms. It is my burden of proof. So Mr. Olson will go next, and then I will have a chance to get up here one more time. So I thank you again for all of your patience, and I appreciate your time. Thank you.
Okay, here we go. Strap her in, ladies.
Okay, Mr. Olson, now is your time.
Okay, hold on.
And your clock is starting.
1 second, please. My closing argument is in my paperwork that has been disheveled. It's in the back with the rest of my documents.
Clock is starting.
Oh my God. Where's that?
Oh, fucking hell.
So, as I stated, I never denied knowing Betty Handel or being with her. So all of the evidence found that places me in cars irrelevant. As Rex stated, and I thought he testified pretty well, even though I was trying to pay attention. I was a little incoherent at the time from some other issues. But anyway, I did hear Rex and Attorney Wazalewski informed me of some of his testimony that he did testify quite well on my behalf as well. As he stated, we left together and we spoke. Me and Betty spoke for almost an hour at the bar, unlike what she had claimed, just for a minute or two. And to rebut what the DA said, sometime within the 2 years before 2022, it wasn't during the time that she claimed when COVID, where everything was closed. But there is a place that Betty goes to. She's the one that, when I arrived there, told me about the buy one, get one burger. I thought that was funny because you buy.
Actually, not in evidence.
Okay, sustained.
I did.
Was not in evidence. Continue with your closing.
So, as I had stated in my testimony, I talked about meeting Betty at this restaurant bar. And as I had stated, Rex clearly noticed my demeanor at the restaurant and that I was well dressed and well mannered. I'm never a vicious or violent person. Anyone that knows me knows that. We left together, like I said earlier yesterday. When I walked out, I was going to go get into the passenger seat, but her door flew open all the way and she couldn't shut it, so I went and shut it for her. So if there was a camera outside, this wouldn't even be here right now. As a detective testified, he didn't even bother to investigate camera footage, and it's such a serious allegation. I mean, there's no footage of anything that would resemble a kidnapping. I asked the detective if he would turn over his version of the phone download so I could have it investigated even by the FBI. Why wouldn't that have happened if there was nothing to hide?
Objection. I'd ask that that last sentence be struck.
Well, to the extent it's posing it, I'm going to just allow it. Let's continue.
I also asked for all the photos that he had to be turned over of the car so that, because there was one missing, he denied to do that. Why? This is very odd in such a serious investigation. My interrogation was not used, which if anybody watches like 48 hours, that's pretty rare.
Objection. Not in evidence.
Sustained. Continue.
The detective perjured himself on the stand numerous
Objection.
times.
Relevance.
To the extent this is posing, I'll allow it. Continue.
Am I going to get more time for these objections?
Continue, please.
As I said before, the detective didn't thoroughly investigate this for a reason, because he knew as well there was no crime committed. There was more evidence that this was not a crime. As I testified, me and Betty went to several locations, and I even went into stores on her request to get things, fill up gas in her car. She gave me a birthday card, a Thanksgiving Day card. She gave me some money when I first entered the car. I knew many things about her personal life because she shared that with me over time. Oh, and as far as using the bathroom, like I said, that I testified to, the gas stations in those areas don't have bathrooms that are open to the public usually. So she couldn't wait to go anywhere else, and that was all that was. It was very odd to me as well, but and I really need to stress about requesting the original phone download from the detective, because as I stated before, that the Google Voice, and there was text from Betty to me asking me where I was, if I was coming back, and I've stated that from day 2. I called the media.
Objection. Not in evidence.
Continue.
What?
Finish.
I called the media and let them know about this text and my innocence on day 2, Channel 12, and another reporter.
Now the objection is sustained.
All right,
That was not in
okay.
evidence. Continue.
There's no evidence of any that I physically restrained anyone, and there was no. So I know in here it states that the. Oh, just because there's a reasonable opportunity to escape doesn't change confinement. There was nothing to escape from. I'm not a violent person, and I would never mistreat an elderly person that way. I'm very close with my family, my mother, who is, elderly as well, and that's just absurd that I would be charged with something like this. I spent many time talking with Betty about my son, grandchildren. This is a very serious charge, and I would hope that you would all look at everything and know that I'm not the one lying. There's things that were lied about, and I've tried to get this out for quite some time. I would also just like to state that you all can make your own decisions regardless of what these court rules are or any other rules they put in front of you, especially my right to have a fair trial, which was completely stripped of me.
Objection, Your Honor. Arguing for jury nullification.
Sustained. Do not do that, Mr. Olson.
Count 4, which is the burglary of the alleged burglary of the garage. In order for there to be a crime, in order for a crime to exist, there must be an injured party. And since the injured party was no longer with us and no longer able to be here, that one's a no-brainer. It's even though his sister came, she's not the lawful owner. It has to be the injured party.
Objection. Misstates the law.
Sustained. Do not mistake the law. Continue.
That is consent to the lawful possession.
No commentaries.
There also has also has to be an intent to steal. There's no way that anyone can look inside someone's head and say they intended to steal. So just on those grounds alone, it's just virtually impossible for a jury to decide that. As I wasn't able to testify to that, but I believe I spoke to question Detective Zaluski about this. I did know the owner of the RV, and I was in that area for quite some time.
Objection, not in evidence.
Well,
So overruled. Continue, please.
I was not allowed to testify about the other counts. It's also a violation of my right to a fair trial. So I can't discuss any of those points. Is that correct?
The court cannot give you guidance on what to say at closing arguments.
The court could take away my rights. As far as the obstruction, I believe I questioned him about that. There was no obstruction. I started to get on the ground. An officer came up behind. I've never been a violent person or one to resist like that. So he tased me in the back of my arm while I was getting on the ground, or while I was already on the ground, which surprised me. Luckily, it didn't do too much damage. It just kind of shocked me a little bit. But there was definitely no obstruction, as they told. Too bad there's no video, or else you would know that for sure. And if there was any video of more, if you would have done more investigation, we wouldn't even be sitting here. I've sat in this courtroom trying to fight for my rights. I really need to emphasis on count one and count two. Count two, there's no intent of anything. Count two with the misappropriate use of ID. She was with me. She let me use the card. As I stated in my testimony, she gave me one of the cards to use to go inside, which was why when I got out of the car and left abruptly, I still had that card with me. We were supposed to meet up anyway later on in the day, as I had also stated in my testimony on Thanksgiving after she met her brother at Mater's. I have to stress on count one. This is very serious and something that I believe is just absolutely ridiculous. And there's no evidence of me forcibly restraining anyone or anything like that, because it just didn't happen. And this is why Detective Zaluski did not properly investigate this. If I was an officer and I was investigating a crime like this, I would make sure I got all the videos so I could see if this person was injured, harmed, what else was happening, to see if there was a gun, something. I mean, that really goes to show a lot. And I have to restate the text in the Google Voice. If this would have been investigated by this detective, he would find that it was Betty Handel's account, and I don't have passwords to her account. It's pretty easily investigated, and that's not me. It was also clear that Detective Zaluski was avoiding talking about the phone download. There's a reason for that, and the reason why I stress this. This is one of the reasons why I'm representing myself, is because no one would go after these texts or subpoena Betty Handel's phone records, which would have easily shown there's a text missing from the phone download. I tried getting this for almost 4 years. And
In relevance and not in evidence. Sustained, and that's correct. Continue on.
Oh, and Betty at that time was not using her cane. She didn't bring it into the restaurant when we were in Casa de Giorgio. So it was in her car. I noticed it as well. But she didn't use it. She moved around quite easily. So the items that I was found with is clearly not something someone would enter somewhere to burglarize for. This is where like gold watches, or this is, you're talking about like a pack of Skittles and some marbles. That's not what the items were. But I'm just saying this is ridiculous. These charges are all absurd. Again, the amount of things that I knew about Betty's family and past, and I could have only known by knowing Betty. That she had power of attorney over her brother's affairs, or her sister embezzled money from her brother because he was sick of, I'm not sure what was wrong with him, but and then she had passed away, and she was younger than Betty. She made that known that the sister was younger, and that she had already passed away. for such a serious allegation, I'd like all of you to think about some of the things that, some of the testimony that was back and forth. I slept all night. I was up all night. Or Detective Zalewski claiming that I claimed I was Wes Erdman and then recanted his statement. I'd like all of you to use your common sense as well and realize who's lying here. And I'm not even referring to any of the alleged victims. They're clearly hiding things. And you can tell from their facial expressions. I've also like all of you to know that I've contacted the FBI to investigate some of these matters, and I did state this on the record.
Not in evidence.
Correct. Not in evidence. Move on. Time's up. Okay, stay closing. I mean, your last word on the closing.
Thank you. Ladies and gentlemen, just briefly. Be such a nice guy, you left a 79-year-old woman on the side of the road without her cell phone, waving for help after an argument, but he never is angry. Ladies and gentlemen, just think of everything. Think of this case as in total. I think the one thing that Mr. Olson and I might agree upon is that this is serious. You need to make sure you look at the instructions. You need to make sure you evaluate the evidence. You need to give the time which it deserves, go through those jury instructions. And just think of things like the jury instruction you'll also get. It's called the burden of proof. You are to search for the truth. You're not to look for doubt. You are to search for the truth. So the last line in that jury instructions, and ladies and gentlemen, just remember the evidence. Remember Mr. Olson giving a fake name at the time he was arrested. Remember Mr. Olson being arrested with that credit card of Betty. Remember all of these small little details that draw the witness's testimony together. And then I would ask that you would find him guilty of all the charges. Thank you.
Members of the jury, you are to decide this case fairly and impartially, without fear or favor, and without passion or prejudice. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdicts are matters for the court alone to decide and must not affect your deliberations. The following forms of verdict will be submitted to you concerning the charges against the defendant, Timothy Luther Olson, Jr. One reading, we the jury find the defendant, Timothy Luther Olson, Jr. guilty.
So I think from the time that they left to the time that the judge came back on record was about 40 minutes, I think. So the timestamp is 3:45. Say they left and they came back. The judge came back in a 4:23. Well, 22, 23. So it was about 37 minutes.
That these are, in fact, your verdicts.
We the jury find the defendant, Timothy Luther Olson, Jr. guilty of kidnapping, seizures, or confined responsibility, and starting company.
Guilty. If you can't hear that because it's very quiet, guilty.
We find the defendant guilty of kidnapping, he must answer the following question. Did the defendant commit the crime of kidnapping against the person under 60 years of age or older?
Basically guilty of everything. So I'm going to stop that there because I'm going to go to sentencing because I think you can hear again. You can't hear that properly, but he was found guilty. From the time they left to the time they came back was about 35 minutes. So imagine it was less than 30 minutes because he would have had to be brought up from the cells as well. So sentencing. Let's take a look at sentencing then. Everybody. Right. I might have to skip some of it. Yeah, the court's lovely. That's why. So we couldn't hear that. That's why I've jumped to sentencing. You can hear this a little bit better.
Appearances.
Sarah Sadowski appears for the state. Good morning.
Timothy Olson in custody pro se, was in the courtroom moments ago and is now in the holding cell or bullpen area. Attorney John Wasilewski appears as standby counsel.
Good morning to everyone. Before the case was called, Mr. Olson was brought out and seated at defense table. I could see and hear that he was talking to standby counsel. And so I allowed that to continue without calling the case. The court then inquired if more time was needed. The intention would have been if more time was needed, it would be more appropriate for Mr. Olson to be taken back to the bullpen so that he can have, he can continue his conversation with standby counsel. Mr. Olson then responded without invitation of the court. It wasn't meant to invite him to respond to that. It's just a matter of the court determining logistics and timing. And so Mr. Olson, being disruptive, was then ordered to be removed from the courtroom. And he, on his way out, proceeded to continue to talk despite the court's order that he not say anything. My question, though, Attorney Wasilewski, in that Mr. Olson has prepared additional motions. If you could just take a look at it to see, from what you can tell, what type of motion it is. And the question is whether it needs to be addressed by this court, if it's a matter more appropriately to be.
I'll just skip some of this because
Person in custody. Standby counsel John Wasilewski also appears.
I'm objecting because my microphone is off, just like she turned it off during trial, so I couldn't object.
Mr. Olson?
I'm objecting.
I'm gonna, okay. This is the second time I'm trying to have this case called. If you interrupt me, I'm going to have you removed, okay? This case proceeding is not for you to control. I've already explained that, okay.
I have to be
No,
allowed
Mr.
to
Olson?
speak, Your Honor.
Okay, we're gonna have you removed until you can comply with the court's rules of decorum, which you are aware of. Do not speak over one another. You are to wait until the court asks you a question. We can barely get through appearances.
You're violating my rights.
Okay. Remove Mr. Olson.
like you did
You'll be
throughout
given
the
another
trial.
15-minute break, and then if you can comply with the court's rules, you'll be brought back. It's 9:28.
You're violating every code of conduct you can think of.
696. Appearances again.
Sarah Sadowski appears for the state.
Hey, I'm
Timothy
grabbing the
Olson.
microphone. What are you doing?
Okay.
I'm going to ask that you ask your deputy not
Olson?
to assault me. I was grabbing the microphone.
Okay.
It's unnecessary.
Mr. Olson, you need to stop.
It's
You will be
unnecessary,
removed.
though.
Okay. Appearance, please.
Appearances, Timothy Olson appears in court, in custody, pro se, in person. Is it standby counsel John Wasilewski also appears?
All right. Good morning to everyone. This is the third attempt that the court is trying to have this case called. We finally got past appearances just now. It's now 9:57. I did have Mr. Olson removed at 9:28, so more than 15 minutes was given to Mr. Olson to calm down. Mr. Olson, I'm letting you know that if you fail to follow the court's rules of decorum and you continue to be disruptive, I will have you removed and you will appear on Zoom for sentencing so that the court can okay. I'm not done talking. I'm letting you know that your disruptive behavior, if it continues, will result in your removal. It does not prevent the court from continuing with sentencing, and I intend to complete sentencing today. You will appear on Zoom.
May I
All
speak
right.
now?
No, you may not.
Okay, I'm
Because-
objecting.
All right, Mr. Olson, I'm going to have you removed,
I'm
and
just
you're going to appear on
objecting.
Zoom.
Hey, can you make sure this either goes with you or goes into the file? That's this is the envelope full of the big flash drives that I have to have it analyzed.
We're off the record. Okay, so now that I know that, I do want to circle back and go to, I'm going to refer to them as document 170 and 171, but those are the two motions that Mr. Olson wanted to file on Saturday when we were in trial. They have since been filed. The 15-page one-sided or single-sided motion is document 170. The 2-page is document 171. I have read those motions, and Mr. Olson, you are the movant, and so I'll give you an opportunity to place on the record explaining what you're asking of the court and the basis you have for what you're asking, and you're to limit what you place on the record on that.
Objection, Your Honor. Lack of foundation calls for speculation. Unintelligible. I don't understand.
Go off on a tangent. You start talking about something else. I will mute you and then we'll continue. But I'm letting you know that your continued failure to follow the court's rules of decorum, including when the court directs you to pay attention and focus on what's at hand, will result in your Zoom being muted. Okay, so at this time, let's have Mr. Olson unmuted, and I want to go one motion at a time. The first motion is the 15-page single-sided motion, which I refer to as document 170. That is the white packet here. The other one is the yellow paper here. So let's start with the 15-page on white paper. As to your motion, Mr. Olson. Hold on, you have to be unmuted. We can't hear you, but I can tell you're trying to say something.
Okay, hello.
Yes, we can hear you.
So I would like to ask that those copies of those motions be brought back to me so that I can go over them, because I don't have copies of them. I was not able to make copies because of you placing me in a hole.
Okay, hold on. Yep, we'll bring it back.
I would ask that all
Mr. Olson, just wait until you have your motions. 15-page motion. What are you asking of the court?
I'm asking the court for a mistrial and to dismiss charges.
Okay, and then the support for that.
Well, the jurors were talking in the hallway, at least 8 of them in front of the elevator. They actually tried getting on the elevator with me. Several of them, they were all in the hallways talking about the case. Your deputies were talking about it. I know for sure Deputy Rivers was texting about the trial during the trial. This was on 3/11 and more days than that, but for sure I heard him talking about it then. Also, I noticed that the DA and yourself were communicating via cell phones during my trial with texts and calls. I was also informed by other clients of T.I. Thomas Fisher that the DA informed Thomas Fisher that she was bribing you to conceal the text and misconduct that she's been committing. And I'm asking that this is fully investigated by the FBI. All phones, yourself, your deputies, and the jurors, including Attorney Wasilewski, these phones need to be downloaded, and this needs to be fully investigated because this is very serious. And the text that it's generating exists, and the DA perjured herself on June 16th when she asked Attorney Wasilewski if he received the redacted version of the phone download, then claimed there was never a redacted version. And on, I believe it was October 24th or November 24th, the hearing in November or October of 25, the DA refused to answer what she gave Attorney Conradi on February 14, 2024, when she gave over the unredacted phone download, which the DA and the detective claimed there was no unredacted version and you couldn't redact or unredact. This is all one big lie, and it's provable by perjury committed by both of them during trial testimony and transcripts that I had requested. And DA Stelzky intentionally gave us flash drives that wouldn't open, and Attorney Wasilewski testified to this in court that he tried it on his computer. But these are because permissions can be given to open those flash drives on other computers or not given. This is why they wouldn't open for us and it would open.
Okay, Mr. Olson, I'm going to stop you there for a minute. In all fairness to the state who has to respond, or they don't have to respond, but they will be given an opportunity to respond. And having read your motion, you should not bring into your motion new things that you did not give notice to opposing parties. So to the extent that some of the things we're talking about are not contained as part of your basis or support of your motion, try not to talk about those things, okay? All right, continue and try to sum it up, because I'm going to move on and have the state respond. And when I do that, I'm going to have you muted.
All right. The deputies were purposely parading me through the hallways instead of going the back route. Any other time before trial, we never went through the front like that. But all of a sudden during trial, I'm being paraded through the front. Even during the medical emergency, I would walk out through those hallways with covered clothes. I was incoherent, and this is one of my main reasons for a mistrial. I was brought into the courtroom, and they knew I was incoherent from puking in the back. I had a seizure in the back when a different deputy, wasn't Rivers or Bruce, were back here. I had a seizure in the wheelchair. I was driving. They knew I was incoherent in the courtroom. I was not even able to object or respond because of the severity of the concussion. I'm not positive, but I believe on Wednesday, the 12th of March, during the third day of trial or second day of trial, I believe I had another seizure in the cell and made a head wound on the headwards, which is, this is when, Sergeant Goldborn took pics of my head wounds on
Okay, Mr. Olson, I'm going to have you muted. And now that you're muted, I'm going to invite the state to respond. In reading document 171, which is the 2-page yellow paper that you also filed, you provide mostly, if not all, the same basis for that motion that you did for 170. So I'm going to turn to the state and allow the state to respond as it relates to the motion to dismiss and or an alternate motion for a mistrial. To the extent that document 170, which is the 15-page, is addressed to Chief Justice Jill Krofsky and other entities and organizations, but other entities. But I think to the extent that it could be interpreted as a petition for supervisory writ, the trial court is not the proper forum for that. That should be filed under it should be filed with the Court of Appeals under 809. And so setting that aside, construing 170 and 171 together as a motion to dismiss or in the alternate motion for mistrial. State your response, if that makes sense, what I'm saying for the record. There's a lot of people who are named and many people who these motions are addressed to. 170, I think, could also be interpreted as a defendant's petition for supervisory writ. And to that extent, trial court is not the proper forum.
Right. And I was going to say, none of them necessarily seem to be addressed to this court either way. Additionally, none of these, Mr. Olson was able to verbally argue all of this in his motion at the close of evidence. So I think also these are untimely, even if we would have addressed them before the final verdict. So there's no new information here. This is untimely. It wasn't addressed to us. It's not the proper forum. It's after the judgment of conviction. And frankly, parties cannot make wild claims without any factual basis. And so I think that is also a reason that these should either be, that these should be dismissed or they can be filed for review upon a different court.
In trying to make sense of these motions, it's clear to me that Mr. Olson is unhappy with the trial court's decisions. And he's certainly entitled to be unhappy. As a matter of fact, many times people are unhappy with decisions of the court. But by no means does that mean that Mr. Olson can repeatedly ask the same court to reconsider its decision. And so I think another angle of this is that to the extent that Mr. Olson is requesting the court to reconsider its own decision, he doesn't provide a legal basis for which the court can do that. Many of the grounds or basis that he provides in support of his motions, whether it's document 170, 171, are basis or allegations that the court has already addressed previously. At milestones of this trial, Mr. Olson was invited by the court to make any motions of the court, and the court specifically at the close of the state's case in chief indicating that this is a sufficiency of the evidence standard, and then again at the close of all evidence indicating that it is sufficiency of the evidence. That being the case, the grounds for which Mr. Olson puts in support of his motions do not address the sufficiency of the evidence, but are more along the lines of his grievances towards the trial court, as well as anyone else who's touched his case, whether that involves prior counsel, standby counsel, or the state. And thus, these motions are untimely, and the trial court is the improper forum relative to document 170. And I think the court has more than on more than one occasion has been willing to entertain Mr. Olson's motions, but it has simply come to a point where enough is enough. This has just been another tactic of Mr. Olson to delay the court in closing out this case, especially now that we're at sentencing. And so for all those reasons, document 170, the court will, even if it's not construed as a petition for supervisory writ, that must be filed with the Court of Appeals. That motion, if it's construed as a motion to dismiss or a motion in the alternate motion for mistrial, denied by the court. For all those reasons, the court placed on the record, document 171, the 2-page motion also denied for all those reasons placed on the record. With respect to the unfiled motions, it sounds like to me, based on the description given by standby counsel, for purpose of the record, we can pull it in, but the court's not going to address it because many of those grounds and bases sound like the same grounds and bases provided for motion document 170 and document 171. To the extent that Mr. Olson can raise those issues on appeal, he may do so. But I think for completeness of the record, those motions can be received by the clerk, and the clerk may receive them file in the record, but the court will not address them for all those reasons. Okay, so now we're going to move on to sentencing. And State, are you complying with victim notification?
Yes, we have victim notification of all victims. There is no victim impact statement that the state is filing at this time or restitution request.
And just so we're all on the same page, I did go through the counts, and I'm confirming with you, State. count one is a Class C with an enhancer. By the way, I sentence in months, just so you know.
I'm sorry, what was that?
My sentencing, I do it in months, not years.
Oh,
just so
I
you know.
did not know that. So
Okay, but for the purpose of the record, because and to be consistent with what's in the information, count one is Class C with an enhancer. Initial confinement for Class C is 25 years, enhancer is 6 years. So the total initial confinement, the maximum is 31. Extended supervision is 15. The total imprisonment for count one would be 46. I'm just going over the maximum. Is that correct for count one? So it's Class C 25.
Yes.
And then the enhancer is 6.
Yes.
So that gives me 31.
Yes.
And then extended supervision is 15. The total imprisonment, initial and so the bifurcated would be 46. Did I get that right?
Yes.
Yeah. Let me double check my math. That's why I always like to do. Yes, 46.
But you would prefer
And
that
those are in years. So in months, that would be 552 months. So if we were to break that down into months, it would be the total initial confinement with enhancer is 372 months. Extended supervision is 180 days. And total imprisonment, the bifurcated imprisonment would be 552.
Yes, you just misspoke briefly. You said 180 days for extended
Oh, I'm sorry,
supervision instead of
180 months. Yeah.
Yes, okay.
There are no days. We do it in months here. And the reason why I do that is because the written explanation of determinate sentence, I can do it in years or months, but sometimes, there are no years. So it's just easier if I do it across the board in months. That's why I do it this way. It's not to try to, unnecessarily burden anyone, but it's just easier for me to do it in months because of the worksheet I ultimately have to use.
That's fine. I'm just doing some calculations myself. Thank you.
Okay. And then, so say you concur with the maximum as how I just calculated it?
Yes.
Okay. Then moving on to count two, Class H, initial confinement is 3, enhancer is 4, which takes us to 7 for initial confinement and years. Now, I'll first do years and I'll go 2 months, with exception of count 3, that's a misdemeanor, so we're not talking years there. Extended supervision will be 3 years, and so total imprisonment for the bifurcated sentence maximum would be 10. And months, that would be initial confinement 36, enhancer is 48 months, with a total of 84 months, and extended supervision would be 36 months, and then the total bifurcated sentence maximum would be 120 months. Count 3 is a Class A misdemeanor, 9 months. And then count 4, beginning with years first, 7.5 years initial confinement, 5 years extended supervision for a total of 12.5 years imprisonment. Again, that's a Class F. And then in months, that's 90 initial confinement, 60 extended supervision, 150 maximum for in months. And then count 5 is the same thing, 12.5 years maximum total imprisonment bifurcated, or 150 months total bifurcated, with a 90 and 60, 90 initial confinement, 60 extended supervision. Okay, so I think I did the math correct. State, do you concur with that?
Yeah.
Okay, and then Attorney Wasilewski, to ensure that the court is doing the math correctly, would you concur with all that as well?
I would concur with all the year calculations. I haven't done the month conversion, but the years were correct and I was following.
Okay. All right. So now that we all have that as a starting base, so that Mr. Olson, it's really for Mr. Olson's benefit, so he understands what the maximum is. But state at this time with respect to your sentencing argument.
Thank you, Your Honor. I just want to say one thing. I'm not going to talk about the facts of the trial in great detail. We were all here just last week going over the facts of the trial. But what I think is important to do is to fill in some of the gaps that were not talked about during the trial. And when I say that, for example, one thing that sticks out to me greatly was a discussion of why and some of the locations where Mr. Olson and his handler were driving around the city. Detective Zaleski and frankly, many other people in this community reached out regarding determining the identity of Mr. Olson. And so that is where I start basically this sentencing argument and why I think this is important as I talk about the seriousness of the offense, the character of the defendant, and the need to protect the public. As we all know, Ms. Hannell was now, we can say as the jury convicted, was abducted on the night before Thanksgiving in 2022. The next day, when she was recovered by police officers, again, this was a bit disturbing. The initial responding officers from Greenfield, and I've had discussions with them about this, truly did think for a moment that this was someone suffering from some of the more unfortunate effects of old age. But what we're all grateful for is that an investigation continued, that even Greenfield officers didn't just give up on this and walk away. As the story kept coming out, they realized that this something happened, and the investigation carried on. So the next thing that happened in the investigation was that it was determined that Ms. Hannell's credit card was used not just at 1 or 2 locations, but a minimum of 5 locations across Milwaukee County that were discussed again at extent during trial. The video that was obtained from 2 of those locations that was shown during trial, that was broadcast through other law enforcement agencies and via the media. The media was also interested in identifying a case in South Milwaukee, which happened on November 17th, 2022. That case in South Milwaukee had Mr. Olson and an individual who is now deceased walk into a bar together, a drinking establishment. And it was shown on video and on the media that this individual, the victim, or not Mr. Olson, female, lost consciousness in the bar and later passed away. That image was also being broadcast throughout the media at the same time. This led to several tips of the identity of Mr. Olson, as he was, for lack of a better term, connected to several crimes, alleged crimes, throughout southeastern Wisconsin and into northern Illinois in fall of 2022. Some of the facts in this trial that were discussed and then avoided: there was allegations of Ms. Hannell being on the north side with Mr. Olson due to the purchase of illegal substances that Ms. Hannell told officers. Ms. Hannell and my investigating officers were directed not to talk about that because I think that that was not charged, but that was some of the allegations why there were many, many stops all over Milwaukee County for no discernible reason for the trial. But I think that's important context for Your Honor to have. Now, mind you, Your Honor, I'm talking about things that have not been charged. So of course, I know that you will give them the weight to which they are due during this investigation. Additionally, it was discussed at the trial, Casa de Giorgio, where Rex Adrizi discussed Mr. Olson leaving without paying his bill. That was actually where several of the tips came from for law enforcement regarding the identity of Mr. Olson, as Mr. Olson had made a habit of going to an establishment, ordering a meal, and then leaving without paying. Many of these establishments, which was turned over in discovery, which, as you know, the state turned over a full copy of discovery, led to the identity of his face, of his features in these establishments. So again, this is all going to the character of the defendant and what he was doing. And I think that in this scenario too, he was realizing that he was closer and closer to getting caught, closer and closer to getting picked up by police, in which he was on November 29th of 2022. The other incident that I think leaves a lot of context out is, and was discussed briefly during the trial, was during the cell phone download. There were a lot of searches for Mr. Olson's mother's name, her in association with Racine Police Department, her in association with CCAP records. And that's because then on November 8th in 2022, Racine had investigated a death investigation because there was an individual that was found deceased in his mother's home after being out for a night with Mr. Olson. So this was another individual associated with Mr. Olson that ended up deceased in close proximity with meeting him and going out with him. And those are uncharged cases. Racine County also has 2 charged cases that I would also like to reference. These cases Mr. Olson has yet to make an initial appearance on in Racine County, but they are first case number 22 CF 1503. Your Honor, this was referenced. There are 5 counts of personal ID theft for financial gain, where again, the allegations are that the individual was an adult that met Mr. Olson online, ended up going out with him, ended up being what was described as roofied, and then having her credit card be used at a number, well, at least at 5 charged locations in this complaint. Additionally, in case number 23 CF 43, conduct that happened on September 16th of 2022, this individual, again, was out with Mr. Olson, complained again of being given something which altered her mental state. That complaint alleges a number of controlled substances in her system, which she denies taking, and she was sexually assaulted. In that case, is charged as a second-degree sexual assault of a person incapable of giving consent due to being under the influence or an intoxicant. Some of the allegations continued in identifying Mr. Olson. We had some individuals reach out stating they had met up with him regarding the buying and selling of illicit substances. It's just adds so much regarding his character, regarding the need to protect the public, regarding the effective rampage that Mr. Olson was on during this time frame. It's difficult to imagine how this could have happened over and over again. Additionally, Your Honor, there is one consequence that when we're in trial today, that when we're discussing the trial that happened last week, when we're discussing the victims from last week, there's one consequence that, to me, it's difficult to think about, and in a way that it doesn't come top of mind. And what I say about that is, as you know, Mr. Olson has an extensive criminal record, and I'll run through that briefly because I think it's important to have that during the sentencing argument. In 2002, he was convicted of possession of drug paraphernalia in Racine County. In 2012, theft in Kane County, Illinois. In 2009, driver-operated vehicle without owner's consent. In 2007, a burglary in Illinois. In 2005, resisting and obstructing in Dane County. In 2005, possession of cocaine or controlled substance in Dane County. A felony theft conviction in 2004. A forgery from 1997, where he was convicted in 2000. A felony theft in Kenosha County from 1997. An escape from 1997 in Kenosha. 2 counts of forgery uttering in Kenosha in 1994. And then when I reviewed it with carefulness his in custody time through Illinois and Chicago, it is clear that Mr. Olson has been spending his time in custody by the installment plan, not having much more of a gap in custody than like approximately 3 or 4 years, several years in a row. And while I want to talk about his conviction now, is I'm bringing up specifically case number 06CF5944 for 2 separate reasons. One, that case was discussed during trial because Mr. Olson stated, oh, part of that was concealed because of misconduct. Part of his character also goes to the fact that he doesn't believe that your court, defense attorney, or I can fact check or inquire as to what actually happened in that case. And while I think the reasons for that case being resentenced are appropriate for not being put on the record, it wasn't misconduct. It wasn't those allegations. And why I'm also bringing up that case is that our general DA mailbox received an email from the victim of that case, partially just discussing the trial as a whole, but partially discussing about the fact that even though this was 20 years ago and she thought she had put this behind her, seeing Mr. Olson's face on television day after day after day, for now, Your Honor, it's been almost 2 weeks since he first claimed competency that he has been on the news and on the media, and that she's sitting in her home and this ends up basically invading her living room, about how this brings up her past and how she is still to this day devastated, embarrassed, and ashamed and in shock that she could have fallen prey to this evil person. She's brave for still being here, for reaching out, for discussing that. Every victim, every witness that came forward in trial last week to talk about what happened, to talk about their story, is going to have those same effects for a long time. I think it's important to bring up because this victimization isn't just a one-time done. This lasts with victims, especially when they're taken advantage of in this way for years. And I think, Your Honor, that's one of the reasons why the need to protect the public is so high and why the seriousness of this offense is so high. And I would like to discuss now exactly what I am asking for in months from each of the counts that Mr. Olson was convicted of. For count 1, kidnapping, and Your Honor, just to be clear, I'm going to ask Your Honor for consecutive sentences for each of these counts. They are all separate. They all have separate victims, are separate crimes with separate types of motivations by Mr. Olson. While counts 1 and 2 are the same victim, they are very different crimes with very different consequences. For count 1, I'm going to ask for 264 months in custody with 180 months of extended supervision. Count 2, 36 months in custody with 36 months of extended supervision. Count 3, 6 months in custody. And for counts 4 and 5, I'm going to ask separately. So count 4, 60 months in custody and 36 months extended supervision. And then the same for count 5. Frankly, Your Honor, this is as close to what the state believes a case should be deserving of for a maximum sentence. And the only reason I am not asking for a maximum sentence is, one, because Ms. Hannell was allowed to escape relatively unharmed, even though it has taken her years and years. Well, frankly, she says she still has a nightmare every night. So that was her testimony. This is still causing her nightmares every night. So I guess physically unharmed would be a more accurate way to put it. And regarding the burglaries, those types of allegations Mr. Olson's faced in the past, has been convicted of in the past. The only reason I'm not asking for a maximum sentence on those is that it was not the primary residence that was fully broken into. Although, of course, with the Endell home, that is part of what caused Ms. Endell, Christine Endell, to have such trauma, is that she could tell that her home was attempted to be broken into. And that was an incredible violation of her sanctity, her security, and how she viewed that residence that her and her brother were able to take care of. Your Honor, I think that this is truly described best as Mr. Olson is one of the most serious people that this court could prosecute, taking a then 79-year-old woman throughout the city, causing her so much fear, as well as all of the surrounding circumstances, is why Your Honor should follow the state's recommendation. Thank you.
All right, thank you. We're going to need Mr. Olson unmuted. Mr. Olson, while the deputies come back there to unmute you, I want to let you know that there are factors for me to consider as sentencing. These factors include age, family, education, work history, and any history of undesirable behavior pattern or things that the court can consider relative to your character, nature of the offense, any mitigating, aggravating factor, and then also the need to protect the community, which may include the need to protect specific individuals and or the community at large. But I'm letting you know that so that when you make your sentencing argument, you are aware of what the court must consider in fashioning a sentence. Okay, so Mr. Olson, as to your sentencing argument.
Well, so first of all, I'd like to object to everything the DA said, if that's possible. Some of the history is wrong, and as far as that case from 2009 in Milwaukee, it was changed for a reason. There was DNA misconduct in my case, and the alleged victim never claimed that I stole a car, which is why I should have been charged. Again, if you look at the charging document, I was borrowed the car, we lived together. So that case shouldn't even have ever been charged. There was no crime committed, which is why that case went from 5 years to 3 months, and the judge let me out. I believe it was around 3 months, serving that 5-year sentence. He let me out immediately because there was no crime. So everything is being kind of it's being made to look as if it is more than what it really was. And as far as this case, I mean, I've always claimed my innocence, and that they're attempting to exonerate me. I'm not the person that they're making me out to be. I'm a kind, caring individual. Anybody that knows me knows that. I continue to do that in jail, helping inmates. They can't read and write, file grievances, file other numerous things just within the jail. Anybody that knows me can vouch for this. Unfortunately, I have nobody here today. This has been very difficult to defend myself, having 2-3 concussions in the last week. And I know help really from my standby. I was told he was going to be helping me and that he would take over for my trial if I couldn't go, but then wasn't allowed to do so. This has been very, very hard to defend myself. And again, anyone that knows me knows I'm a very kind person. This narrative you put out there is completely wrong. And as far as these allegations or investigations, I've never been charged with anything, but I did nothing wrong. And that the DA was bringing up from other counties. And I still have not been officially charged with these crimes and the racism that she's bringing up. And again, for these counts, I've always maintained my innocence, and I wish Your Honor would take a look at those unredacted phone download forms that were falsely filed, which proved that there was a text that exonerated me. I claimed this since day one. I don't know why anyone would make a claim of that sort. And the DA has perjured herself. So I hope you take that into consideration. This person should have been charged with filing a false police report, which is why they kept this text. The DA knows she could never win her case if she gave up this text. This is why I've asked the FBI to get involved to help me prove my actual innocence. And as far as these other cases go, I said I knew those individuals. I knew the individual that owned the RV, and I'm not sure, why I wasn't given more of a chance to testify, so I could be on my side of the story. I used to make deliveries to the individual that owned the garage, which is how I knew him, and I was not able to testify to that. I did Uber Eats deliveries to that individual, Instacart deliveries to that individual. There were numerous things I was able to testify about, which would have made clear more things about why I was how I knew them. But again, my innocence is I've claimed my innocence from day one. There are texts in this download, which is why she came out with another download. It's clear in the transcript, Your Honor, that she withheld the text. In January of 2024, Attorney General acknowledged receiving full discovery. And then in February 14, 2024, they revealed they had an unredacted phone download that contained text that pertained to my case. And this would also show the communication between my attorney and DA Olson. So I'm not sure why none of this was ever investigated by the OLR, the Judicial Commission. I've contacted so many people, and even the FBI. I'm asking the FBI to look into this phone download. So and her Betty's phone records will show that text is there, but no one would subpoena the phone records by motion number 11.
Mr. Olson, I'm going to interrupt you there because I've allowed you to go way off track there. I already told you what the court must consider as sentencing. And to the extent that I've already addressed your motions, try not to spend your time talking about things that really aren't relevant to sentencing. And even if it's relevant, it has probably very little, it's going to be given very little weight, okay? Because those are motions you can file on appeal, or issues rather that you can file on appeal. And so to the extent that the court's goal here as sentencing is to pronounce a sentence that, one, punishes you for what you've done and to protect the community, what are things that you want to argue on your behalf and make sure that I'm aware of?
Well, and that's why I was bringing up the alleged victim's phone records. If those simply would have been subpoenaed by any one of my 7 attorneys, that's one simple thing that I asked of my attorney. Can you please just subpoena for phone records since the DA is not giving us the complete phone download? And none of them would do such a simple task. I don't understand why. So this pertains to my innocence. This is huge. I mean, if those texts would have been handed over, or the phone record subpoena that shows that phone call is missing from the phone download, this blows the case out of the water. Oh, Mr. Olson's been innocent.
Okay, Mr. Olson, I'm going to interrupt you and remind you yet again, you can follow the court's rules relative to your sentencing argument. I think at this time it's proper for me to mute you and then proceed. So let that be your last warning, but please continue with your sentencing argument.
Okay, well, I mean, there's no reason to protect the public. I'm not violent. I'm innocent of these charges. Anyone that knows me knows I'm a kind and caring person. I'm innocent, so I guess I don't know how much of an argument I can make as far as what he sentenced me to charge a sentence an innocent man to prison. I haven't been in any trouble since for 10 years, and I know the DA brought up a case in 2002 that wasn't even mine. There was some cases that she bringing up in her mind, but I don't remember all of them, what she said. But I mean, I'm not someone that needs to be. The public doesn't need to be protected from me. I've been in the jail here 40 months. I have not one rule violation at all, and that's rare here. Not one fight, not one anything. Lock-ins are given here for any rule violation. I have 0 lock-ins in 40 months. I'm polite, courteous to everyone, just like I am out there. You know, some of my past 20 years ago, I did have some issues that were drug related, and I always owned up to those. And if I pled guilty to the plea, I did own up to those crimes, and I paid my debt to society. And even more so, I believe I was overly sentenced on all of those charges when parole was taken by Tommy Thompson and did more time than necessary for some of those crimes which were minimal. And I'm not trying to minimize the crimes, but compared to other crimes on that scale, yeah, I did a lot of time for crimes that I shouldn't have. And the escape that is on my record, that is a non-report to a disagent. It's not an escape from a facility or a jail. It is a non-report to a division of intensive sanctions agent. That was a very odd situation. I didn't report to my PO basically, and they charged me with escape. It was a very odd rule. But there's no need to protect the public from me. I'm a very kind person. If the news and the media has put up this narrative in the day that I'm this person that people need protected from, that is completely absurd. And if they knew me, anyone that knows me would testify that fact. Anyone in the jail, the people that I talk to in the jail, even inmates, nurses, the guards, you know, some of the guards might not like me because I fight for my rights, but they'll definitely say that I never call me foul and polite and courteous. So this narrative that's being put out is way off. And my son, my mother, anyone in my family, parents, uncles would testify to that. I'm a very good person. You know, and like I said years ago, yes, I had some issues with drugs. The charges, most of them are from 20 years ago. All that I owned up to, and I took responsibility for that, and I paid my debt to society. Doing 10 plus years in prison. I guess that's all I have to say. I would hope that a minimal sentence would be placed upon me because of my innocence. I mean, I'm not sure why Your Honor even never looked into it. I don't know if you can, but if you take a look at some of the transcripts and the fraudulent documents.
Mr. Olson, I'm going to end you there, okay? Because I think let's have him muted. Now, the other thing I do need to know is credit. Attorney Wesley, have you had an opportunity to look at credit?
Yes, Your Honor. It's my understanding Mr. Olson was arrested on November 29, 2022. He's been in continuous custody since then. I confirmed with Ms. Sadowski that neither of us know of any other sentences or revocations that would apply to any other case than this one. So I believe he's entitled to continuous credit from his arrest date to yesterday, which would be 1,204 days. And I have prepared a form indicating that, which I can submit to the clerk.
Yes, please. I'll take a look at that. All right, thank you. Okay, the credit worksheet, I have no reason to doubt the math is not correct. It looks fine to me. And then considering that Mr. Olson has been in custody since November 29, 2022, $1,204 days will be given as credit. All right, Mr. Olson, as I stated before, sentencing primarily serves two purposes. One, to punish you for what you've done, and the other is to protect the community. Now, the court is to consider the least restrictive means of punishment unless confinement is necessary because you have needs that can only be met in confinement, or if putting you on probation would unduly depreciate the seriousness of the offenses. There are factors for the court to consider, but not that include but are not limited to your history touching upon your character, as well as the nature of the offense, if there are any mitigating, aggravating factors. And the sentence should be sufficient to deter anyone else from engaging in those same conduct. Now, beginning with your history, you're 55 years old, you have a birthday coming up. So in advance of that, happy early birthday to you. You have a high school, you have an HSED, which you were able to obtain through the local community college. You have a history of substance use and abuse, which you stated as well in your sentencing argument. And during this trial, of course, I did learn that you are a father, and I believe, if I heard you correctly, that you're also a grandfather. But certainly, you're a father, you're a son. And I emphasize that because one would think that if someone has those type of relationships, that some reasonable consideration would be given to those in the public, in our community. You do have employment history, most recently working independently as an Uber driver. And with respect to your knowledge of and involvement with the criminal justice system, certainly you have a long history. To the extent that the state talked about other cases that you were not charged, Mr. Olson, the court will only consider it to mean that you are no stranger to the criminal justice system. Relative to the pending cases in Racine County, you're presumed innocent until proven guilty. Thus, there's no conviction in those cases, those pending matters. But to the extent that they touch upon your character relative to your experience with the criminal justice system, the court may and will consider it. Your history is quite extensive, and it is alarming that you have such a long history. You've done so much time in custody, yet your behavior, your criminal behavior, just doesn't cease. And many of these crimes do speak very poorly of your character, of you not being able to be a community member that the community can reasonably trust and expect reasonable behavior. And it's disconcerting. And because, in part, the crime for which you're being sentenced today involves an elderly person. And so your decision to engage in criminal conduct to inflict harm on others isn't limited to just the young and able, but you certainly have expanded that to the elderly and immobile. Your behavior throughout the pendency of this case, such as your refusal to accept court decisions, despite being warned and told numerous times that you may not like the court decision, but you can certainly appeal it. Once the court has made a decision, you move on. You refuse to follow those rules, as well as other rules. You continuously disrupt the court and your antics to achieve your goal of protracting this case. This case has been pending for quite some time. You went through 7 attorneys. And so not only are you a difficult person to work with in court, as well as by reading the lines, the fact that you went through 7 attorneys, but your behavior towards the victim during the time that you had confined Ms. Hennell. And so that takes me to the nature of the offense here. I'll first start with the mitigating factors, because there are actually some mitigating factors in this case. You did, as the state pointed out, allow the victim to escape physically unharmed. However, though, the psychological and emotional trauma you inflicted is without a doubt everlasting, as she herself testified at trial. The amount that were charged without authorization, without permission, I think in the big picture here, those amounts were not large amounts. Some of the items recovered may not have been returned to the victims yet, but nonetheless, they have been recovered. I believe the bike was recovered, correct, State? Because that's when law enforcement observed him with a bike. The phone was tossed along the road, and that was recovered. That's correct, right? And so to the extent that those items have been recovered, eventually, probably at one point, those items could be returned to the victims. And so it's not a total loss in that regard. So those are the mitigating factors. As to the aggravating factors, the victim here, one of 3 victims, but the first one, Ms. Hennell, she was 79 years old at that time. And I know that there was evidence that was brought in by way of testimony indicating that today her mobility is much more limited than it was back then. But nonetheless, she had limited mobility. And for at least 15 hours, you held Ms. Hennell against her will, without her permission. You held her captive, and you inflicted emotional and psychological trauma. The one thing that has stayed with me to this day is when Ms. Hennell testified and explained that during the time that she was with you, Mr. Olson, she thought about how to escape and whether she can escape. And for someone in that moment to know that the door is also close, like freedom is so close, but yet not within grasp. She couldn't trust herself that she could get away from you. That emotional, psychological trauma, I just can't imagine the depth of that trauma. But to this day, and through her testimony, that still haunts her. In addition to that, she, of course, herself testified that on a daily basis, she relives this incident and is able to recall this incident. And so the harm that you've inflicted on her is extensive, no doubt. I don't doubt that for 1 minute. But what was, I think what was disconcerting, and I think at a greater level, emphasizing the need to protect the community beyond the 3 victims in this case, is the fact that when you subjected Ms. Hennell to this harm, and she tried to flag down help, that the first person who saw her told her that that person cannot help her because they had a turkey in the oven. So she was turned away from help when freedom was so close, and yet turned away. And I'm sure that reinforced her belief that she could not escape. So it made it so much more persuasive why she felt so helpless and hopeless. Because in fact, at the end, she was refused help because somebody had a turkey in the oven. It's just beyond words, the harm that you subjected this victim to. And on top of all of that, you talk about your mother. Ms. Hennell is someone's mother as well. But that consideration you did not extend to Ms. Hennell. And that emphasizes how much how important it is, the need to protect the community, because you cannot extend that reasonable consideration to anyone else in the community but yourself. That puts the community at risk, and it puts the community on edge. You use the victim's phone, then you discarded it. You used the victim's bank card, and it was found on your person. You made purchases without permission, albeit I did count as a mitigating factor the fact that the amounts that were charged were more or less nominal, but nonetheless, you had no permission to use her bank card. You entered properties without permission. You damaged property in the course of doing that. You defecated in someone's RV when that RV had been winterized. All that takes time and money. And also, when law enforcement approach you, and I forgot the word exactly that the officer used when he testified, but I'll just basically describe it as quiet resistance. You were on your knees, but you failed to, and you refused to fully follow the instructions, which is not inconsistent with your behavior in court. When I asked you if you can follow the rules, you would give a long statement before you would say, well, I guess, well, you're the boss. It's a yes or no, and you know that. But that's consistent. That behavior is consistent with the resistance that you gave to the officers on that day. The amount of resources used by you, not just with one jurisdiction, Greenfield, but you extended that to Franklin. And those resources could have been used to address important needs in the community, but yet because of your criminal conduct, your criminal mindset, that you unnecessarily used up all those resources. Considering all these factors, the court will sentence you in the following way. I agree with the state that this has to be a consecutive sentence because each offense is a distinct harm that you've inflicted on the community, and it has to be recognized for that. With respect to count 1, initial confinement, 240 months, extended supervision, 180 days, consecutive to any sentence you may be serving. Count 2, 36 months in, 36 months out, consecutive to count 1. Count 3, 9 months, that'll be consecutive to count 2, and that's 9 months in the jail, but the DOC will do its math on that relative to your placement. Count 4, 60 months in, 36 months out, and that's consecutive to count 3. As to count 5, 60 in, 36 out, consecutive to count 4. You're not eligible for boot camp by virtue of your age, but you're not eligible for programming additionally. And so that's the court's sentence. As to conditions of supervision, they are as follows. AODA assessment and comply with recommended treatment.
So that's 33 3/4. That's 33 years and 3/4. And I think he served like 3 3/4. So basically another 30 years. Wow.
Absolute sobriety, no illegal drugs or alcohol, prescription drugs without a valid prescription, random drug testing. A refusal is the same as a positive. You are to obtain, maintain employment. No new law violations rising to the level of probable cause. You are to successfully complete any programming deemed appropriate for you by your agent and to cooperate fully with your agent. You are to undergo any cognitive behavior programming, including but not limited to thinking for a change. You are to undergo mental health assessment and comply with any recommended treatment. And you are to complete a financial literacy class. Mandatory court costs, assessments, and fees shall be paid by the end. Actually, give me a minute here. Shall be paid in full within 24 months. Any remaining balance at that point will be docketed against you as a civil judgment. DNA sample is ordered. Non-mandatory costs will be waived due to indigency. You do have the right to appeal my decision. Your attorney will. You do have the right to appeal my decision. There will be a counsel, Attorney Wasiewski, is there a form in front of you or at your table, a notice of appeal?
I don't have such a form. However, I can state that Mr. Olson has expressed the desire to appeal, and I told him if the court allowed, I would file the necessary notice of intent to start the appeal. So I can state that on the record. I'll take responsibility to see that his appeal process is initiated.
Okay, thank you. You may do so. The notice of right to seek post-conviction relief shall be provided to Mr. Olson. Mr. Olson, if you want to appeal, you have to do that within 20 days. Otherwise, it is difficult for you to appeal.
John, can I just ask a clarification question?
Yes.
On count 1, you said 240 months in custody and 180 days extended supervision.
180 months.
Okay.
Did I say days again? I meant 180 months.
Considering the discussion regarding months, I was wanting to make sure.
Yes. Okay, thank you for that clarification. Anything else I may have missed today? State.
Not that I noted.
Okay, and I'm aware that Mr. Olson is trying to get the court's attention, so we'll have him unmuted. My first question to you, Mr. Olson, is there anything that I may have missed that you believe I need to address now?
So I just want to make sure that I'm appealing, that the court knows I'm definitely appealing, I'm innocent, always remain innocent, and I'm like, well, I would be happy to see it, to maybe come back today, go over the thought process with me, either right now or in the jail. I also need to get on the record that my microphone trial was turned off and I was not allowed to object. So the whole purpose of appealing is based on being able to object. If they don't find objections.
Okay, Mr. Olson, is there anything that I may have missed relative to pronouncing the sentence that I need to cover on the record? So we talked about initial confinement, extensive supervision as required by law, the bifurcated sentence. I issued conditions. I also gave you your notice of right to appeal, and I've indicated that Attorney Wasusi may assist you in putting in that initially that appeal in, and that you be given the notice of post-conviction relief form, which every defendant is given after sentencing. Is there anything else I may have missed? And that really goes towards procedure.
Well, I mean, as far as the sentence, I believe that is extremely harsh, considering that innocent. Not only that, let me restate that innocent, but there are people that get sentenced every day for murder.
Mr. Olson, you can bring that up with the Court of Appeals. You're not making good use of the time that the court is allowing you. Again, the question was limited to procedural things I may have missed. Let's have him muted.
You're being prejudicial advice.
Deputy, mute him.
Bribing the judge.
Okay. All right, Mr. Olson is muted. From what I can understand, he did not have anything that he wanted to point out that I may have missed in the course of pronouncing my sentence. Okay, restitution is set to 0 as none is requested. All right, thank you, everyone. This hearing is concluded. Oh, yes, Counsel? Yes.
Just before Mr. Olson was removed from the courtroom the last time, he pushed this envelope towards me. It's a clear Ziploc bag. There is one flash drive in it that's visible, and then there is a paper envelope inside that feels like it has perhaps 2 more flash drives. And he directed me to make this part of the record, and I am frankly not sure what that means or what to do with this envelope. I guess the options are the court could accept it as an exhibit. The court could direct me to hold it for appellate counsel. The court could direct it to be returned to Mr. Olson's property for him to do with what he will. But it's sitting here now, so I just...
Deputies, please return that to Mr. Olson. He can do what he wants with that.
Okay. What a shit show. That was a lot, though. I didn't expect him to get 33, nearly 34 years. But hey, he'll appeal it, whatever. To me, and Wisconsin, you do not get to get out of prison early. I don't think the 85% works in there. So anyway, thank you for bearing with us on this one. Right, so tomorrow, there's a couple of trials. The one I'm concentrating tomorrow is going to be in Georgia. There's another one in Massachusetts as well, if people want to watch that. I don't even remember what that one's about. So the one in Georgia is going to be around Suzanne Merkel. She's facing a malice murder and felony murder charges after allegedly shooting her boyfriend James Barron through a bedroom door at their home in Gainesville on Lake Lanier. According to Georgia investigators, Barron had locked herself inside the bedroom during an argument where Merkel allegedly fired the shot. She's a doctor as well. She's a dentist as well. She was struck in the torso. He was struck in the torso and later died from his injuries. First responders found him unresponsive inside the room. So that's the trial we're doing tomorrow. So yeah, that is got to be on there. Just a few updates for people. There's an ongoing trial in Massachusetts at the minute called Judy Church. Her one is basically around poisoning her boyfriend with antifreeze. So there's that. There will be a trial, so I'm not covering that one, but if you do want to go and see it, I'm sure someone's going to stream it. It is on Law and Crime as well. On Monday, Kelsey Fitzsimmons has her trial beginning. I think that'll be like a 3-day trial or something. I'm not covering that, but again, lots of people will be covering it. And she's been granted a bench trial, so she'll have a bench trial, not a jury trial. So again, if that's something that people are interested to watch next week as well. But for the next few days or next week or so, I'll be covering this Georgia trial. I'll be doing it from a day behind. So zooming a day behind. So just for people to be aware of that we will be a day behind on it. So basically I can skip all breaks, skip dinner, and skip all those kind of stuff. So that's the plan anyway, to do that. I wanted to bring something a little bit different. There's plenty of people could be streaming Kelsey, plenty I'm sure will be covering the other mass trial. I don't know anyone that's covering this one except for Core TV and Law and Crime, so I'll be doing this one, zooming it. So there you go. That's all I have for now. We'll be back tomorrow, probably around 9 o'clock tomorrow. But the stream is set up ready. But for now, thank you for watching that trial. That was a cringy trial to watch, but still, I think it was a funny trial. Not funny, haha, but funny as in, jeepers, this guy's a nutter. But anyway, there we go. Not more we can do. I'm going to go for dinner now. It's nearly 7:30 in the evening here. I am hungry. I've not eaten today. So I'm going to love you and leave you. And I shall see you all I shall see you all tomorrow. And for now, take care. Goodbye. Bye-bye, baby.